Hello, hello.
Court officer.
Case number
10816 26.
ನಾಳೆ ಬರುತ್ತೆ
ಸಿಗ್ನೇಚರ್ ಲೇಟ್ ಆಗ್ತದೆ, ಮೆಮೋಸ್ಟ್ ಆಗಿತ್ತು ಅಷ್ಟರಲ್ಲಿ, ಸೊ ನಾಳೆ ಬರುತ್ತೆ.
ಅಂದ್ರೆ ಡೇಟ್ ಇವತ್ತೇ ತೋರಿಸ್ತದೆ.
ಡೇಟ್ ಇವತ್ತಿತ್ತು, ಸಾಹೇಬ್ ಸೈನ್ ಮಾಡಿರೋದು ಲೇಟ್ ಮಾಡಿದ್ದಾರೆ, ಸೊ ನಾಳೆಗೆ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಂದ್ರೆ ನಾಳೆ 24th.
ಇದರಲ್ಲಿ ಅಪ್ಡೇಟ್ ಆಗುತ್ತಾ?
ಅಪ್ಡೇಟ್ ಏನಾಗಲ್ಲ ಸರ್, ಬೈ ಡಿಫಾಲ್ಟ್ ಬರುತ್ತೆ.
ಲೋಕಾಯುಕ್ತ ಮ್ಯಾಟ್ರ ಏನು 7 13
ಮೆಲಾರ್ಡ್
2ನೇ ತಾರೀಕು. We'll see. Cancel the bail. ಯಾವ್ದಿದು? ಕೊಡಿ, ಅದು ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಅದು ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಕೊಡಿ ಅಲ್ಲ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಟ್ಬಿಡಿ. ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟ್ರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡೋಣ. ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಓನ್ಲಿ ಆನ್ 29th. ಗಿವ್ ಇಟ್. Yes. Unless there is a ಕೊಡ್ತೀರಾ? ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀರಾ? ಮಾಡಿದ್ರೆ ಬರುತ್ತೆ. And no client should come before 4 o'clock inside the court. At 4 o'clock. I'll take it at 4 o'clock. None of them inside before 4 o'clock. Yes. Yes, yes. Vacating stay, give it. Hey, you filed vacating stay, it will come, give it. Huh? 7A, kodi. ಏನ್ ಬೇಕು? 7A ಕೊಟ್ರಲ್ಲ, 2ನೇ ತಾರೀಕಿಗೆ ಬರೋದು 7A ಕೊಡಿ. ಎಸ್, ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ತಾನೇ ಅವರು. ಒಂದು ನಿಮಿಷ. ಟುಮಾರೋ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಸೋಮವಾರ ಬರುತ್ತೆ. ಬರಲ್ಲ ಕೊಡಿ. 23 ಇದ ಬರುತ್ತೆ, ಎಲ್ಲ ಬರುತ್ತೆ. 23 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಬರುತ್ತೆ, ಕೊಡಿ.
Pending 376 matter, my lord, for vacating stay, my lord.
376 ಅಲ್ಲಿ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇನಾ? ವೈ ಸರ್?
My lord, they have done certain suppression of fact, my lord. It is a 2025 matter.
All right, ಕೊಡಿ. Yes, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಸ್ ಎಲ್ಲ ಕೊಡಿ. ಆಲ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಕೊಡಿ ಸರ್.
My lord, this is a covered matter, my lord.
Give all vacating stay applications.
Vacating stay, lord.
Please give.
My lord, the petitioners has been served with Tahsildar has issued direction to appear before them and direct the execute the surety, my lord, without non-compliance of section 130, my lord.
ಆಯ್ತಾಯ್ತು, ಕೊಡಿ. ತೊಂದ್ರೆ ಇಲ್ಲ. ಮಂಡೇ
My lord, my lord, this is a covered matter, my lord.
give ಎಲ್ಲ ಕೊಡಿ. Pending, please give, sir.
My lord.
Sorry. We'll see. It will come, give it.
My lord, one matter, my lord.
ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ತಾನೆ.
My lord, this is a fresh matter, my lord. The covered judgment.
ನೀವು ಕೊಡ್ರಿ.
My lord, 25th, my lord. The 27th.
ಯಾಕೆ why do you want it on 25th?
Evidence is a commencement.
It will come on Monday only.
My lord, one matter, my lord. There is.
Why both of you are here? Come this side.
The matter was listed before the vacation court, my lord. It was no order was passed. The case was.
Give it, give it.
My lord, one matter.
Matter reach ಆಗದೆ ಇರೋದೆಲ್ಲ next week ಬರುತ್ತೆ.
My lord, one matter. There is some urgency, my lord. My lord, in this matter, it is a breach of agreement, my lord, and criminal proceedings are being initiated against me. I am retail shop owner, my lord. Police are interfering each and every day. They are terrorizing me and my staff, my lord.
Tomorrow.
My lord, it may be taken up at 2:30, my lord. It has been complained last Thursday, my lord.
Tomorrow. You want it tomorrow or Monday?
Tomorrow, my lord. Tomorrow.
My lord, case and counter case, my lord. ನಾನು ಕೊಟ್ಟಿರೋ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ NCR ಮಾಡ್ತಾರೆ. They trespass the property in the morning 4:30, my lord. Yes, my lord, comply ಆಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ.
ಸೋಮವಾರ ಬಂದೇ ಬರುತ್ತೆ, ಕೊಡಿ.
My lord, tomorrow, my lord.
ಅಂತ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ತಗೊಂತೀನಿ, ಅಂತದೇನು ತೊಂದ್ರೆ
ಅವ್ರ ಕೇಸ್ ಅಲ್ಲಿ
ಆಗೋ. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ತಾನೆ ಒಂದರಲ್ಲಿ NCR ಆಗಿದೆ ತಾನೆ?
No, my lord. ನಾನು ಕೊಟ್ಟಿರೋ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ NCR ಮಾಡ್ತಾರೆ.
ಏನು ಅರೆಸ್ಟ್ ಆಗ್ತಾ ಇದ್ದೀರಾ ಸರ್?
ಅಲ್ಲ, ಪೊಲೀಸ್ ಅವ್ರು ನಂದ್ರೆ
ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
ಬೇಲ್ ಗ್ರಾಂಟೆಡ್.
ಹಾಗಾದ್ರೆ we'll post it on 6th July.
No, my lord, Monday.
8 criminal petitions arising out of the same issue, my lord. My lord, for vacating of stay, my lord.
ಕೊಡಿ.
My lord, is a foreign national, my lord, is in judicial custody from past 2.5 years.
Why? NDPS?
Please, my lord.
ಕೊಡಿ.
My lord, petitioner four.
Tomorrow, my lord.
Please
Petitioner
give
four
up all
is,
the memos now.
petitioner four is pregnant, my lord. She's around 7 months
All
pregnant.
the memos kodi. Please kodi sir.
My lord,
Then come after 10 memos. Yes.
My lord,
Kodangidre kodi.
my lord, my lord,
Why sir? Complainant is the practicing advocate. Yen problem adike? Monday.
my lord.
ಏನು
petitioner four
ಪ್ರಪಂಚ
is-
ಬಿದ್ದೋಗ್ತಾ ಇದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಲ್ಲದಕ್ಕೂ ಅರ್ಜೆನ್ಸಿ. ಡೋಂಟ್ ಪ್ರೊಜೆಕ್ಟ್ ಎವ್ರಿಥಿಂಗ್ ಲೈಕ್ ದಿಸ್. ಎಲ್ಲ ಕಳ್ಕೊಂಡ್ಬಿಡ್ತೀರಾ ಆಮೇಲೆ 2:30ಗೆ.
My lord,
ಸುಮ್ನೆ ಇರಿ.
my lord,
ನೆಕ್ಸ್ಟ್ ವೀಕ್
petitioner is
ಹಾಕಿ.
an,
ಆಯ್ತು ಕೊಡಿ ಸರ್.
my lord, petitioner is a pregnant, my lord.
ಪಿಟಿಷನರ್ ಇಸ್
Pregnant, my lord. Here, my lord.
ಪಿಟಿಷನರ್ ಇಸ್ ಸರಿ.
Petitioner number 4 is pregnant, my lord.
ಸೊ
And even petition number 2 and 3 are parents of
Who
the
pregnant?
petitioner. ಇಲ್ಲ, parents of them, they are senior citizens, my lord. So ಎಲ್ಲರ ಮೇಲೆ FIR ಹಾಕಿದ್ದಾರೆ, my lord. So
ಏನ
this is
ಏನೀಗ
quashing-
ಅದಕ್ಕೆ?
ಇಲ್ಲ, quashing, my lord.
ಅದಕ್ಕೆ ಬೇಲ್
ಇದು
ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
ಆಲ್ರೆಡಿ ಆಗಿದೆ, my
ಅಲ್ಲ
lord.
ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
ಬೇಲ್ ತಗೊಂಡಿದ್ರು.
ಮತ್ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ ಈಗ?
ಇಲ್ಲ, ತುಂಬಾ ದಿನ ಪೆಂಡಿಂಗ್ ಇದೆ, my lord.
ಇರ್ಲಿ ಬಿಡಿ, ಏನೀಗ ಸ್ಟೇ ಇಲ್ವಾ?
Stay ಇಲ್ಲ.
ಇಲ್ವಾ?
ಇಲ್ಲ,
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ.
pending
Fresh matter.
Notice not.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ ಪೆಂಡಿಂಗ್.
ಪೆಂಡಿಂಗ್ ಮಾತ್ರ.
ಯಾಕೆ ಸ್ಟೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ?
ಇಲ್ಲ, ಫ್ರೆಶ್
ಏನ್ ಹೇಳಿಲ್ವೇನೋ ಪ್ರೆಗ್ನೆಂಟ್
fresh
ಲೇಡಿ
matter,
ಅಂತ?
fresh matter.
ಫ್ರೆಶ್ ಅಂದ್ರೆ ಮಂಡೇ. ಎಸ್
Pending matter notice not been.
ಕೊಡಿ ಕೊಡಿ ಎಲ್ಲ ಕೊಡಿ ಫಸ್ಟ್.
Petition is, my lord, petition is taking judicial exam.
ಕೊಡಿ ಸರ್.
Petition is taking judicial exam.
ಆಯ್ತು ಕೊಡಿ.
Notice not been issued.
ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಅವೆಲ್ಲ ಕೊಡಿ. ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ದೇ ಇರೋದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಕೊಡಿ. ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ.
Police investigation, state matter.
ಸಾರಿ?
Police investigation, state.
ಪೊಲೀಸ್?
Police investigation, state is.
ಸೊ ವಾಟ್ ಸರ್ ಕೊಡಿ.
Secretary.
ಕೊಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ರೆ ಕೊಡಿ. ಎಸ್ ಕೀರ್ತಿ ಹೊಡಿ.
My lord, I'm moving a matter for 2:30.
Why?
My lord, unlawful assembly and criminal trespass are the charges. The owner of the apartment wants me to vacate the building, my lord, and every day they're sending, with hand in glove with the cops, they're sending me, they're coming to my house
2:30.
every day, my lord.
2:30.
FLW has been
ಸ್ಟಾಪ್.
issued.
ಆಯ್ತು ಆ ಕಡೆ ಮುಗೀತು.
My lord, police have filed a FIR, withdrawal the liberty to.
ಚಾರ್ಜ್ ಶೀಟ್. ಫೈಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಂತ ಹೇಳಿ FIR.
My lord's petitioner is finding it difficult to renew his passports, my lords, because of the pendency of the matter.
ರಿನ್ಯೂವಲ್ ಆಫ್ ಪಾಸ್ಪೋರ್ಟ್.
Renewal of passport.
ಮೇಡಮ್ ಅದು ತಗೊಳ್ಳಿ, ನಾಳೆಗೆ ಹಾಕಿ.
Responding railways. Stay in this matter, my lords. Public work has been stopped. Special order, my lord.
ಸ್ಪೆಷಲ್ ಆರ್ಡರಾ? GM ಯಾವ್ದು ಮೇಡಮ್ ನೋಡಿ?
ಇದು ಮೂರ್ ಕನೆಕ್ಟೆಡ್ ಇದೆ, ಅದಕ್ಕೆ ಮೂರ್ ಮೆಮೊ.
Notice has been issued but not pending matter, my lord. Notice has been issued but not listed. Thereafter it is not listed.
We'll see, give it, yes.
23 matter.
Wait,
my lord.
come this side. Ronald, come this side. Come this side. You also, sir. ನೀವು ಈ ಕಡೆ ಬನ್ನಿ. Yes, wait.
Your lordship, lifetime tax matter, your lordship. Criminal proceedings has been initiated for non-payment of lifetime tax. Kindly have it tomorrow. Another matter.
Monday, all fresh matters will come on Monday, give it.
My lord, it's a fresh matter.
Fresh matters ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. All fresh matters you give. Unless there is emergency, you give.
Your lordship, the other matter, urgency 29th, it has been posted in the trial court for framing of charges, your lordship.
And then take that, which is that framing of charges?
Your lordship,
Take that
there is
tomorrow.
Your lordship, there is a POCSO and organized crime clubbed with a W.
Coca?
Yes, your lordship.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಅದರಲ್ಲಿ?
Actually, in the trial court, the special court judge is insisting on moving a memo because the other accused, she has split
What
up
has
the charge.
happened here? Vacating stay, is it?
No, your lordship, I have got a stay in the matter. But in the POCSO matter, the trial court wants to proceed and until after obtaining any orders from this honorable court.
No, POCSO is stayed.
POCSO is stayed.
I have granted.
Yes, your lord.
Could
No,
you?
no, the previous.
Give it, yes.
And
The day after tomorrow ಹಾಕಿ madam.
My lords.
How POCSO is stayed, we'll see, yes.
My lords, we're in a pickle, my lords. The fresh matter we have filed and in the matter in which we have challenged the FIR, both are connected. This is not coming up because the objection says you have to withdraw that matter.
Precisely so.
The previous matter is not coming up because it is connected with the fresh matter.
Precisely so.
They're not withdrawn.
It will come on
First
Monday.
2:30, my lords.
Tuesday ಹಾಕೋಣ, maintainability ಎಲ್ಲ Tuesday ಬರುತ್ತೆ.
My lord, pending matter.
Give it, give it,
passport
give
is
it.
not in the passport.
Give it, madam. Passport ತಗೊಳ್ಳಿ madam.
My lords, this is a pending matter, my lords.
Give it.
Against the petitioners. I filed a vacate, IA for vacating.
You can't be in slow motion, tell it fast, yes.
My lords, a date may be fixed, my lords.
ಅಷ್ಟೇ ತಾನೆ ಕೊಡಿ.
My lord,
My lord, atrocity matter. my
Wait.
lord, for tomorrow. Atrocity, my lord.
Atrocity tomorrow, yes.
pending matter for
ಕೊಡಿ,
130.
give the memo.
Because of
You have another memo.
the trial court not
Pending matter.
consider the warrant application, my lord.
ಕೊಡಿ ಮೇಡಮ್ ನಾಳೆಗೆ ಅಟ್ರಾಸಿಟಿನಾ?
No, my lord, 138 of in.
ಆಯ್ ಪರವಾಗಿಲ್ಲ ತೊಂದ್ರೆ ಅದೇನು ಅರ್ಜೆನ್ಸಿ.
ಅದರಲ್ಲಿ ವಾರೆಂಟ್ recall
ಅಪಿಯರ್ ಆಗಿ ವಾರೆಂಟ್ ಹೋಗುತ್ತೆ.
they are not considered my
ನೋ
application.
ಪ್ರಾಬ್ಲಮ್.
Reporting settlement.
ಸೆಟಲ್ಮೆಂಟ್ ಯಾವಾಗ ಬೇಕು ಕೊಡಿ. ಎಸ್
Pending
ಮೇಡಮ್.
matter 69, my lord, the offense is, the lodge can have it any week next week.
ತಗೊಳ್ಳಿ. ಎಸ್ 69 ಹಾಕಿ. ನೀವು ಮೆಮೋ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Atrocity ಅಂತ fresh matter ಪಕ್ಕ.
Oh, that ಇದರದ್ದು. ಹಾ. ಕೊಡಿ. ಆಯ್ತು ನಾಳೆಗೆ ಹಾಕಿ.
FLW has been issued.
It's a pending matter, but
ಮೆಮೋಸ್ ಕೊಡಿ. Here you this side, come this side. ಕೊಡಿ ಸರ್ ಬರುತ್ತೆ. ಸ್ಟೇ ಇಲ್ವಾ? ಹಾ ಆಯ್ತು, ವಿಲ್ ಸಿ. 2:30 ಹಾಕಿ ಮೇಡಮ್.
Fresh matter, my lord.
ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್ ಸರ್.
Pending matter, my lord.
ಕೊಡಿ ಸರ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ವೇಟ್, ಫ್ರೆಶ್ ವೇಟ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಕವರ್ಡ್, ಅನ್ಕವರ್ಡ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಸರ್.
Matter is coming on 29th.
ಮೆಮೋ ಕೊಡಲ್ವಾ? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಡೇಟ್ ಕೊಡಲ್ಲ, ಮೆಮೋ ಕೊಡಿ. ಮೆಮೋ ಕೊಡಿ ಸರ್. ತೊಂದ್ರೆ ಇಲ್ಲ, ಬರುತ್ತೆ ಕೊಡಿ. Daughter in law, 2:30.
My lord.
138 proceedings, your lordship.
138.
498.
ಹಾ.
They are deciding in Calcutta, 70 years old.
ಪೆಂಡಿಂಗ್
No, fresh matter.
ಮಂಡೇ ಆಗ್ಬೋದಲ್ಲ? ವೈ
Anticipatory bail ಆಗಿರೋದು. Conditions compare ಮಾಡಿಲ್ಲ.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಕ್ಯಾಲ್ಕಟಾ ತಾನೆ. ಮಂಡೇ
Lordship,
ಮಂಡೇ
138
ಬರುತ್ತೆ, ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಬರುತ್ತೆ, ಕೊಡಿ. ನೋ ಪ್ರಾಬ್ಲಮ್, ಕೊಡಿ. ಎಸ್
138 proceedings, your lordship.
My lord, 138.
ಎಲ್ಲ ಕೋರ್ಟ್ ಮುಗಿಸ್ಕೊಂಡು ಇಲ್ಲಿ ಬಂದ್ರೆ ಮೆಮೋ ತಗೊಳಲ್ಲ. ಗಿವ್ ಇಟ್. ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್ ನೌ.
My lord, 130.
ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್.
My lord.
ಗಿವ್ ಸರ್.
Vacating stay, my lord.
No sir, give it sir.
138 proceedings, your lordship.
It is Monday or it will come sir according to, give it.
My lord, 138 matter, lord.
138 proceedings.
So what sir? So what?
My lord, petitioner is
If
judicial.
luxury vehicles are seized, I should take it at 2:30, is it? No problem, give it sir.
138.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಕೊಡಿ.
My lord, petitioner is judicial custody, my lord. 138 matter.
ಕೊಡಿ sir.
Kindly post you tomorrow, my lord.
We'll see, give it. Yes. Fresh matters ಎಲ್ಲ ಕೊಡಿ.
For the co-accused, your
My lord.
lordship.
Fresh matters ಕೊಡಿ.
Pending matter.
Fresh matter exercise act, my lord.
Pending fresh ಎರಡು ಕೊಟ್ಬಿಡಿ. Yes.
My lord.
These are listed on 29th, your lordship.
My lord,
FLW has been issued.
FLW ಯಾಕೆ ಇಶ್ಯೂ ಆಗಿದೆ sir?
A substantial amount has been paid.
No sir,
Suppressing the
nothing.
fact.
No problem, give it.
FLW
Give the
My lords,
memos please.
for one, my lord,
Wait.
for one.
All of you wait. Give the memos please.
Petitioner are read in the 498
Give all the memos.
petitioner are read as 498 for husband of
ಆಯ್ತು, ನೀವು ಕೇಳಲ್ಲ.
Brother of
Call the
husband.
cases.
My lord.
Liberties at stake, my lords. My lords, at 2:30, my lords. My lords, amount has been pending for a matter which is in 2014 registered.
ಇಲ್ಲ madam.
Fresh matter.
No, my lords, this is a pending. Stay was not granted.
No problem, give it.
ನಾಳೆ.
ಆಯ್ತು ಕೊಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ. ಡೇಟ್ ಇಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನಿಮ್ಮ ಒಂದಕ್ಕೆ ಕೊಟ್ರೆ ಎಲ್ಲರಿಗೂ ಡೇಟ್ ಕೊಡಬೇಕು.
this was that matter.
Will you wait please?
Sir,
Why being spoken to?
Commission matter.
Instead of stay, they have mentioned stated, your lordship.
ಆಯ್ತು ಕೊಡಿ. Yes. ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು?
I don't have bail also.
Why?
The advocate himself.
Accused. Why you did not take bail?
No, this is just happened last week. It's a dispute that's been going on between the earlier owner.
What's the allegation against the advocate?
No, the allegation is that he was washing the car at that time. These people chairman's house.
Advocate was washing the car.
That's not, he himself was staying in that. He has been getting the orders against the earlier landlord. He has got a civil order also against.
ಕೊಡಿ, give it.
That's a fresh matter.
ನಾಳೆ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ತಾನೇ ಅದು?
2:30.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್.
ಇಲ್ಲ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಬರುತ್ತೆ 2:30.
This is the matter.
FR 2:30.
This is the matter where the wife admits no domestic violence in a DV proceeding.
No problem,
Your lordship
give it.
said already heard it. Any date may kindly be fixed. Any
Next
date
week.
may kindly be fixed.
FLW ಆರಾಮಾಗಿ ಬರುತ್ತೆ, ಕೊಡಿ. Here the husband. Then 138 ತೊಂದ್ರೆ. No FLW ಅನುಭವಿಸಿಲ್ಲ. Nothing doing, nothing.
My lord, fresh matter.
FLW 138 ಅಲ್ಲಿ ತಗೊಳ್ಳೋದು. You're the accused ಅಲ್ವಾ? You walked away from this compromise.
paid inter-amount.
No, sir, nothing. No problem, give it, sir.
My lord.
My lord, fresh matter.
No,
DD Act, my
tomorrow.
lord.
My
It
lord.
will come Monday, Tuesday, it will come.
My lord, fresh matter tomorrow
Case and
is
counter
for
case.
posted for orders in the trial court, my lord.
What orders, sir?
For the final disposal of the case.
2:30.
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸು ನೋಟಿಸ್ ಆಗಿದೆ, ಚಾರ್ಜ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ, ಮಾಡ್ಲಿ ಬಿಡಿ.
ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ.
My
ಮಾಡ್ಲಿ
lords.
ಬಿಡಿ. ತೊಂದ್ರೆ ಇಲ್ಲ. ಕೊಡಿ.
My lords.
ನೋಟಿಸ್ ಆಗಿದೆ.
ಎಲ್ಲ ಹೇಳ್ಬೇಡಿ, ಕೊಡಿ.
My lords, in this petition, the prayer is to consider my application under section 4 of the Probation of Offenders Act, my lords.
Give it tomorrow.
DV Act.
Memo for withdrawal tomorrow.
Thank you.
Going it for 2.
Let's
2:30.
let's DV Act petitions of father-in-law and mother-in-law. ಮಾರ್ಚ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ, ಬಟ್ ಪ್ರೀವಿಯಸ್ ಕೌನ್ಸಿಲ್ ಅಟೆಂಡ್ ಆಗಿಲ್ಲ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks ಅಂತ
ಏನ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್
ಬರುತ್ತೆ, ಕೊಡಿ.
ಎನಿ ಡೇಟ್
ನೋಡೋಣ, ಬರುತ್ತೆ.
ಡೇಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಲ್ಲ ಅಂತಿದ್ದಾರೆ.
ಅದು ಕರೆಕ್ಟ್, ಕೊಡೋದೇ ಇಲ್ಲ.
ಎನಿ ಡೇಟ್.
ನಾನು ಡೇಟ್ ಕೊಡೋದೇ ಇಲ್ಲ, ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
father-in-law and mother-in-law.
ನೋ ಪ್ರಾಬ್ಲಮ್. Yes.
My lords, that
ಕೌನ್ಸಿಲ್ ಇರ್ಬೇಕು.
renewable energy.
NOC ಮೇಲೆ
ಕರೆದಾಗ ಕೌನ್ಸಿಲ್ ಇರ್ಬೇಕು.
ನೋ ಮಿಲಟ್ಸ್, NOC ಮೇಲೆ ನಾವು ಬಂದಿರೋದು.
ನಾನೇನ್ ಮಾಡಕ್ ಆಗಲ್ಲ. Yes.
Lordship, that renewable energy policy matter which was taken up yesterday is listed tomorrow. One matter
Yes.
hadn't been tagged. I'm just handing over a memo so that it
It's
can come
tagged.
tomorrow.
I passed an order yesterday, it's tagged.
Oh, I'm so grateful.
All right, yes.
7586.
Yes.
Obliged, man.
My lord, for the petitioner, the matter is already disposed, petition is in.
Obviously, 24 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರುತ್ತೆ. Learned counsel with what is called in question in an application rejected, rejection of an application of section 311 of the CRPC, which comes to be rejected in the year 2024. The trial itself is now concluded as a submission, disposed as having become infructuous.
319 application.
319 application.
Allowed.
Application
ಮಾಡಿದ್ದಾರೆ.
Application is allowed. Lord, only one document.
Yes, sir.
Not to look into page 142.
506B.
506B. 142. This is the further statement of the complainant. Last, my lord, 4 lines, my lord.
ಇದು 1 ವರ್ಷ ಆಗಿದೆ ಆರ್ಡರ್ ಆಗಿ, ಈಗ ಏನಾಗಿದೆ?
It is posted for trial now. Charges are framed.
ಅದಕ್ಕೂ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ, ಟ್ರಯಲ್ ನಡೀತಾ ಇದೆ, ಅವಾಗಲೇ ನೀವು ಒಳಗ್ ಬಂದಿರೋದು.
15/7/2026, my lord, it is posted.
Yes, what's wrong with the order?
Lord, your lordship may kindly see the further statement.
Page.
My lord, the page 142. Last but one paragraph. ದಿನಾಂಕ 23/2/2012 ರಾತ್ರಿ 11:45 ಗಂಟೆ ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನೀಡಿದ ದೂರನ್ನು ಬೇರೆಯವರಿಗೆ ಬರೆಸಿಕೊಟ್ಟಿದ್ದು. ಆ ದೂರಿನಲ್ಲಿ ಅನ್ಸರ್ ಪಾಷಾ, ನಿಸಾರ್ ಪಾಷಾ ಇಸ್ ದ ಪಿಟಿಷನರ್ ಮತ್ತು ಅಂಜು ಆಲಿಯಾಸ್ ಅಮ್ಜದ್ ರವರುಗಳು ಮಕ್ಸೂದ್ ಮತ್ತು ಮುಕ್ತಿಯಾರ್ ಮೇಲೆ ಹಲ್ಲೆ ಮಾಡಿದ್ದಾಗೆ ಬರೆದಿರುತ್ತೆ ಎಂದು ಈಗ ವಿಚಾರ ತಿಳಿಯಿತು. ಆದರೆ ಈ ಕೃತ್ಯ ಸಮಯದಲ್ಲಿ ನಿಸಾರ್ ಪಾಷಾ ಮತ್ತು ಅಂಜು ಆಲಿಯಾಸ್ ಅಮ್ಜದ್ ರವರು ಸ್ಥಳದಲ್ಲಿ ಇರಲಿಲ್ಲ ಮತ್ತು ಮುಕ್ತಿಯಾರ್ ಮೇಲೆ ಯಾವುದೇ ಹಲ್ಲೆ ನಡೆದಿಲ್ಲ. This is the further statement. Based on this, my lord, the police have proceeded to file the charge sheet exonerating me. Now
what is the statement now?
Now he has stated that even Nisar Pasha was also there at the time.
Where is that?
That statement.
Page
not 147. This is, my lord, the examination in chief of
ನಿಸಾರ್ ಪಾಷಾ ಇದ್ರು ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಇದರಲ್ಲಿ page 147 ನೋಡಿ. Third line ನೋಡಿ. ಸದರಿ ಗಲಾಟೆಯ ಸಂದರ್ಭದಲ್ಲಿ ಅಮ್ಜದ್ ಮತ್ತು ನಿಸಾರ್ ಎಂಬ ವ್ಯಕ್ತಿಗಳು ಇದ್ದರು. ಸದರಿ ಅಮ್ಜದ್ ಮತ್ತು ನಿಸಾರ್ ಅವರಿಬ್ಬರು ಸಹ ದೊಣ್ಣೆಯಿಂದ ಚಾಸ 2ರವರೆಗೆ ಹೊಡೆಯುತ್ತಿದ್ದರು. No such the alleged club is.
Your lordship, they have chance to cross the petitioner, your lordship.
No, but this is his statement again.
Please, your lordship, but in the box it is.
The petitioner was arraigned as an accused in crime number 19 of 2012, registered for offences punishable under section 307 ಇದೆಯಲ್ಲ, 307, 506B and inter alia. The matter is committed to the court of inter alia. The matter is committed to the court of session and is now pending as SC 61 of 2014.
72 of 19. 72 of 19.
Renumbered as 72 of 2019. The issue is not with regard to the merit before the concerned court. The petitioner, who was an accused when registration of the crime, was dropped from the area of accused while filing the charge sheet on the statement of on the further statement of the victim. The further statement of the victim reads as first para aladu?
Yes.
Page 142 alli.
142.
Which paragraph?
Last but one paragraph. There's no number, my lord.
ಅಲ್ಲ ವಿಚಾರ ಮಾಡಲಾಗಿ
23/2/2012 ಅಂತ start
yes.
ಆಗಿದೆ.
The further statement of the victim reads as follows. It is based upon this statement the petitioner was dropped from the array of accused. Charges were framed. The trial is in progress. During the trial, the victim again makes a statement, a vague statement, that the petitioner also was assaulting the victim. The statement reads as follows. Page 147.
147.
Marked portion. Therefore, there is serious contradiction in what the complainant had stated earlier and what the complainant has now deposed in the examination in chief. In that light, there shall be an interim order of stay of the order that brings in the petitioner into the web of proceedings all over again until further orders. Yes, next.
Petitions.
JY 85,
Yes.
1 illa, 2 to 5. Yes. Husband no stay.
Husband and wife relationship was already seized, my lord.
No problem. Yes.
So Lordship, page 21, my
No
lord.
problem, sir. Yes, next.
Offense under 279.
324, 504, 506.
337, 504, 504.
337. In the meantime, next. One HCGP, 2 emergent notice. Yes. In the meantime, 1181, gain ilvela. Yes. Next. Again, 324.
324, my lord. Subsequently, 326 also included, my lords.
324 ge ಏನ್ ground ಇಲ್ಲ. Yes, madam. ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಿದೆ ಕೊಡಿ.
Simple ಅಂತಾನೆ ಇದೆ. But it is on the right temporal region of the.
Where is the own certificate? That's at page 104.
It's from, I'm reading 100, your lordship. Page 99 in the.
Painful source. Which is this? 104?
My lords, that's the MLC, my lords.
Huh?
104, my lords.
That's the own certificate.
Page 99 ಅಲ್ಲಿ grievous
ಇಲ್ಲ, my lords.
99
Starts from 86.
1 minute.
86 first MLC ಆಗುತ್ತೆ.
1 minute, sir. Page 99, madam. Your pagination ಸರಿ ಇಲ್ಲ.
Pagination.
Full certificate of one Bindu, your lordship.
Grievous hurt ಇದೆಯಲ್ಲ.
My lords, that's only with regard to my lords injury 3 and 4, my lords. Apart from that, my lords, all simple injuries. I'll just trouble this honorable court, my lords.
No problem. ಒಂದಿದ್ರೆ ಸಾಕು.
ಇಲ್ಲ, statement, my lords, of the witnesses themselves.
We'll see. Let the complainant come. 1 HCGP, 2 emergent notice. She's a lady.
24/7 ಗಿದೆ.
ಇರ್ಲಿ. Yes. Time ಕೇಳಿ ಅಲ್ಲಿ.
I seek leave of the court. No, my lords, here the stays because there's a current.
Earlier petition pending?
Earlier petition.
Which is that?
4718, page
Kodi.
458, my lords, of the second volume. Stay has been granted in that.
Give me that, sir. Which is, where is the stay granted?
My lord, I'm for the And second there's also respondent.
You entered appearance in the other case?
No, I have not appeared, my lord. I'm seeking leave of the court.
No, you can't seek leave. You are not on caveat. Yes.
458, my lord.
Kodi.
And also there's an observation made by this honorable court about 5 after matrimonial discord, my lords, they want to unsettle all the registered transactions.
458.
458, my lords. And there's also an observation made by this honorable court in another petition. About 5 complaints have been filed against the husband.
Mediation, it was referred to mediation?
It was referred to mediation. Mediation did not succeed.
Okay.
And after that, my lords, suppressing this FIR, which is of the same GPA, which they have alleged, they filed another complaint at Davangere.
Can I make this petition?
Another, my lords, another.
Tag this petition along with the criminal petition 4718 of 2023.
Can I make a? And my lords,
No.
my lords,
yes,
I have passed on an interim order where an observation has been made by this honorable court regarding all the frivolous complaints filed by the wife. In 5953 of 24. My lords, may kindly see the offense alleged, the order dated 25/6/24. The offense alleged.
ಇದು war over car.
war over car, my lords. Another
My-
5
my
complaints
lord.
have been lodged against the husband and
G-
wife
GP
after 35 years of marriage,
GP
matrimonial discord.
You are the husband.
I'm for the husband.
Yes.
My lord, GP has been fabricated.
We tagged along with
GP and
Tag
every
this
property,
petition,
every penny
which is
has
this
been-
another petition, is it?
another petition. Another
Tag
three
this petition, JY, tag this petition, criminal petition 4718 of 2023 and criminal petition 5953 of 2024.
And
List,
my lords,
list
and-
them, one nimsham, sir. List them all on 8th July in the fresh matters list. The learned counsel so and so undertakes to enter appearance for the respondent complainant in the subject petition. There shall be an interim order of stay as is prayed for till the next date of hearing.
there are other two petitions, my lords.
Kodi, ella kodi, give all.
351 and 13659.
Husband and wife generating 5 petitions. Give it, give it.
All
My lord,
complaints
entire GP has been fabricated.
No problems.
He has taken and entire properties has been transferred to
We'll
himself.
see, sir. Yes. Give all the numbers. Kutra.
The petitioner, my lords, 315 and 318, my lords, lodged in
Still number 10 na.
9, my lords. 9, my lords, for the petitioner.
Hmm.
315
Tag the
and
petition along with criminal petition 241 of 26 and 1520 of 26, same order. Next.
Grateful.
Where for petitioner, my lord.
Hmm.
My lord, the petitioner, my lord, is running a my lord, mentally retarded, charitable institution, suicide, my lord.
ಅದಕ್ಕೂ ನಿಮ್ಗೂ ಏನ್ ಸಂಬಂಧ?
ಅದೇನೆ, that's what my lord, that's why, my lord.
The entire records are not available.
Records not available. ಇವ್ರ ಹತ್ರನಾ?
Charge sheet ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ, charge sheet, complaint, FIR, post mortem report, everything I have filed. Everything is there.
We'll see.
Because in charge.
Lord, I have filed, my
In-charge
IA,
urine-
my lord.
Allah, there is no allegation that he has
Yes.
killed or something. It is only 201 destruction of
Oh,
evidence.
not one, yes, ma'am.
We'll see. 1 HCGP, 2 emergent notice. ಇಬ್ರು ಇವರೇ ನೀವೇ ಇರ್ಬೇಕು. Complainant ಯಾರು? Learned HCGP accepts notice for both the respondents. List the matter on 16th July. There shall be an interim order of stay of further proceedings.
Yes. My lord, IA is put, yesterday's file, my lord, it's put up, my lord. It's
ಸರಿ.
not shown yet.
ಹಾಕಿದ್ರೆ IA ಇದ್ರೆ ಸ್ಟೇ, ಇಲ್ಲ ಅಂದ್ರೆ ಅಷ್ಟೇ.
ಇಲ್ಲ, ಇಲ್ಲ, ಇದು ಹಾಕಿದ್ದೀನಿ.
Offense under section 323, 324, 506.
Counter blast. Yes, next.
Counter blast, my lord. Civil 2 and 3 are no allegation, my lord.
Blast ಆಯ್ತು. Yes, next.
Ladies, my lord. 2 and
ಏ
3.
ಕೊಟ್ಟಾಯ್ತು ಸರ್.
Please.
Yes.
I have for petition.
In the meantime, next. 85 husband, ಬೇಡವಾ?
Matter settled.
ಕೊಟ್ಟಾಯ್ತು.
Notice respondent.
Settlement ಆ?
Settled ಆಯ್ತು.
Yes, my lords, parties have entered into a compromise.
Where?
A compromise affidavit has been.
Compromise
filed.
here or before any other court?
My lords,
For
out of,
dishonorable.
out of court settlement.
Of course, out of court, not before any other court. Then give me the settlement.
Compromise affidavit is page number 76 to 80.
ಹಾಕಿದ್ದೀರಾ? Yes.
Yes, ma'am.
ED should be furnished to the wife.
How much?
5 lakh rupees.
ಅಲ್ಲಿ last ಅಲ್ಲಿ the learned counsel of the petitioner hands over a demand draft of rupees 5 lakhs to the counsel to the complainant herself who is present before the court. Yes. 498.
Please, sir.
Next.
Yes, my lord, for the petitioners, there was a civil suit filed by the second.
Maybe you are not in possession. You have lost this suit.
Execution is still pending.
No problem. Execution ಯಾರ್ದು? ಅವ್ರದ್ದು, ನಿಮ್ದಲ್ಲ.
Because still possession is not handed over.
No problem, sir. Yes. 1 HCGP, 2 emergent notice. Next.
Order has been passed without.
In the
following
meantime, next.
Petitioner in this case, my lord.
The petitioner is the husband.
Husband.
1 HCGP, 2 emergent notice returnable by the 14th of July. Less the matter on 14th of July.
There is a matter of, this could be a settlement, my lord.
ಅದಕ್ಕೆ returnable by 14th of July.
Can the matter be stayed? my
No,
lord?
sir. If it is stayed, husband will not come forward for settlement.
No, he'll appear with a mediation. my lord.
A mediation I'll send. No problem. Yes. If you want mediation, I'll send. Next.
It's purely a love story, my lord.
Love
between
story?
a Love story turned into a POCSO case. I can see the photographs and 17 years old girl when
18-year-old boy. But what to do? ಏನ್ ಫೋಟೋಸ್ ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ? Showing a movie, is it?
ಅಲ್ಲ movies
Then- Now, who is the complainant?
complaint is Victim's mother, my lord. Fathers.
ಮದುವೆನೂ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ ಇನ್ನು.
ಹಾ. Yes, madam. What to do with this?
Your lordship, FSL is pending and just secure and 17 years and. Yes,
You are in custody?
Bail ಆಗಿದೆ.
Bail ಆಗಿದೆ. As I said, it is a love story. Something should be done. Anyway.
Taken her and bought her back.
Huh?
Yes, taken her.
Oh, taken her, bought her back, left home. Diligently has left her back home. Problem is next day pick up ಮಾಡಬೇಕಾಗಿತ್ತು, ಅಷ್ಟರಲ್ಲಿ ಸಿಗಾಕೊಂಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅಲ್ವಾ? The petitioner now stands an accused on a complaint registered by the second respondent complainant, the mother of the victim. Classmates, huh?
ಇಲ್ಲ, second PUC and is in degree.
The petitioner falls in love with the daughter of the second respondent complainant and move around everywhere, catches the eye of the complainant, and the offense for punishable under POCSO has sprung. As contended by the counsel for the petitioner, there are plethora of documents to demonstrate that the petitioner, who is 18 years old, was in love with the 17-year-old daughter of the complainant. The petitioner obviously would not know the consequences of law that he has consequences of law and the consequences of love that he has fallen into. In that light, I deem it appropriate to stay further proceedings with the petitioner till the next date of hearing. More so in the light of the fact that neither the mother nor the statement of the victim would anywhere indicate that the petitioner has indulged in forcible sexual assault upon the complainant. All the chats, all the statements speak a singular stream that she was in love with the petitioner. Yes.
Petition. One is husband, my lord. Second
A2, A3, stay, one no.
Yes. After, my lord.
Barley.
Notes, please.
Stay in so far as the husband is concerned would be considered after the appearance of the wife. Emergent notice returnable by 15th July. Yes, next.
I appeal for petitioner in serial number 19, please.
Yes.
Yes.
With petitioner,
Section 138 of NA.
petitioner to serve on the counsel who represents the respondent in the trial proceedings, file an acknowledgement of such service, list the matter on 6th July in the fresh matters list. Next.
Much.
In the meantime. Wound certificate.
My lords, it's on page number 64, my lords. It says simple in nature, and she's in fact complained that ಹಾಗೆ ಹೊಡೆದ್ರು ಹೀಗೆ ಹೊಡೆದ್ರು and the
ಹಾಗೆ ಹೊಡೆದ್ರು ಹೀಗೆ ಹೊಡೆದ್ರು
but
ಪರ್ ಹೇಗೆ ಹೊಡೆದ್ರು ಅಂತ ಎವಿಡೆನ್ಸ್ ಬೇಕಾಗುತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, and the
ಹಾಗೆ ಹೀಗೆ ಅಂತ
and the date of the wound certificate and the date of the charge sheet are the same, my lords, and it is from a private hospital which a wound certificate has been got. Petitioner number 1, he's freshly graduated law student.
wound fresh ಆಗಿದೆ
ಸ್ವಾಮಿ, ಅವನೇನು ಮಾಡಿಲ್ಲ, at least with some relief for him, my lords. ಎನ್ರೋಲ್ ಆಗ್ಬೇಕು ಅವನು ಇವಾಗ.
ಎನ್ರೋಲ್ ಆಗ್ತಾ ಇಲ್ವಾ?
ಅಲ್ಲಿ ಡೆಕ್ಲರೇಷನ್ ಕೊಡ್ಬೇಕಂತ ಏನೇನ್ ಕೇಸಸ್ ಪೆಂಡಿಂಗ್
ಇದೆ ಅಂತ. ಮತ್ತೆ ಈ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ ಈಗ.
If some relief can be granted to him, my lords.
What relief?
And my lords, there is a civil dispute. It is a carefully orchestrated attack on the land where against whom the suit is pending. His
Carefully
wife and children.
orchestrated ಅಂದ್ರೆ I'll send you to a concert.
His wife and his children come and do this attack on my land, my lords, and they cry foul that I have hit them with. In fact, it is the other way around, my lords. The civil dispute is pending adjudication.
That is, madam, injury is simple in nature. 118 ಬರೋದೇ ಇಲ್ಲ. OS number ಹೇಳಿ. The parties to the list,
36 of 16.
the i.e. the complainant and the petitioners accused, are before the civil court in OS
36 of 16.
16. ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ.
ಇಲ್ಲ, it's still pending ಇದೆ ಸ್ವಾಮಿ. Same schedule I will.
which is still pending adjudication, be that as it may, the perusal of the wound certificate would not indicate causing of an injury by usage of a weapon or voluntarily causing hurt by using a weapon. It is without rhyme and reason drawn into the web of allegations. In that light, there shall be an interim order of stay of further proceedings by the petitioners till the next date of hearing.
I'm deeply
After the enrollment, I'll vacate this day.
I'm grateful, man.
Yes.
For the petitioners. That's civil proceedings which is pending. Civil proceedings are pending.
Ulva.
And
Meantime, yes.
that's it. Maybe connected with two other cases.
Kudi, numbers. Yes, Anand.
For the petitioner, my lord.
Amale.
Evidence stage.
420 and 406.
Charge frame ಆಗಿ ಬಹಳ ದಿನ ಆಗಿದೆ.
But my lord, there is only one transaction. So the Supreme Court judgment is very clear on the
Very
point.
clear, sir. No problem.
So
I am also very clear.
406.
I'll direct a Delhi race club.
Yes, my lord.
ಅದು ಬಹಳ ಹಿಂದೆ ಈಗ ಬಂದಿರೋದು ಅದು. They don't apply that now.
Thereafter also there is one more Supreme Court judgment, my lord.
Maybe, sir. Yes.
Because otherwise this entire, the trial would be.
No problem.
Because there is only one transaction.
No problems. We'll direct the court to expeditiously dispose
And
the
even
trial.
also there is a civil matter, my lord. In that civil
No,
matter.
parvailla, sir. Yes.
I may permitted to withdraw, my lord.
Perfect. The learned counsel appearing for the petition would seek leave of this court to withdraw the petition. ಯಾವ ವರ್ಷದ allegation?
2016, my lord.
The issue is of the year 2000. The petition they withdraw ಮಾಡಬೇಡಿ. The learned HCGP on instructions would submit that charges have been framed, the trial is on, and it's fag-end. The learned counsel for the petitioner seeks to project certain contentions with regard to the amalgam of the offences under section 406 and 420 that cannot coexist according to him in a particular crime. It's too late in the day for the petitioner to contend the same as the trial is at its fag-end.
No, my lord, it's in the beginning, my lord.
The trial is in progress. In that light, since the issue is of the year 2016, I deem it appropriate to infuse finality into the proceedings by directing the concerned court to conclude the proceedings with an outer limit of 6 months, if not earlier, in accordance with law. It is needless to observe that the concerned court would answer all the legal contentions that the petitioner would urge before the concerned court, ordered accordingly.
Much.
I'm appearing for the petitioners in this case, my lord. My lord, the encroachment of petitioners land, complainant land, my lord, is an encroachment. So
Correct.
Panchayat development officers came to release the encroachment, my lord. The complainant thinks that he is the one given a complaint, hence they are came for a encroachment release, my lord. This is the what, my lord, is nowhere is petitioners is involved, my lord. Petition number 5 is a retirement stage, my lord. Is in the last year of the retirement stage is a STA working as a STA, my lord. And petition number against the petitioners, my lord, petition number 4 is the mother of the petition number 1, my lord. She is nowhere, the entire family has been falsely
Page 21.
My lord, the complaint, my lord, only the
Page
petition number.
21, complaint bitpudi.
Please, ma'am.
Page 21, then go to page 33 and 34, the wound certificates, which shows grievous hurt.
My lord,
Anything else, madam?
my lord, here the petition number 4 and 5 are nowhere,
File discharge.
my lord, nowhere
Nothing
is.
in this grievous hurt, I will not.
My lord, it's not a grievous offense, my lord. Even the
33,
case and
34,
counter case, my lord, even
Parvailla,
they,
33, 34 ನೋಡಿ ಮೇಡಮ್. ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರೆ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ?
my lord, they also,
ಏನು?
my lord, ಹೇಗಾಯ್ತು ಅಂದ್ರೆ ಪಂಚಾಯತಿ ಡೆವಲಪ್ಮೆಂಟ್ ಆಫೀಸರ್ಸ್ ಬಂದು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ರಿಲೀಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಫೈಲ್ ಡಿಸ್ಚಾರ್ಜ್
ಇವರಿಬ್ರು
ಅವ್ರ ಕೇಸ್ ಹಾಕಿದ್ರು ಅದು ಅದನ್ನೇ ಮಾಡ್ತೀವಿ. ಫೈಲ್ ಡಿಸ್ಚಾರ್ಜ್.
case and counter case, my lord, and nowhere the petition number 5 and 4 is involved here in this, my lord. There are families, the aged parents, my lord.
You want file discharge? ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಬನ್ನಿ. Next.
My lord, petition number 4 and 5 consider, my lord, they are very aged and they nowhere involved, my lord.
Oh, no.
Mother and father is nowhere involved, my lord. Is a retirement stage, my lord.
File discharge. Before retirement, come back. Yes.
It's a 1 year is there, my lord.
ಅದಕ್ಕೆ ಅಷ್ಟರಲ್ಲಿ ಡಿಸ್ಚಾರ್ಜ್ ಆಗುತ್ತೆ ಬನ್ನಿ. Next. Discharge format.
My lord, pertaining to only petition number 4 and 5, my lord, is a complaint against only petition number 2, my lord.
No, madam. Yes.
My lord, I appear for petitioner's counsel.
This petition is safely sheltered under your lordship 12th June judgment.
ಅದೇ ಸಿವಿಲ್
Civil in
ಕೊಡಿ.
the petitioner is the father and petitioner number 2 is the son. Respondent 2 is the brother's wife, my lord. There is a plethora of civil disputes. And the allegation is that a joint family property was sold during the unison of the family. For that, a case has been, a private complaint has been filed. Even OS is pending in 2504 of 22, my lord. Kindly peruse page, recital at page 38.
Complainant is your brother, hello,
So
sister.
complainant is the brother of the respondent's husband.
Sister. One HCGP to emergent notice in the meantime.
Much.
Yes, next. Heard the learned senior counsel Devakar. Next.
My date of appearance, my lord.
But crime is too fresh. I'll see the investigation papers. 26/5/26 is the crime.
Initially, UDR was reported, my after 10 days, case was registered, my
No
lord.
problem. Learned HCGP to secure the investigation papers and place it before the court 6th July in the fresh matters list.
No court system, I'll cooperate with the, no, I'll cooperate with the investigation, my lord. No court system will still meanwhile, my lord.
ಯಾಕೆ ಬೆಲ್ ತಗೊಂಡಿಲ್ವಾ? Why?
Child, my lord, it will take long time there. my
I will
lord.
see. Yes. Respondent shall not take any coercive steps, but the petitioner will cooperate for investigation till the next date of hearing. Yes, next.
My lord, in this, they were not named accused in the FIR. It was a fight outside Garuna Mall. And even if your lordship will take column 17, there is no allegation against A2 and A4 with respect to grievous hurt, and even 504 is not made out. The other point, my lord, is A5 is subsequently made a witness. That is the only material against us.
No, man.
So my submission is that it has to be
Page
taken as a
56, 57 are the wound certificates which depicts grievous hurt. Page 25 is the summary which
That's right,
shows
my
your
lord, but-
name. Anything else?
But my lord, the allegation is that A1 used a beer bottle against. I have
No,
only
no.
used my hand is the allegation.
You
My-
better stop this brawl after being in an inebriated
Not
state.
present.
Yes.
We were first called as witnesses.
No,
The only
no, no,
material against me is the confession statement of A5, subsequently made a witness. Your lordship's recent judgment is there, my lord. A chachi cannot stand. Just a voluntary statement, my lord.
No problem.
There is no other material
No
corroborating.
worries.
The eyewitness statement is
No.
not matching the eyewitness. The
That's a
statement
matter of evidence,
A5, my
man.
lord.
That's a matter of evidence.
My lords, may
The
please take
judgment
page-
you said was a matter of trial. Yes, after trial.
No,
Yes.
my lord, it was a charge sheet was quashed, my lord. In 2026 SCC online KR 1756, my lord. Prakash case, that bus case, my lord. My lord, may please take page 25. I will just point
25,
out.
yes.
The only thing
See
is
page
that
25.
we have used our hand, my lord.
No.
Yes, my lord. The only allegation
Even
is
that, why did you use?
cannot be 326, my lord.
No, we'll see.
And even otherwise, my
Fought
lord.
with beer bottles after outside the mall. Yes.
504, my lord. It just says, "Tu kya kar sakta hai kutta." That is the only thing. Can 504 be made out for that, my lord?
No, no, that is not the issue.
Even
The
this,
other
my lord,
offenses.
in the last 3 lines, it says A1 has beaten Sakshi
Well,
1 with the beer bottle, my lord.
Yes,
We
who
were
is
not
who is the
present.
complainant? Have you registered a complaint?
No, my lord, we were not even present. We
One,
were in fact called
one
as
HCGP
witnesses.
to emergent notice. Yes,
My lord.
next. No, no.
My lord, there are 3 young students.
No, no,
They
no.
were not involved in
You
this
should
at
have
all.
been students, yes.
My lord,
Not involved in brawl.
but there is
Yes.
nothing, there is
No,
no
madam.
material at all.
Nothing. Yes.
Even the
One HCGP to emergent notice. Thank your fortunes, I'm issuing notice. Yes.
Blight.
Who's in possession? Meantime. Learned is the petition HCGP 29.
Please, madam.
DV Act
Oh,
2 and
English.
3. Yes.
Unless husband is not before
Both
this.
husband is not there. DV Act respondents 2 and 3.
Please.
Yes, next.
This is for unmarking of the.
Huh? Correct. SPP has to appear in this.
Yes, my lord, this is for that unmarking of lien in Devrajar's terminal, my lords, where A2, my lords, was pleased to quash. Now, when we file an application for unmarking of lien, the only reason for rejection is, so far as A1 is concerned, there is a stay. Therefore, I can't consider the application.
Let the SPP appear. Heard the learned senior counsel Sandesh. Heard the learned senior counsel Sandesh Chowta appearing for the petitioner. Learned HCGP is directed to accept notice for the respondent state. The learned SPP is directed to appear in the case at hand. List the matter Monday, fresh matters.
Obliged.
Shiji split.
Split some.
Split andre acquit agidara yararu.
No, they have pleaded guilty.
That can't be split.
Lordship
You also plead guilty.
No, 10 years they tried to, CW 1 to 3, 1 to 5 are the,
Proclamation is issued to CW 1 to 5, you know.
why they have been dropped? Because 10 years prosecution tried to secure them, they could not do
What's
that.
the offense?
Sorry, my lord.
What's the offense?
Offense is 324, simple in nature. Wound certificate is page number 34, my lord, simple in nature.
How many of
And I am not the
you? How many of you remain here?
5 of us. 1 to 5 are remaining.
Who have pleaded guilty?
6 to 10.
You are accused 1 to 5.
1 to 5. For a moment,
Yes,
lordship.
madam, look into it. The learned HCGP is directed to accept notice to the respondent. Tuesday, fresh matters. Yes, next. Accept notice and look into the papers and make submissions. List on
For petitioner.
one ನಿಮಿಷ sir. List on Tuesday. ಈ 32 Zoom ಕಾರ್ ಕೊಡಿ ಬೇರೆ ಎಲ್ಲ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ. ಎಲ್ಲಿದೆ?
Appearing for petitioner.
ಆಮೇಲೆ
The complaint, the respondent too has filed complaint.
ಅದು
against the
ಆಮೇಲೆ.
petitioner. So they have sold the vehicle.
No case at all. We'll dismiss it.
No,
I have stayed in 10 cases. Where is that? Without homework, you come. The Zoom card on them. Yes. Same. Next.
My lord, the victim and petitioner are both are colleagues in Victoria Hospital.
Victoria Hospital.
Yes, my
ಏನಾಗೋಯ್ತು?
Data entry operators.
ಅಯ್ಯೋ.
They had a love since 2018.
Data change ಆಯ್ತು.
The complaint lodged in the year 2023, my lord.
2016.
18, since 18, 2023 FIR is registered.
Promise to marry.
Promise to marry.
Yes. The petitioner and the respondent, complainant, were employees in Victoria Hospital working as data entry operators. They have had friendship, relationship, which was physical as well for over 7 years. The relationship breaks in the year 2023 and the offense of rape as obtaining under section 376 has sprung on breaking of the said relationship. In the light of the settled principle of law that an offense under rape cannot spring in a consensual relationship for years together, permitting further proceedings would run foul of the judgment of the apex court in the case of Dhruvaram Madalayar Sonar, so and so, 2018-19 SCC, page 191. Therefore, there shall be an interim order stay of further proceedings square the petitioner to the next date of hearing. 1 HCGP 2 emergent notice. Next. List 173 violation. List the matter on Tuesday. Further proceedings before the concerned court shall remain state till the next date. Avate hakidin madam ella. We'll send everything back. Yes, next.
Connected matter, let me kindly be tagged with it.
Kodi.
35, my lord.
30 ಲಕ್ಷ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
Lord, I have
Online
given check.
transaction ತಾನೇ ಆಗಿರೋದು.
I have given check, my lord.
ಎಲ್ಲಿದೆ? Where is the?
My lord, the check.
Where is the evidence to show that you have returned the money?
No, my lord, I have given the check, my lord.
Check honor ಆಗಿದೆ ಅಂತ ಎಲ್ಲಿದೆ?
Lord, they have not.
ಅದು ನಂಗೆ ಗೊತ್ತಿಲ್ಲ.
But there is no intention, my lord, in
No,
so far as section
give
420
back.
is concerned.
No, ಅವೆಲ್ಲ ನೋಡೋಣ.
My lord,
ಈ ಸ್ಮಾಲ್ ಪ್ಲೇಯರ್ಸ್ಗೆಲ್ಲ ಸುಮ್ಮನೆ ತೊಂದರೆ ಕೊಡ್ಬೇಡಿ.
the amount is borrowed by accused number 2.
No
I am
problems.
accused number 1.
So what, sir?
My lord,
Accused
the
number
entire-
2 ಯಾರು?
Accused number 2, my lord, is the person who borrowed the money.
Who
from
are
me.
you?
My lord, I am the friend of accused number 2.
ತೊಂದರೆ ಇಲ್ಲ. Anything else?
My lord, I have
Show
no
me
transaction, my
the
lord.
petitioner to demonstrate the return of the amount of 30 lakhs as he submits that check is already issued in favor of the complainant. If such demonstration comes about, it's only then the interim order would be granted. List the matter on 6th July in the fresh matters list. Yes.
My lord, insofar as section 420 and 406 concerned, my lord, there is no case, my lord.
No problems. ನೀವು ಕೊಡಿ, ಕ್ಲೋಸ್ ಮಾಡಬೇಡ.
My lord, I cannot give, my lord, the entire.
Get the info, sir. Get the your friend alva. Get the info.
Now, my lord, he is not.
Oh, his enemy is big. Frenemy. All right. Get it.
Now, my lord, he is not in touch with me,
No,
my
if you
lord.
want an interim order, get the information. Yes. Zoom kara adane ಮಾಡಿ.
Tuesday, my lord.
And for the petitioners, my lord, the present case arises out of the long-standing land dispute between the petitioners
Correct.
and.
Own certificate allide. Madam,
Hmm.
own certificate.
27 and 28, your lordship.
One one eight.
But ಮರದ ದೊಣ್ಣೆ ಇದ್ದ ಅಂತ.
ಅಲ್ಲ ಇಲ್ಲಿ ನೋಡಿ ಇಲ್ಲಿ.
Please, your lord.
In the meantime, yes, next. Statement.
It's much of it.
Petitioner.
ಇದು ಕಷ್ಟ. Own certificate.
At 67, my lord. Page number 67. Simple in nature, my lord. Whereas it is a counter complaint lodged by the.
Nim complaint date ಏನು?
Same 8.
Case and counter case.
Please, my lord. 8/2/26. There is an 1 hour of difference where after the.
One HCGP2 emergent notice. ಯಾರ್ದು picture ಇದು? Page 94.
94 is the petition number 3, my lord.
The meantime, next. Yes.
Obliged.
I'm for petitioner. Promise to marry the.
Fulfill the promise.
The law affair between the.
No affair. Then why did you promise?
2020 minute date of incident.
Hello, why did you promise, sir?
The complaint came to be lodged and after 5 years, madam. 5 years, after 5 years.
5 years you had relationship.
Yes. The last minute incident on 21/6/2025, madam. She has implicated all father. And,
Last of the incident.
Last minute, that is the last incident. Then, madam, the other petitioners, madam, they are friends, madam.
Friends?
Friends.
You know.
The petitioner, second petitioner is the father, madam.
On that we will stay, not a problem.
Third and fourth petitioner are the friends of the father.
That also will stay.
Please.
Yeah, first one. Huh?
The consensus sex mode last from 2020 minute they had in sexual intercourse mode.
2020.
2020 minute, according to.
The petitioners are accused 1 to 4. 4 or 5?
1 to 4.
1 to?
1 to 4.
1 to 4 are before the court calling in question the proceedings registered for offence punishable under section 69 inter alia. The first petitioner and the respondent complainant have had relationship sexual as well between 2020 to 2025. All on the pretext of promise of marriage is the allegation. The relationship breaks. The petitioner, accused number 1, who has had relationship, his brother and parents are also dragged into the vortex of crime without there being any rhyme or reason. Permitting further proceedings would run foul of plethora of judgments rendered by the apex court on the issue, and the latest being 2026 SCC online SC page 436. Therefore, there shall be an interim order of stay of further proceedings by the petitioners to the next date of hearing. Next. In the meantime, the petitioner is alleged of offence bigamy.
Bigamy.
A4.
Witness, man. There are witness.
The petitioner is accused number 4 in an offence of bigamy that is alleged against the complainant by the complainant against the husband accused number 1. The petitioner is alleged to be present at the time of the said alleged incident of the second marriage. Barring the said statement, there is nothing against the petitioner that a proceeding must be permitted to be continued for bigamy. In that light, there shall be an interim order of stay only against accused number 4 till the next date of hearing.
5, 6 are the witness.
4, 5, 6 ಮೂರು ಜನ ಇದ್ದಾರಾ?
3 ಜನ 4, 5,
4, 5, 6 same. Yes.
4,
same
5,
order.
6.
4, 5 ಅಲ್ಲಿ 4 ಬದಲು 4, 5, 6 ಅಂತ. Yes, next. Arbitration proceedings is the.
Yes, page. Page 93, my lords, is the first arbitration.
A breach of financial transaction between the parties is sought to become the fulcrum of the registration of the crime. Such proceedings, if permitted to continue, would be putting a premium on the usage of the criminal justice system for the purpose of settling financial discord between the complainant and the petitioner. In that light, there shall be an interim order of stay. Next.
Registered agreement of sale in 2018. 2026, they go and file a complaint saying that 31F.
May not be as simple as you're saying.
It is, because that is the only basis on which the complaint is filed. That 2018, I entered into a registered agreement of sale. That agreement of sale I have not yet acted upon because it is subject to the outcome of an FDB proceeding which they are conducting in the civil court.
Atrocities ಏನೋ ಇದೆ ಇಲ್ಲಿ?
They belong to that community, so they go
Heard the
and
learned senior counsel, Dhananjay Joshi, appearing for the petitioner. The second respondent is the complainant. The complainant and the petitioners enter into petitioner accused number 1, sole accused.
Sole accused. Others anta idare, but we are the only
accused number petitioner accused in the year agreement of sale ಹೇಳಿದ್ನಲ್ಲ, agreement of sale in the year 2018. The complaint is registered in the year 2026. Suit ಹಾಕಿದಾರಾ?
ಇಲ್ಲ.
Registered in the year 2026, and the fulcrum of the complaint is breach of the agreement or the contract. Having lost limitation to institute a suit for specific performance, the complainant appears to have set the criminal law into motion. In that light, there shall be an interim order of stay, further investigation. Yeah, till the next date of hearing. Next.
Grateful.
The petitioners are accused 1, 3 and 4.
2, 3 and 4.
But 1 ಅಂತ ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ? 2, 3 and 4, sorry. 2, 3 and 4, 85. Madam, ಅದು ಬರ್ಕೊಳ್ಳಿ. 2, 3 and 4, 85 ಅಂತ ಬರ್ಕೊಳ್ಳಿ. ಕೇಳಿ ಅವರು. Yes. In the meantime, there shall be an interim order of stay for the proceedings. Next.
Petition.
1 HCGP, 2 emergent notice.
Your Lordship, I will take notice for respondent.
You file your wakalat, madam. Tundre. Yes.
I will file during the course of the.
Oh, yes. Whenever you
file
want.
my objections also.
Whenever, whatever you want, you can do. Yes.
Stay.
Husband.
I am husband, but only 2 points I will make submission. If your Lordship is appeased of those 2 points, your Lordship may grant stay.
Yes.
My refuse. First point, my Lord. On 22/4/2025, she has lodged the first complaint alleging that the incident has taken place on 18/4. Thereafter, the police offered NCR. Thereafter, my Lord, the marriage of the brother of the petitioner was scheduled on 7/5 and 8/5. Then she lodged the complaint on 4/5, alleging that the incident has taken place on 17/4, just to sabotage the marriage. Though, albeit she has filed the complaint on 22/4, alleging the incident on 18/4. In her complaint dated 4/5/2025, she has not stated anything about the incident on 18/4. And thereafter, my Lord, the police started insisting the brother of the petitioner to come to the police station, whose marriage was scheduled on 7 and 8. There he was compelled to approach this honorable court. And
correct. Nane permit ಮಾಡಿ, don't disturb the marriage anta.
Your Lordship, they only have filed the.
Who asked you to speak? Are you on caveat? Then wait.
No, Your
Yes. I have myself given permission for the marriage, telling the police, don't disturb the marriage.
Yes, I have produced.
All right. Correct. I have ಹಾಕಿದ್ದೀರಾ? I have not seen anyway. Yes.
I have not first time.
No. If you have destroyed her peace, she has tried to destroy your peace. Nothing. Now both of you end things with peace.
The number of
Peace. Yes. Next. Husband.
It's only the husband.
Only the husband. Gottu.
FIR, it was 11 of them, please.
1 HCGP 2 emergent notice, returnable by 15 July.
One statement.
Avate ನೋಡೋಣ.
In fresh matters, please.
Of course, fresh matter. Yes. 1.
Yes, my lord.
24. Page 24.
Yes.
Notice 1 HCGP 2 emergent notice.
My lord, in this case, there is in the wound certificate, my lord, it is not
Barley. Yes. Next.
Because A3 also, my wife also died, my lord, because both are related.
We'll see. Yes.
I was not present on that day, my lord.
One. Why?
I was not present.
Other not.
I was in some other village.
Clear alibi evidence. Yes.
Clear, my lord.
1 HCGP 2 emergent notice. Next.
For the petitioner, my lordship, for merely commenting on the social media post
Police have invoked 153.
ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ.
504 of IPC, my lordship. Kindly come to the page number.
1 HCGP to emergent notice. Next. Barley, let the complaint come. Yes.
Date may be given, my lord.
Returnable by 16 July. Yes. Next. 171E. In,
Election.
ಕೊಡಿ ಜಡ್ಮೆಂಟ್ ಈಗಲೇ ಕ್ವಾಶ್ ಮಾಡ್ಬೇಡ. ಏನ್ ಅದಕ್ಕೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದು ಅದು ನಾನೇ ನೋಡ್ಕೋಬೇಕಾ? ಮತ್ತೆ ಏನ್ ಹಿಂಗ್ ಮಾಡಿದ್ರಿ?
Sorry.
ಕಂಪ್ಲೇಂಟ್ ಯಾರು?
Complaint squad flying also.
171E.
Within 100 meters.
1 HCGP to emergent, HCGP accepts notice for the response in the meantime. Next. Judgment ತರಲಿ no quashing. Yes.
One submission. He is a guest lecturer.
ಸ್ಟೇ ಕೊಟ್ನಲ್ಲ ಸರ್. ಸ್ಟೇ ಕೊಡೋದ್ ಬೇಡವಾ?
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಗೆ ಕಾಲ್ ಮಾಡಿದ್ದಾರೆ.
ಸ್ಟೇ ಕೊಡೋದ್ ಬೇಡವಾ?
ಬೇಕು.
ಮತ್ತೆ ಡಿಸ್ಪೋಸಲ್ ಅಂದ್ರೆ ಜಡ್ಮೆಂಟ್ ತರಬೇಕು.
ಮಧ್ಯಾಹ್ನ ಕೊಟ್ಟು.
List on Tuesday in the fresh matters list. No stay, nothing. Yes.
ಅಲ್ಲ
ಅವತ್ತು ಕ್ವಾಶ್ ಮಾಡೋಣ ತಗೊಂಬನ್ನಿ.
ತೊಂದರೆ ಆಗ್ತದೆ. ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಗೆ ಅಪ್ಲೈ ಮಾಡ್ಬೇಕು.
ಮತ್ತೆ ನೀವು ತರ್ಬೇಕು ತಾನೆ ಎಲ್ಲ. ಎಸ್.
ತಮ್ಮದೇ ಜಡ್ಮೆಂಟ್ 4 ಇದೆ.
ಕೊಡ್ಬೇಕಲ್ಲ ಅದು. ಎಸ್. ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಸ್ಟೇ ಇರ್ಲಿ ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ನೀವು ತರದೇ ಬಂದ್ರೆ ಕೊಡೋದೇ ಇಲ್ಲ. ಹೋಮ್ ವರ್ಕ್ ಮಾಡ್ಬೇಕು. ಪಾಸ್ ಓವರ್ ಕೊಡಿ ತಗೊಂಬನ್ನಿ. ಎಸ್.
318 clause 4, my lord. It is a monetary dispute, my lord. Which has been brought into.
ಏನು monetary dispute? ಕಾರ್ ರಿಪೇರಿ ಯಾಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು?
Lords, it has been delivered, my lords. Thereafter, the allegation is that the friend took, my lord. The petitioner has not took the vehicle. Kindly peruse the complaint, my lord. It has been clearly stated, my lord.
Yes.
Please.
2 and 3 498A. Madam. 2 and 3 498A in the meantime. ಅದು ಡೀಟೇಲ್ ಆಗಿ ಸ್ವಲ್ಪ ಆಮೇಲೆ. Yes. Next.
Petitioners in this case, your lordship.
What damage?
Nothing damage, your lordship. Actually, the property ಅಲ್ಲಿ 12 cement boards ಬಿದ್ದಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದಕ್ಕೆ
ರೆಸ್ಪಾಂಡೆಂಟ್
petitioner.
ಪೆಟಿಷನ್ ಈ ಕಡೆ ಬನ್ನಿ ಸರ್. ನೀವು ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಎಸ್.
7 o'clock ವರೆಗೂ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕೂರಿಸಿ ಏನಕ್ಕೆ ಅರೆಸ್ಟ್ ಮಾಡಿರೋದು? ಸಿವಿಲ್ ಡ್ರೆಸ್ ಅಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗಿರೋದು ಲಾರ್ಡ್ಶಿಪ್. ಮಾತಾಡ್ಬೇಕು ಅಂತ ಕರ್ಕೊಂಡು ಹೋಗಿರೋದು ಪೊಲೀಸರು. 7 o'clock ವರೆಗೂ ಕೂರ್ಸ್ಕೊಂಡು ಏನು ಹೇಳ್ದಿರೋ ಕಾರಣ ಆಮೇಲೆ ಅರೆಸ್ಟ್ ಮೆಮೊ ಕೊಟ್ಟು ಅವಾಗ ಮಾಡಿರೋದು ಲಾರ್ಡ್ಶಿಪ್.
1 HCGP to emergent notice. There shall be an interim order of stay of all investigation. Query the petitioner.
Now there is a threat to him, your lordship. IO is
stay
ಬೇಕು lordship. Let the IO be called, your lordship.
Why?
ಏನಕ್ಕೆ ಅಂದ್ರೆ ಲಾರ್ಡ್ಶಿಪ್ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ನೀವೇನಾದ್ರೂ ರೂಲಿಂಗ್ ಪಾರ್ಟಿಗೆ ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮ ಮೇಲೆ ಇನ್ನ ಎಕ್ಸ್ಟ್ರಾ ಕೇಸಸ್ ಹಾಕ್ತೀನಿ. ಚಾರ್ಜ್
learned in the 1 HCGP to emergent notice. In the meantime, there shall be an interim order of stay for all investigation. The learned
This is ready to be filed.
Keep it with you, madam. Yes. The learned HCGP submits the charge sheet is ready to be filed. The readiness and willingness is stalled. Yes. There shall be an interim order of stay of all further proceeding for further investigation. Query the petitioners to the next date of hearing. So learned HCGP secure instructions with regard to the allegations made by the petitioner with regard to the illegal detention of the petitioners in the police station without any rhyme or reason by the next date. Yes. Next. You want to see the IO, is it?
Yes, sir.
You want to see the IO?
Not me, your
Then leave it. Yes.
ರೌಡಿ ಶೆಟ್ರ್ ಆಗ್ತೀನಿ ಅದು ಅಂತ ತುಂಬಾ ಮಾಡ್ತಿದ್ದಾರೆ. ಅವ್ರು ಚಿಕ್ಕ ಮಕ್ಳಿದ್ದಾರೆ ಸುಮ್ನೆ ಕರ್ಸಿ ಸ್ಟೇಷನ್ ಗೆ
ಮತ್ತೆ ಮಾಡಿದ್ರೆ ಹೇಳಿ ಮೇಡಮ್. Yes.
Appear for the petitioner, my lord.
Compassionate appointment ತಗೊಂಡ್ರಾ?
ಇಲ್ಲ madam. No, my lord. 43 page number if you see. Since I have not got the compassionate job, there is no cheating at all. Page 43.
Correct. But ಏನು application ಕೊಟ್ರಿ? Fake death certificate.
But all this is related to A1.
ಅಲ್ಲ ಕರೆಕ್ಟ್. ಫೇಕ್ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ಬದುಕಿದ್ದಂಗೆ ಸತ್ತೋಗಿದ್ದಾರೆ ನಿಮ್ಗೆ ಕಂಪ್ಯಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ತಗೊಂಡ್ರೆ?
ನಾಟ್ ಫೇಕ್ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್. ಏನಂದ್ರೆ PUC ಡಿಗ್ರಿ BCom ಬಂದು 2019 ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ. PUC ಬಂದು
ಸಿಗ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ?
ಅಂದ್ರೆ ನನಗೂ ಇದಕ್ಕೆ ಯಾವ ಸಂಬಂಧ ಇಲ್ಲ. I am just accused number 2. If you see page number, my lord, 43, last paragraph, my lord.
In the meantime, yes. Next.
My lord, stay, my lord. Much obliged.
Main time ಅಲ್ಲಿ ಗೊತ್ತಾನೆ.
This case emperor, petitioner, my lordship.
Hmm.
So like petitioner is this.
79 and 85. Husband.
ಅಲ್ಲ
ಮತ್ತೆ ಇನ್ಯಾರು?
father in law, my lordship.
ಅದಕ್ಕೆ father in law, why did he want anything with the daughter in law?
ಅದು these my lordship think page number C. ನನ್ನ ಪೆನ್ಷನ್ ಎಲ್ಲ ನನಗೆ ಬರಬಾರ್ದು ಅಂತ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದಾರೆ 2020 ಅಲ್ಲಿ. This is motive. My son is the large complaint through our wife, my lordship. Priyanka Srivatsa case comply ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. Private complaint, my lordship.
Yes. Private complaint.
ಹೌದು ಸ್ವಾಮಿ. Page number 21, my lordship.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ?
ಇನ್ವೆಸ್ಟಿಗೇಷನ್
ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಪ್ರಿಯಾಂಕ ಬರಲ್ಲ.
ಅಲ್ಲಲ್ಲ.
1 HCGP 2 ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. ನೆಕ್ಸ್ಟ್.
My lordship, the magistrate.
ಚಾರ್ಜ್ ಆದ್ಮೇಲೆ ಬರಲ್ಲ ಸರ್.
ಚಾರ್ಜ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಬರೋಲ್ಲ
ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ನನ್ನ ಆಸ್ತಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಬರಲ್ಲ. ನೆಕ್ಸ್ಟ್.
ಅಲ್ಲ ಇದು my lordship,
1 HCGP 2 ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. ನೆಕ್ಸ್ಟ್.
Same, my lordship.
No sir.
ಅಲ್ಲ 85 and 4 of the DP Act, my lordship. 95 ಅಲ್ಲ ಸ್ವಾಮಿ. 85 and
79 ಇದೆ.
79 ಇಲ್ಲ ಸ್ವಾಮಿ. ಅದೆಲ್ಲ ಡಿಲೀಟ್ ಆಗಿದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ 85 ಮತ್ತೆ 498 ಗೆ ಹಾಕಿರೋದು ಸ್ವಾಮಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ಡ್.
Come to page 13.
So in page number 36. 36. Column 5, my lordship. 85 and 4.
Your husband ಏನು?
Father in law, my lordship. ನಾನು ಗುಲ್ಬರ್ಗದಲ್ಲಿರೋದು.
ಒಂದು ನಿಮಿಷ. You are not husband.
ಹಸ್ಬೆಂಡ್ ಅಲ್ಲ ಸ್ವಾಮಿ. ನಮ್ ಸೊಸೆ.
ಗೊತ್ತಾಯ್ತು.
Column number 5, Swami. BNS 85.
In the meantime, yes, next.
Much up.
Petition.
A2. 109.
109 is not attached to the accused number 2. It's only against the accused number 1. She is not present at the date of incident, madam. She was in Tirupati at the date of.
Tirupati ಯಾಕೆ ಹೋಗಿದ್ರಿ ಅಲ್ಲಿಗೆ?
She is working at the TTD.
Working there.
And more own certificate is simple in nature.
You don't argue for accused number 1. The petitioner is accused number 2. The second respondent is the complainant. The allegation is attempt to murder under 109 and the offense under the Dowry Prohibition Act. The petitioner works at Tirupati is demonstrated by the petitioner with the documents appended to the petition. All the other allegations are against accused number 1, the husband, including the allegation of attempt to murder as obtaining under section 109. In that light, there shall be an interim order of stay quo the petitioner accused number 2 till the next date of hearing. 1 HCGP 2 emergent notice. Next.
Petitioner, my lord, allegation of section 74 of the BNS and 67 of the IT Act. Said to have, my lord, sent some electronic communication of the year 2022-23. After 3 years, my lord, complaint has been lodged. This is the second complaint, my lord. First complaint.
Which is the first one?
In crime number 40, my lord, which is.
ಅದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಬರ್ಬೇಕಷ್ಟೇ, ಇನ್ನು ಬರ್ಬೇಕು.
ಬರ್ಬೇಕಷ್ಟೇ. ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೇನೆ.
ಯಾಕೆ ಮಾಡಿದ್ರಿ?
ಮಾಡಿ.
ಅದು ಹಳೇದಲ್ವಾ?
ಅದರಲ್ಲಿ accused number 6, my lord.
The petitioner, your husband and wife?
ಇಲ್ಲ, my uncle's wife, my lord. My mother's brother.
Allegation of section 74 of the BNS, which is 354 of the earlier regime, the IPC, has sprung of an incident that happened 3 years prior to the registration of the complaint, that the petitioner has circulated certain photographs of the complainant in the year 2023, 2020, on 10/5/2020, and the complaint has come on 28/5/2026. Therefore, till the appearance of the complainant, there shall be an interim order of stay of further investigation. 1 HCGP 2 emergent notice returnable by 21st July. List on 21st July in the fresh matters list. Next.
Petitioners are in-laws.
2 and 3.
2, 3, 4.
2, 3. Petitioners are 2, 3 and 4. alleged offense is 85 of the BNS, finding no ingredients of the offenses that could become, that could become the offenses as alleged, there shall be an interim order of stay of further proceedings qua the petitioners 2, 3 and 4 till the next date of hearing.
But
Yes.
there is a monetary transaction between the complainant and the petitioner, stating that they have the petitioner has used 27 lakhs. Said amount was repaid to the
No,
complainant, my lord.
page 14 complaint ಆಗಿದೆ ಈಗ ಇನ್ನು. Complaint ಅಲ್ಲಿ ಎಲ್ಲ ಇದೆ.
La complaint, it is, there is no whisper of the date of incident.
No
The entire
problems.
complaint, there is no whisper of
One
date when the
HCGP,
incident.
2 emergent
Alla,
notice.
the entire family members are roped in
No,
the
sir.
commission of
Let
offense.
us see.
There is no coercive steps.
No, no.
Any date, my lord.
ಯಾಕೆ ಬೇಲ್ ತಗೊಳ್ಳಿ? Yes.
Because in the.
ಬೇಲ್ ತಗೊಳ್ಳಿ sir.
Allala, I have paid the entire amount.
No
I
problem.
produced the
Yes.
statement of account.
Learned HCGP to secure the investigation papers and place it before the court on the next date. List on 16 July. Next.
And fresh matters list, my lord.
Yes, sir.
Fresh matter.
Yes, sir.
Because in the entire complaint.
No,
No,
sir. ಮತ್ತೆ ಆಯ್ತಲ್ಲ ಇನ್ನೇನು ರಿಪೀಟ್ ಮಾಡ್ತಾರೆ.
date will end.
ವಾಪಸ್ paid back the amount, is it?
No, madam. This is an
58
employment
ಅಲ್ವಾ?
dispute.
Oh, 58 is 306.
Employment dispute.
No,
in a
we'll
criminal
see.
color. 3 years, my lord, after.
One HCGP, the learned HCGP is directed to secure the investigation. Charge sheet ಆಗಿದೆ ಇಲ್ಲಲ್ಲ? Investigation papers and place it before the court on the next date. List on 7th July in the fresh matters list.
But still,
No,
but
no,
2 years.
abetment to suicide, we'll see.
No,
Let-
abetment is breach of trust, my lord.
DNS.
316.
Oh, okay.
ನಿಮಿಷ ಕೊಡಿ.
DNS.
Pending civil suits are there.
One moment, sir. Why have you said 306?
No, 306 BNS and theft and.
Yes,
Breach of
the main time. Next, state. Nimdu, how do you demonstrate payment?
My lord, payment I have.
You have
payment,
said you
yes.
have returned the entire amount. How do you demonstrate?
My lord, in page number 40.
40.
40. Page number 40, I have paid the entire, and he has
56 lakh 57,000.
I have acknowledged it. And page number 42, my lord, page number 41 also, and 42 also. I have paid, and he has acknowledged it. And in spite of acknowledgement, he has filed.
In the meantime, next. Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. 6 July in the fresh matters. Next. Ketan, wound certificate idea?
Not produced, my lords.
Produce it. Get the records.
My lords, serial number, annexure E, complaint filed by the petitioner in state by the Assembly Court.
Good.
Annexure E, my lords.
Page.
Page 31.
31.
Tag same order. Page 31, madam. Tag with that same order. Next.
My lords, in my interim prayer.
ಅದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಇದೆ.
Yes.
Please. Petitioner. There is a honey trap, my lord. 30
Honey
lakhs-
trap?
Please, 30 lakhs rupees have been collected, my lord.
Who trapped you, sir?
The second respondent. I have lodged a complaint, my lord. I kindly see, first complaint is mine, my lord. After that, my lord, I recently.
Why honey trap in which year?
From 25 only. 25 in the.
Attempt to murder ಇದೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಈ ಕಂಪ್ಲೇಂಟ್ ಆದ್ಮೇಲೆ ಡೇಟ್ ಆಫ್ ಇನ್ಸಿಡೆಂಟ್ 7/5/2026 ಮೇಡಮ್ ಅದರಲ್ಲಿ ಎಲ್ಲೂ ಸಹ there is no weapons used ಮೇಡಮ್
ಕುತ್ತಿಗೆ ಹಿಸುಕಿ ಚಾಕುವಿನಿಂದ ಚುಚ್ಚಲು ಪ್ರಯತ್ನಿಸಿ
ಕುತ್ತಿಗೆ ಇಸ್ಕಿಲ್ಲ ಚಾಕುವಿಂದ
ಅದು ನೀವ್ ಹೇಳ್ತೀರಾ?
ಬಿಕಾಸ್ ಮೇಡಮ್ ಮೈ ಕಂಪ್ಲೇಂಟ್ ಈ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಈ ಕಂಪ್ಲೇಂಟ್ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 17 ಮೇಡಮ್ ಕೆಟ್ಟ ಮಾತುಗಳೊಂದು ನನ್ನ ಮೇಲೆ ಪೊಲೀಸರಿಗೆ ದೂರು ದಾಖಲಿಸಿರುತ್ತಾರೆ ಆಫ್ಟರ್ ಮೈ
let me get the investigation papers. List the matter on Tuesday, Monday, fresh matters. The investigation papers be secured and placed before the court on the next date. Yes. ಅದು 5 ದಿನಕ್ಕೆ ಏನಾಗಲ್ಲ ಸುಮ್ಮನೆ.
ಪೊಲೀಸ್ ಆರ್ ಮೇಲೆ ಥ್ರೆಟನಿಂಗ್
ಹನಿ ಟ್ರ್ಯಾಪ್ ಆಗ್ಬೇಕಾದ್ರೆ ಇವೆಲ್ಲ ಆಗುತ್ತೆ.
ರೀಸೆಂಟ್ಲಿ ಮ್ಯಾರಿಡ್ ಇದಾರೆ.
ಮದುವೆ ಆದ್ಮೇಲೆ ಹನಿ ಟ್ರ್ಯಾಪ?
ಮದುವೆ ಆಗೋದ್ಕಿಂತ ಮುಂಚೆನೆ ಮದುವೆ ಆಗಿರೋದು ಗೊತ್ತಾಗ್ಬಿಟ್ಟು ಈ ತರ ಶಿ ಇಸ್ ನಾಟ್ ಡೈವರ್ಸಿಂಗ್ ಮಿಲಾಡ್. ಶಿ ಇಸ್
ಓ, ಹನಿ ಟ್ರ್ಯಾಪ್ ಅಂತ ಗೊತ್ತಾಗಿ ಡಿವೋರ್ಸಾ?
ಅಲ್ಲ ಅವರು ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಇಸ್ ಮ್ಯಾರಿಡ್ ಮಿಲಾಡ್. ಶಿ ಇಸ್ ಹ್ಯಾವಿಂಗ್ 2 ಚಿಲ್ಡ್ರನ್.
ಆಯ್ತು.
ಅದಾದ್ಮೇಲೆ ಟೇಕನ್ 30 lakhs ಮಿಲಾಡ್
ಫ್ರಮ್ ಹರ್.
ನನ್ನ ಹತ್ರ ಅವ್ರು ತಗೊಂಡಿದ್ದು.
ಆಮೇಲೆ
ಅದಾದ್ಮೇಲೆ ಮದುವೆ ಫಿಕ್ಸ್ ಆಯ್ತು.
ಯಾರ್ ಮದುವೆ ಫಿಕ್ಸ್ ಆಯ್ತು?
ಪಿಟಿಷನರ್ಸ್ ಮದುವೆ.
ಆಲ್ ರೈಟ್.
ಅಂಡ್ ಮದುವೆನೂ ಆಯ್ತು.
ಹನಿ ಟ್ರ್ಯಾಪ್ ಇಂದ ಹೋಯ್ತಾ ಅದನ್ನು?
ಇಲ್ಲ ಮದುವೆ ಆಗಿದೆ ರೀಸೆಂಟ್ ಆಗಿ. ಅದಕ್ಕೆ ಮದುವೆ ಆಗಿರೋ ವಿಚಾರ ಗೊತ್ತಾಗಿ
5 ದಿನಕ್ಕೆ ಏನಾಗಲ್ಲ ಸರ್.
ಟಿಲ್ ದೆನ್ ಅಟ್ ಲೀಸ್ಟ್.
ಟಿಲ್ ದೆನ್ 5 ದಿನ. ಎಸ್. ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ನೆಕ್ಸ್ಟ್.
Offenses 316 and 318. This excessive performance suit is pending. He filed in 2025. Now he filed in May 2026. He filed a complaint against offense 316 and 318.
In the meantime.
Oblige.
Your Lordship has stayed the identical matter.
305 can't be forced. Yes, but tag along with so and so. Same order. ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಮೇಡಮ್ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
And for the petitioner. Petitioner was working as district manager in Shimoga Food and Steel Supply Corporation. He retired in the year 2011, May. A complaint was lodged in respect of a procurement of food grains for the year 2009 and 10.
Criminal proceedings 214B2B ಬರಲ್ಲ. ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿಗೆ ಮಾತ್ರ.
But in 2018, Lokayukta appears to have sent a report.
ಅದೇ correct.
On the basis of this report, after a lapse of more than 8 years.
ಈಗೇನ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ಡ್ ಅಲ್ಲ?
Registered. On the private complaint filed by the corporation.
Learned HCGP is directed to accept food and civil supplies. HCGP is directed to accept notice for the respondent. There shall be an interim order of stay of further investigation qua the petitioner, owing to the fact that an incident of the year 2011 is now sought to be projected to become a crime pursuant to certain report of the Lokayukta. Therefore,
Proceedings pending criminal case before the magistrate Shimoga.
oh, so what? Stay ಮಾಡಿದಿನಲ್ಲ. Yes. Next. Speedy trial.
Speedy, my lord, disposal of the revision petition.
Correct. The petitioner is before this court seeking the following prayer. The petitioner gets embroiled in a crime and crime number. Hey, you are the complainant.
We are the complainant, my lord. We filed the petition.
The petitioner is the ಬನ್ನಿ ಇಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಅಂತ ಹಾಕ್ತೀರಿ. You are the complainant or the accused?
Lord, we are the victims, my lord. The complaint is the second respondent. The assistant register of the cooperative.
Come to the cost title, sir. Wait, first petitioner, accused number 1.
That is a mistake, my lord.
Mistake. Correct the mistake.
My apologies, my lord.
Yes, sir. Correct the mistake. Tomorrow, fresh matters. Yes.
The petitioner.
OS number.
OS number 265 of 25 and another case is 506 of 25.
Perkondu madam.
Synopsis.
The parties to the list are before the civil court in the said original suits. On the same set of facts, the petitioner, the complainant is sought to set the criminal law into motion. Therefore, an issue which is seemingly civil in nature is sought to be dressed with the color of crime. Permitting further proceedings would become an abuse of the process of the law, albeit prima facie. Therefore, there shall be an interim order of stay of further proceedings, qua the petitioner to the next date of hearing. Password. Learned HCGP is directed. NDPS.
Yes, please. Lordship has quashed. I have produced in Annexure C, my lords. Based
What
on the
quashed?
voluntary, based on the statement of the co-accused, I have been arraigned in the.
You have the
accused
Junaid
number
case,
4.
huh?
Sure.
Junaid's judgment, is it?
Yes, please. Junaid and also your Annexure C, my lords. Page number 201, my lords. Sakayat Bhattacharya, even your lordship has quoted in Tufan Singh case also.
Tufan.
Please.
Yes, we'll see. One, HCGP is directed to accept notice for the respondent. List on Monday, fresh matters. We'll close it on that day.
Obliged.
Madam, check if there is any corroborative material.
No
Yes.
material.
Allow note. Let her see. Yes.
Obliged.
For petition.
69. No?
16.
Ah.
They are in relationship of more than 2 years.
Why did you break?
We are ready to marry, but
Ready to
she-
marry?
but
I'll
she-
record it now.
She is breakup.
She is breakup.
Yes, Your Lordship.
Then you should make up. Why breakup?
There is a, Your Lordship kindly see in
Stay application. 70. Offense. 69 offense then.
69.
Serial number 70.
70.
Ah.
The offense is 69.
Correct. The confusion. Yes.
Your Lordship,
You are ready to marry now?
now not Your Lordship.
Why?
She-
Crime register madadru antana.
Allah, she is arrested.
She is arrested.
By
Why is she
inducing-
arrested?
By inducing the respondent number 1 police.
She is arrested for inducing you.
Respondent number 1 police.
She has induced respondent number 1 police.
ಅಲ್ಲಿ ಶಿವಮೊಗ್ಗದಲ್ಲಿ ಅರೆಸ್ಟ್ ಮಾಡಿ ಇಲ್ಲಿ ಕೆಂಗೇರಿಲಿ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ.
ಯಾರನ್ನ?
ಪಿಟಿಷನರ್.
ನಿಮ್ಮನ್ನ. She is arrested ಅಂದ್ರೆ ಏನಿದೆ? ಈಗ you are out on bail?
Yes, I am out.
ಕೊಟ್ರ? Yes. The petitioner. ಏನ್ ಬೇಡ ಬಿಡಿ. In the meantime ಅಂತ ಹಾಕಿ. Yes. Next. Shall I record the undertaking that you are ready to marry? Yes.
A4 and A7.
The petitioner in this case, consists of.
You are Abhisheka.
As junior.
All right. Yes. A4 and A7, 498A.
Split up ಆಗಿದೆ.
Huh?
Split up.
Split up.
Please.
Then let it come day after tomorrow. Yes, next. 73 acts. Alla, one nimsha. 69, 72.
Appearing for the petitions.
Huh?
Appearing for the petitions.
Yes, sir.
It's more than 8 years of relationship.
8 years. ಈ 69 ಒಂದು ಕಾರ್ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಡ ಮೇಡಮ್. ದಿನಕ್ಕೆ 20 ಇರುತ್ತೆ. More than 8 years.
2017 is the.
You are 34, she is 44.
Please, she
Then?
was a divorcee. They were
Ah.
working colleagues, working in the same company in the year 2017. They got acquainted with themselves, and thereafter the physical relationship has happened. And it ended in the year 2021 as per the complaint herself.
What?
The relationship ended in the year 2021 when
Ah.
he moved out of the company. Now the complaint is lodged.
Why did you end? Promise of marriage.
There is no promise of marriage, my lords.
Yes, sir.
Legal notice is issued by her before.
Legal notice, why? There is
25
money
lakhs.
transaction.
That I have paid her.
Where?
In the reply, my lords have.
The petitioner. You are married.
No, my lord.
The petitioner, accused number 1, sole accused.
Sole accused.
The sole accused is before the court, calling in question proceedings in CC 25197 of 2026. The complainant is the second respondent. The complaint itself indicates that the two meet as the professionals in the same organization on 13th October 2017. The meeting blossoms into friendship into relationship, which was physical as well. They stayed together for over 8 years. The relationship soars. The relationship breaks And the complaint for offense punishable under section 69 inter alia springs in crime number 173 of 2025. 8 years of consensual relationship allegedly on the pretext of promise of marriage is projected to become a deceit. The learned counsel for the petitioner submits that there was no promise of marriage for all the years, but what is projected now is a farce. Therefore, the permitting further proceedings would run foul of the judgment of the apex court in the case of 2026 SSC Online SC page 436. Ankit Tomar anta ಇದೆ. Next. Access.
It's different ಇದೆ.
ಯಾಕೆ?
Because my lord, the attachment order is passed by the adjudicating authority in the PMLA Act.
PMLA.
And my lord, it's only the special court which is trying the offense under 8(3) can order for defreezing and transfer. This fact was brought.
IA madam. ಅವರಲ್ಲೇ ನೋಡ್ತಾ ಇದ್ದಾರೆ ನಮ್ದೇ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆರ್ಡರ್.
ಅಲ್ಲ, ಬಟ್ ಅದೇನಂದ್ರೆ ED is not a party.
Oh.
ED says we will not release this property because provisionally attached. Now it's subject matter of.
Now who has attached it?
The ED. And my lord, I am for the Axis Bank. I am
Make
only,
ED a party, why?
My lord, I have nothing against ED in this.
Then
case.
what is the order of challenge?
My lord, the order of challenge is of the learned magistrate directing me to defreeze and transfer it to the victim.
Transfer it to the victim. The emergent note, 1 HCGP 2 emergent notice, there shall be an interim order of stay of the order of the learned magistrate till the next date of hearing.
For the petition, my lords, the FIR has been registered against.
Forgery, sir. Forgery is the allegation.
Well, forgery is the allegation for a 30-year-old dispute, which I am a purchaser and witnesses.
You're a purchaser in the meantime. Yes, next.
Great.
PSCL property.
Yes, my lords, but
Wait. The
accused
learned,
number 5, my lords.
wait. Learned HCGP is directed to accept notice. Your accused number 5, I know, but the property will see. Learned HCGP is directed to accept.
Not been made as an accused.
ಒಂದು ನಿಮಿಷ ಸರ್. ಅದೇನು ಪರವಾಗಿಲ್ಲ, 319 ಪರ್ಮಿಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ. ಎಲ್ಲದ್ರಲ್ಲೂ ಹಿಂಗೆ ಮಾಡ್ತೀರಾ?
Directors ಕೂಡ they have not been.
ಇನ್ಮೇಲೆ ಎಲ್ಲದ್ರಲ್ಲೂ 319 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ wherever company is not made a party. Yes, the learned HCGP is directed to accept notice for the petitioner, secure instructions with regard to the role of the petitioner accused number 5 in the episode of crime. List this matter on.
In a connected matter, my lords, there is a stay.
ಕೊಡಿ ಯಾವ್ದದು?
Page 309, my lords.
List this matter on tag along with ಅದ್ರಲ್ಲಿ ಇದೆಯಾ? ಅದು accused number?
Accused number 2.
To go through the papers and secure instructions with regard to the role of the petitioner accused number 5. The learned counsel submits que accused number 2 coordinate bench.
Your lordship's order.
Que accused number 2, this court has granted an interim order. In that light, there shall be an interim order of stay of further proceedings que the petitioner to the next date of hearing. Yes. Date to yes, 16 July.
Lord petition. Two matters, my lord. First being, my lord.
Appearing in 1.1, my lords.
1.1 ಏನು?
ಒಂದರಲ್ಲಿ ಕ್ವಾಶ್ ಮಾಡಿರೋ ತಾವು 12,157 2023.
ಇದೇನು?
ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರು ದಿ ಇಂಟ್ರಿಮ್ ಮೇಂಟೆನೆನ್ಸ್ ಗ್ರಾಂಟೆಡ್ ಬೈ.
ಅದಾಯ್ತು. 1 ಅಲ್ಲಿ ಏನು?
ಇದೇನೆ ರೆಸ್ಟೋರ್ ಮಾಡಬೇಕು ಅಂತ ಕೆಲಸ. ಮೀಡಿಯೇಷನ್ ಸೆಟಲ್ಮೆಂಟ್ ವೈಲೇಷನ್ ಇದೇನೆ. On 27/10/2021, there was a mediation settlement.
1 minute. Where is the closure on settlement?
That is on lordship would.
Pages you have to tell.
Mediation. Next year, yes, madam. Document
97.
I am holding 3973 of 2019.
No, that other.
12157.
12157 ಅಂತ.
ಇದೇನು?
ಇದು ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ 6,000 ರೂಪಾಯಿ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಟ್ರು. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ಮೇಲೆ 20,000 ರೂಪಾಯಿ ಫಿಕ್ಸ್ ಆಯ್ತು. ದೆನ್ ಅಗೇನ್ ಇಟ್ ವಾಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಹಿಯರಿಂಗ್, ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರು.
ಆಯ್ತು ತಿಳಿಸಿ. ಈಗ ರೀಕಾಲ್ ಆಗ್ಬೇಕಾಗಿರೋದು ಯಾವುದು?
ರೀಕಾಲ್ 2 ಆಗ್ಬೇಕು. 1 to 1 poison.
You are appearing in that, madam.
Yes, my lords.
Page number 97.
Contention is that, my lords, I have filed for divorce, my lords, the respondent, and they have sought for interim maintenance, my lords, and that is pending and posted for orders on July 13th.
No problem. One nimisha. This is arising out of what proceedings?
This is arising out of the compromise petition entered.
Where is the compromise?
97. Ink page number 97, annexure F.
One nimisha. 97. Reunion ಆಗ್ಲೇ ಇಲ್ವಾ?
ಆಗ್ಲಿಲ್ಲ. ಆದ್ಮೇಲೆ ಪ್ರಾಪರ್ಟಿ ಮಾರಿ then again he has gone back.
All right.
ಆದ್ಮೇಲೆ ಕೂಡ ಚೆನ್ನಾಗಿದ್ರು, but 2 years ಆದ್ಮೇಲೆ they started to separate, my lords.
Para number 6, my lord, specifically. Para number 6 of the mediation. Para number 4 to 6.
The petitioner is the wife and the daughter.
Daughter.
Wife and the daughter. The respondent is the husband. The proceedings that was brought before this court, that are brought before this court, arises out of a criminal miscellaneous 68 of 2019, which is instituted by the wife, the petitioner, invoking Section 12 of the Protection of Women from Domestic Violence Act 2005, hereinafter referred to as the Act for short. Heard so and so. The petitioner, for the first petitioner and the respondent get married on 27/4/2009. The marriage between the two, the relationship between the two flounders. On floundering of the relationship, it transpires that the wife instituted several proceedings against the husband. One such proceeding is the one that is invoking the provisions of the Domestic Violence Act, the impugned proceedings. During the subsistence of the proceedings before the concerned court, the parties to the list enter into a settlement. The settlement so entered into reads as follows, page 98-99. The conditions of the settlement was that the parties have settled the dispute and have decided to live together, or a reunion as the case would be. Further condition is that the respondent husband undertook to look after the petitioner and the daughter, together with fulfilling all the obligations, and agreed to meet the educational expenses of the minor daughter, and also to live with the petitioner and the daughter. The petition is preferred, seeking recalling of the, based upon the said compromise, the proceeding against the husband stood obliterated. The petitioner and the husband is said to have, and the husband are said to have lived for a few months,
1.5 years.
for about 18 months. Again, the relationship flounders and they are separated. The petition is now preferred, seeking recall of the said compromise on the score that the husband has breached clause 6 supra of the compromise that was entered into, as he is neither taking care of the educational expense of the minor child nor is living together with the petitioner. The learned counsel appearing for the petitioner submits that petitioner wife and the daughter would submit that after the compromise, all the properties were sold by the husband, and is now wife and the daughter are left in the lurch again.
Some are subsisting, my lords. Some are
Only one property.
one property.
A property is sold, and the proceeds of which are not even paid to the petitioner and the daughter, and therefore they are now left in the lurch. If the petitioner, the mother and the daughter, or the wife and the daughter is left in the lurch, there is breach of the said compromise. Therefore, the obliteration of the proceedings which happened on the said compromise must be recalled. The learned counsel appearing for the respondent submits that the reunion did happen, but the reunion did not last for long as the relationship again floundered. The floundering of a relationship on a subsequent event would not mean that the petitioner, the proceedings must be restored by recalling the order of compromise, as the folly lies with the wife and the wife as well for not staying together with the husband. She would seek dismissal of these petitions. As observed herein above, the proceedings before the concerned court under section 12 of the Act stood obliterated only on the compromise that was entered into. The terms of the compromise were unequivocal. The the respondent husband was to live with the minor daughter and the wife, and by fulfilling all the obligations of such marriage. The allegation is that the obligation is not fulfilled, as the property that was the succor to the wife and the daughter is sold without and leaving the daughter and the wife in the lurch. Therefore, the wife in the lurch. The settlement did close not one but three proceedings. The criminal miscellaneous that was pending in 169 of 2019, the charge sheet that was in 4835 of 2020, and the criminal miscellaneous 588 of 2018 pending before the concerned court. Therefore, the husband takes advantage of the compromise and gets all the crimes closed against him, and later breaches the terms of compromise without fulfilling clause 6 as quoted supra. In that light, the inevitable conclusion is that recall of the said order, recall of the compromise and the orders of the concern, orders dated orders dated so and so, which was closed on the terms of the compromise. The said proceeding before the concerned court shall stand restored to be considered on its merit by the concerned court. Innond petition ಏನು?
Innond petition ಅಲ್ಲಿ the trial court was pleased to grant 6,000 rupees maintenance, and this one court was pleased to fix as 20,000 per month.
ಅದು ಕೊಟ್ಟಿಲ್ವಾ?
ಅದು ಕೊಟ್ಟಿಲ್ಲ, ಅದು ಕೊಟ್ಟೂ ಇಲ್ಲ. Now that has to be confirmed by this on the court.
ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ ಅಷ್ಟೇ ಅಲ್ಲ?
Order came
ಈಗ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಇದರಲ್ಲಿ?
6,000 ಕೊಟ್ಟಿದ್ದಾರೆ, ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. ಅದನ್ನ this one court was pleased to fix the maintenance as 20,000.
By which order?
Order dated 15/7/2019.
2019. ಅದನ್ನ ರೀಕಾಲ್
ಆದ್ಮೇಲೆ ಕಾಂಪ್ರಮೈಸ್ ಆದ್ಮೇಲೆ ಇದನ್ನ ರೀಕಾಲ್ ಮಾಡಿ.
ಇದು ಈ ಆರ್ಡರ್ ರೀಕಾಲ್ ಆಯ್ತಾ?
ಈಗ ಆಗ್ಲಿಲ್ಲ, ಇದು ಹಂಗೆ ಪೆಂಡಿಂಗ್ ಇತ್ತು, ಈ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇತ್ತು.
In the light of the order passed in criminal petition 12157 of 2023, the order that is the order passed by this court during the subsistence of the criminal petition 3973 of 2019 stands confirmed. The petition is thus disposed.
Maintenance of rupees 20,000 is to be confirmed.
ಅದೇ ಅದನ್ನ dispose
ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ
disposed with the observation that the order passed by this court for grant of 20,000 maintenance stands sustained.
One submission, my lord.
ನೀವೇನ್ ಇಲ್ಲ ಅದರಲ್ಲಿ ಸರ್ವ್ಡ್ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ we have filed for the divorce and that interim maintenance is pending. So
ಅಲ್ಲೇ ಎಲ್ಲ ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿ.
if this is confirmed,
ಅಲ್ಲಲ್ಲ, ನಾವು ಅಲ್ಲಿ
20,000 ಇಲ್ಲಿ ಮಾತಾಡಬೇಡಿ ಸರ್.
ಆಯ್ತು,
ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿದ್ದಾರೆ, ಸರ್ವ್ಡ್ ಅಂಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಕೌನ್ಸಿಲ್. ಅದು ದಯಾನಂದ್ ಹಿರೇಮಠ್ ಯಾರು?
we do not represent.
There is no representation. We have respondent 1 2 3 ಅಂತ ಮಾಡಿ. Yes. ಮಾಡ್ಬಿಟ್ಟು
That first matter we have sought for the dissolution and interim, they have sought for the interim maintenance and
ಎಲ್ಲಿ?
family court ಅಲ್ಲಿ.
ಮಾಡ್ಕೊಳ್ಳಿ.
That should not come in the way.
Which one madam? 3973 ಇಲ್ಲ?
157.
12157 have recalled ಅಷ್ಟೇ.
Yes. Please, madam.
Next.
This is my lord 498, my lord 306. And my lord, the complaint, my lord, herein, my lord, he wants to withdraw all these allegations. And my lord, there is no any ingredients, my lord.
You are what, husband?
I'm husband, my lord, husband, and my lord, the parents of the husband.
306 husband, I will not.
my lord, the complaint, my lord, he is ready to, my lord, withdraw, my lord, all his allegation. The complaint, my lord, is before the court.
ಫಸ್ಟ್ 302 ಹಾಕಿದ್ದು.
FIR ಅಲ್ಲಿ 302.
302 ಇತ್ತು, ಆಮೇಲೆ 306 ಗೆ ಮಾಡಿದ್ದಾರೆ.
There is no any ingredients, my
No,
lord.
no, sir. Others we may see, abatement ಇರ್ಲಿಕ್ಕಿಲ್ಲ.
No abatement.
But
there is no mens
498
rea also, my lord. There is no mens rea also, my lord. The lordship
Okay,
judgment is there, my lord, on that
ಏನು
point.
ಹಸ್ಬೆಂಡ್ಗ
That, my lord, Singaravelu judgment.
ಸಿಂಗಾರವೇಲು 498 ಐತಾ?
306.
ಮತ್ತೆ 306 alone stands on a different footing. 498 306 ಅದೊಂದು ತೀರ್ಮಾನ ಮಾಡೋಣ.
There is no any
I think
mens rea also not there.
ಕೀರ್ತಿ ಮೇಡಮ್ ನಿಮ್ದಲ್ಲ ಅದು 498 306. That order is released? Not yet. That's only mother-in-law and yes. Husband ಗಿಲ್ಲ.
No, my submission is this, my lord, in complaint, my lord, what is given by the brother, my lord, he has stated, my lord,
Mother-in-law, father-in-law, fine. Husband 306 in ಯಾರ ಮೇಲೂ ಬರಕ್ ಸಾಧ್ಯವೇ ಇಲ್ಲ.
she is, my lord, mentally, my lord.
No, 306 is different. 304B is different. 304B ಅಲ್ಲಿ mother-in-law, father-in-law better because demand of dowry. ಇಲ್ಲಿ the abatement to suicide, there will be nothing. ಇಲ್ಲೂ ಅಷ್ಟೇ, there is nothing. ಆರೋಪಿ 1ರಿಂದ 3 ಮಕ್ಕಳಾಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಅಂತಿದೆ ಅಷ್ಟೇ, ಅಷ್ಟು ಬಿಟ್ರೆ ಬೇರೆ ಏನಿಲ್ಲ. That cannot be ground for abatement, but husband is. I'll post it tomorrow. ಅದು ಆರ್ಡರ್ ರಿಲೀಸ್ ಮಾಡಿ ಇಲ್ಲ ನಾಳೆ ತಗೊಂತೀವಿ. ಇಂಟರ್ಮಾರ್ಟರ್ ಇದೆಯಾ? ಹಸ್ಬೆಂಡ್ಗೂ ಇದೆಯಾ?
Yes, my lord. Since there is no any, my lord.
No any what?
Death note, my lord, death note is also not there. And my lord.
Tomorrow, fresh matters. Don't worry. Husband will have to go. Others I will stay. Others will quash. Yes, next. ಜಾವೇದ್ ನೀವಿದ್ದೀರಾ?
On behalf of secondary.
ನೀವು ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ.
ಹಸ್ಬೆಂಡ್ ಮೇಲೆ ಏನಿದೆ?
There is no allegation.
No allegation.
One complaint also present. He has, my lord, he is ready.
No, sir. Abatement to suicide, no. Death note ಇರಬೇಕು ಅಂತಿಲ್ಲ. It's not. The other two I will quash. Mother-in-law and for following that judgment I will quash.
Lordship, I will next week.
Next week ಯಾಕೆ? ನಾಳೆ ಇರಲಿ ಬರಲಿ. ಇಲ್ಲ, ಡೇ ಆಫ್ ಟುಮಾರೋ ಹಾಕಿ ಮೇಡಮ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Please.
This is that black money wash.
ಇದೊಂದೇ ಉಳಿದು ಬಿಟ್ಟಿತ್ತು. ಛೇ, ಕುಡಿಯೋದು ಜಡ್ಮೆಂಟ್. ಇದನ್ನ ತರಿಸೋ ಅಷ್ಟೊತ್ತಿಗೆ ತುಂಬಾ ಕಷ್ಟ ಆಗೋಯ್ತು ಅವ್ರಿಗೆ, ಉಳಿದ್ಬಿಟ್ಟು.
ಲಿಸ್ಟ್ ಆಗಿತ್ತು
ಅಲ್ವಾ? ಅಷ್ಟೇ, ಕ್ಲೋಸ್ ಮಾಡೋಣ. ಎಸ್. ನೀವ್ ಯಾರು ಸರ್?
His name is Manoj. He's also called Lord Narsim Reddy. Then Basha also.
Basha? Amar Akbar Anthony.
Charge sheet
Allegations. That the loan, the complaint secure the loan amount. I was present in the house of accused number 1. He describes that it is Mr. Narsimha Reddy anta. In the end, he says Narsimha Reddy is Manoj, not one material to demonstrate.
You are Narsimha Reddy, Manoj or Basha?
Manoj. My name is Manoj. Allegations are made against one Mr. Narsimha Reddy.
You are not Narsimha Reddy.
Narsimha Reddy.
In alias?
Manoj, there is not one material in the charge sheet except the voluntary statement of a co-accused and one statement under 161.
ಅಲ್ಲ, ನಿಮ್ಗೆ ಬ್ಲಾಕ್ ಮನಿ ತೊಳಿತೀನಿ ಅಂತ ಯಾರು ಹೇಳಿದ್ದು?
ಅಲ್ಲ, ಇವರು everybody is associated. All of them. They introduce us, then they take the money, and he receives the money.
Who? Manoj or Narsimha Reddy or Basha?
It's called Narsim Reddy antane ide. Alias Manoj.
Is that not a matter of evidence, mister?
No, the complainant does
Anything else?
Even in the judgment that is submitted.
Yes, sir.
It was challenged.
Yes, sir.
The stage of investigation. Investigation is completed. Now challenging this charge sheet.
ಯಾವ್ದ್ರಲ್ಲಿ? ಯಾವ್ದ್ರಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ ಚಾರ್ಜ್ ಶೀಟ್ ನ?
In the judgment that is produced, your lordship's order.
ಆಯ್ತು, ಏನೀಗ?
Investigation, today we are challenging the.
ಯಾವ್ದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಸರ್?
ಇದರಲ್ಲಿ 22542 crime number.
ಯಾವ್ದು ಕೊಡಿ ಮೇಡಮ್.
The petition this is 104.
No CDRs, no tower location, ಏನು ಇಲ್ಲ ನನ್ನ ಕೇಸ್.
ತೊಂದ್ರೆ ಇಲ್ಲ.
In the end, they out of the.
No problem. Oh, this is that Roshan.
Yes.
Yes.
My name does not appear in.
Well, no worries.
Either of the complaints.
No problems, no problem. CC 567 of 2023. ಅದರಲ್ಲಿ ಬರೀ ಕ್ರೈಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದ?
ಹೌದು.
ಯಾಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿರ್ಲಿಲ್ವಾ? ಆಗಿರ್ಲಿಲ್ವಾ ಅವಾಗ? ಸ್ಟೇ ಇತ್ತು ಅಂತ.
ಸ್ಟೇ ಇತ್ತು.
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಇರ್ಲಿಲ್ವಾ?
ಇದರಲ್ಲಿ ಸ್ಟೇ ಇದೆ. That's why not we moved vacating stay.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ CC ಯಾಕೆ ಹಾಕಿದ್ರು? ಸ್ಟೇ ಇತ್ತ ಮುಂಚೆಯಿಂದನಾ?
A2 Lord filed the first.
Wait, I'll hear you separately.
A2 filed the petition first.
Wait, first we'll finish Ravi's matter.
Yes.
ಇದ್ರಲ್ಲಿ ಕ್ರೈಮ್ ಮಾತ್ರನಾ?
ಇಲ್ಲ, ಇದರಲ್ಲೂ ಚಾರ್ಜ್ ಇದೆ.
CC ಆಗಿದೆ. 567 of 23.
ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ಸೇಮ್? ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್?
Complainant.
Or complainant different, because idrallu 10 complainants.
Similar allegation.
There's a Roshan Saldana and others.
Look, complainant same ಇದೆ.
Who is the complainant here?
Shiv Kumar.
Same accused, yes. The criminal petition 10148 of 2025. The petitioners are accused 1 to 7. 1 to 7. Call in question the proceedings in CC so and so. The learned counsel appearing for the respondent complainant would submit that the entire fulcrum is considered by this court in criminal petition. Madam Ilide. So and so. This court, while noticing the facts, has held as follows from the reasons till the end. The cases before the court, which was decided as noted here and above, were at the stage of crime, but the subject petition charge sheet is also filed by the jurisdictional police. Those matters were stayed at the hands of this court, and therefore the charge sheet was not filed. The fulcrum of the complaint remains the same. The modus operandi of the accused remains the same. Therefore, the issue stands completely answered by what is observed by this court in the aforesaid judgment. Therefore, leaving open to the petitioner to avail of the remedy available in law, the petition stands disposed on the same terms.
Please.
Yes, ಈಗ ನಿಮ್ದಕ್ಕೆ ಬನ್ನಿ.
My case is that allegations are made against one Mr. Narasimha Reddy. In the end, they say Narasimha Reddy is Mr. Manoj. He gives 5 numbers, my lords, of Mr. Narasimha Reddy, the complainant. 5 number kottidare at page number 15 of my petition, my lords. Adral onrudu call detail CDRs illa, no tower location, let alone them establishing by any material that the meeting of minds was.
Your accused number?
2.
A2. He's collected money also, no?
Yes, yes, sir.
ಎಲ್ಲಿ ಇವ್ರ ಬಗ್ಗೆ ಏನಿದೆ?
ಇದೆ. Not my objections, if my lords would turn to. Filed in 10148.
Objections filed in the complainant petition.
ಹೌದು. 1014. ಇಲ್ಲೇ ತಾನೆ? At page 102. The 4th line.
What is that 102?
This is a statement of not CW4, Mahadev.
Who's a friend.
He's a friend of the complainant.
Friend of?
Complainant.
Here says.
All right.
Eyewitness as well. ಅಲ್ಲಿ
Hmm.
ಇದರಲ್ಲಿ ತೋರಿಸಿದರು ನಂತರ 10-15 ನಿಮಿಷದ ಮೇಲೆ ನರಸಿಂಹರೆಡ್ಡಿ A2 ಎಲಿಯಾಸ್ ಮನೋಜ್ ಇವರೇನೆ ಶಶಿಕುಮಾರ್ ಗಿರಿಧರ್ ಮತ್ತು ಇತರ 4 ಜನರು ಆ ರೂಮಿಗೆ ಬಂದರು. ನಮ್ಮನ್ನು ಪರಿಚಯಿಸಿಕೊಂಡು ನರಸಿಂಹರೆಡ್ಡಿ ನಮಗೆ ತಿಳಿಸಿದೇನೆಂದರೆ ನಮ್ಮದು 50 ಕೋಟಿ ವ್ಯವಹಾರ ಇದ್ದರೆ ಮಾತ್ರ ಪಾರ್ಟಿಗಳಿಗೆ ಸಾಲವನ್ನು ಹಣ ನೀಡುತ್ತೇವೆ. So he is directly involved there. Then multiple places, even bottom of that page, his name is referred. Everywhere not is referred.
File discharge, sir. Or else I will have, not a problem to write.
He was not present in the room, my lord.
That's a matter of evidence.
My lord, it's hearsay.
No,
the only
that's
other
a
material available
plea
is
of alibi is a matter of evidence. In this particular facts, I will not interfere at all. You are all cohorts in crime.
My lord, even
No, sir. Nothing. If you want to file discharge, you file, or else I'll record everything and close it. Yes. Yeah, what do you say? You want me to write?
My lord, this is
You want me
hearsay,
to
my
write
lord.
an order? I will write an
The
order.
complainant describes
No problem.
these incidents to this witness.
Yes. Anything else?
My lord, no recovery is made.
No
All
problem.
fake currencies were recovered from accused number 1.
No worries.
No CDRs, no tower location.
Ella take advantage of that, file discharge or
Even if I stand trial, my lords, there's
no, sir,
material against me.
not in the facts of these facts of this case.
My
How many people do you hoodwink, sir?
That's my very identity.
No, sir. Your identity is doubtful evidence.
Not once arrested.
No,
No
no,
TIP
nothing.
been conducted.
Anything else, sir?
In fact, not A1, I'm told, has murdered the prime witness in another case.
We'll see. Yes. Anything else?
That would be it.
Will file discharge or what?
File discharge.
Yes. E case interfere adra ಅಷ್ಟೇ. Discharge format. Yes, next.
Please.
I appear for the petitioner, my lords. Matter may kindly be passed over to 230, my lords.
Passed over to 230.
The senior is held up in trial court, my lords.
Oh, very good, madam.
So respondent number 2.
Yes, sir. ಏನು ಹೇಳಿ?
School bus incident, my lord. Children has 40% disability of the eye.
40% disability, correct.
Even after registering the FIR, Lord, after 51 days, this honorable court has granted.
Oh, this is that school,
School bus.
confetti. Yes.
Even the more than 50 days, the police have not taken any effort to seize the bus or any mazar.
ಈಗ ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲಿ?
Stay ಇದೆ.
Vacating stay.
Yes,
State
ma'am.
has been filed. Vacating stay.
Short pass over, my
Nothing.
lords.
230 sharp, I'll take this.
Yes, my lords. Yes, my lords.
If he is not coming, I'm going to dismiss it.
Please, my lord, please.
Yes. Pass over.
Counsel for petitioner, your lordship, extension of interim order.
ಅದಕ್ಕೆ ಬಂದಿದ್ಯಾ?
Opposite counsel appear ಆಗ್ತಾ ಇಲ್ಲ.
ಆಗ್ತಾ ಇಲ್ವಾ? ಕೊಡಿ. ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ ಮೇಡಮ್?
ಸರ್ವ್ ಆಗಿದೆ.
ಯಾವಾಗ?
ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ 1/6/2026.
ಸರ್ವ್ ಆಗಿರೋದು ಯಾವಾಗ ನೋಡಿ ಮೇಡಮ್? Where is the acknowledgement of service? Office objections are not complied. List the matter on 14th in the fresh matters list. In the event the matter is again listed for non-compliance of office objections, the petitions, the interim order subsisting would get automatically vacated. Yes. Subject to the said condition, interim order stands extended. '69.
Right, my lords,
My
last
lord, I'm
date,
filing an affidavit, my lord. Your lordships had asked me to place an affidavit on record for the
The counter. Yeah.
counter affidavit.
Lords, the affidavit which the complainant had filed, para 7, my lords may look it at once, para 7 of the affidavit filed by the complainant. Lords, that has not been answered in the affidavit which was filed by the petitioner now. She's saying that last night till 1 o'clock, he has convinced her that he'll.
My lord, I've now placed an
still-
affidavit on record to state that we deny all the allegations that are made by the complainant. And I've also placed on record, my lord, my wedding invitation that is slated next month. So insofar as
You have
the
placed.
petitioner is concerned, my lord, we're very clear that we're not interested in mediation.
No,
or
that's mediation, you're not interested, but what is this? You went out even after that?
My lord, my instructions are this, my lord. Now, even after serving a copy of this affidavit, she goes to my office, she comes to my house, creates a ruckus, threatens me and harasses me that she will commit suicide.
Well,
Now, because of all
that's
these
something,
reasons, if
well,
I may complete, if I may just complete and then.
Wait, Mugasli Tali.
And now all these allegations are there, my lord. If someone is coming to my house and harassing me and threatening that they will commit suicide, the natural human reaction to that is to try and console the other person. Despite me being very clear that we've moved our separate ways in the month of October itself last year. I'm now engaged to another person. And despite that, there are multiple threats and harassment of suicide and all that. So the reaction is to not with an intention to, my lord, promise to marry, but to just to console the other person that we've moved our separate ways, my lord. If that is taken in a way that I'm going ahead and trying to convince the person to marry, my lord, that, my lord, would not attract the rigor of 69 as my respectful.
Heard reserved.
Malas, I have one submission to make, Malas. She's saying she has some material to place on record. Malas, may have it on first.
No, don't get the client here. This is not trial court. Yes.
Malas, my lords may have it on first. I'll place on record the facts is this, my lords. Last night till 1 o'clock, he has convinced her that he'll marry her. My lords, lords may take any decision after me placing on record such material. I'll not come in the way. My lords, the fact is he has convinced her after the interim order and has.
My lord, in your lordship's
accused
jurisdiction of
certain
482, my respectful submission is, my lord, is
place
this.
on affidavit that I have not threatened
Your
him that
lordships
I'll
cannot
commit
conduct a
suicide.
mini trial here, my lord. Your lordships will have to look at this matter with respect to the present FIR and the complaint, and whether that attracts 69 or not is my respectful submission. Today, if they are going to place material, my lord, I also have. Your lordships also mentioned last time, my lord, let this court, my lord, let us not make it into a dirty and let's not clean dirty linen in public, my lord. Your lordships have also made this very clear. So insofar as the present complaint and
Well,
FIR
see,
is
whatever you want to place, you place. Judgment reserved. Yes.
grateful.
You place whatever you want to place. Yes. Next.
Petitioner is accused number 3. Alleged offense is section 12 of the.
There is some inconvenience today, so kindly have it in next week, my lords.
No, reserved.
Accused number 3.
Heard the learned counsel for the petitioner, G. Pawan Kumar. Yes. Interim order subsisting will continue to the next date of hearing. List after 2 weeks, objections if any by the next date. Yes.
Preparing for the petitioner, my lord. Petition under section, application was filed under 436A, my lord, for completing half of the maximum imprisonment. Now, in fact, my lord, I have finished nearly 2/3, my lord. 2/3 of the maximum imprisonment.
We'll post it for dictating orders on Monday.
Look, there was one office objections regarding maintainability was raised.
That was overruled, my lord.
Maintainability for what, madam?
Of this petition, my lords, 482.
Office objections.
482.
Why are you worried about the office objections? Yes. Prosecution complaint is filed. Yes.
My lords, I have placed on record the previous orders, my lords.
No problem. Yes.
My lord, I am producing the list of dates and events.
Monday. ಏನಿದು?
KPI. From day one, my lords, we've been maintaining that whatsoever amount, my lords, that is placed in so far as we are concerned, we're willing to deposit in the best interest, my lords, of the depositors.
Madly.
Let them deposit.
First deposit
Let
ಮಾಡ್ಬಿಡಿ.
them deposit.
I've been saying this from day one. The petitioner my lords is a resident of the USA. She's been living there.
No,
since
correct.
2000.
Actions should speak louder than words. So deposit.
38 lakhs.
ಯಾವಾಗ?
38
38 ಲಕ್ಷ. When?
Weeks time.
List the matter on 8th July. The learned counsel for the petitioner submits that to demonstrate the bona fides, the petitioner is ready and willing to deposit the entire amount that is claimed by the second respondent complainant, i.e. 38 lakhs. Yes.
Such time.
Let them deposit.
Deposit ಮಾಡ್ಬಿಡಿ, ಏನ್ ತೊಂದ್ರೆ?
We are in the US. There is a lookout notice, lookout circular.
ನೀವು ಮಾಡಿ.
Blue corner notice.
ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿ, I'll grant stay whole hog.
This given birth, 2 months, 40-day-old child.
Your lordship, let
Don't
them-
precipitate
no,
the matter.
Deposit, we can concede to the extent of, will not take action against them. Let them deposit. 1 week your lordship has given, let them deposit.
ಒಂದು ವಾರ ತಾನೆ.
If Jagdish is saying no.
Don't worry. Yes. If he's saying, no problem. Yes.
I'm so grateful.
Yes.
For the petitioner, my lord, on the last date, status of the trial court has been set. Charges are not yet framed before the trial court, my lord.
Charge frame ಆಗಿಲ್ವಾ? In the meantime, yes. ಗೊತ್ತಾ ಮೇಡಮ್? In the meantime ಅಂದ್ರೆ ಗೊತ್ತಾ? Yes, next.
For the petitioners, my lords. Petitioners are accused number 4 to 6, my lords. Petitioners are tenants.
List after 2 weeks, interim order subsidy.
There is no interim order.
For the respondent number 2.
ಇಲ್ವಾ ಮೇಡಮ್?
Interim order.
ಇದೆಯಾ?
ಇಲ್ಲ sir. But petitioners are accused 4 to 6, my lords. They are tenants running a school, my lords, in the premises, my lords. Since 2020, the school is being run in the premises by accused number 2 and 3, my lords. In 2024, madam. Accused 4 to 6, my lords, are the petitioners before my lords. My lords, since 2020, my lords, school is being run in the premises belonging to the complaint society. My lords, in 2020, by accused number 2 and 3, my lords, we are accused 4 to 6. In 2024, my lords, on 23/9/2024, we take up the school from them. My lords, we are running the school in the premises. Now, my lords, in view of the dispute between the members of the society, my lords, a complaint comes to be filed, saying that, my lord, this premises is taken by criminal trespass, and we have created documents, is what they say. But we are not named in the FIR. But now in the charge sheet, my lords, they make us an accused. Lords, miss, kindly see column number 17. There is no allegation against us. All that they say, my lords, we have taken over the school from the earlier management.
ನಿಮ್ ನೋಟ್ ಒಕಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ.
5, 6, 7 ಮೇಲೆ ಏನಿದೆ?
Accused number 1, without rhyme or reason, he had created documents and he has let out the premises, school premises to accused number 2 and 3. Subsequently, 2 and 3 sold the school to 3, 4, 5. And they are squatting and illegally paying the rents till let.
ನಿಮ್ಗೆ ರೆಂಟ್ ಬೇಕಾ ಏನ್ ಬೇಕು?
Rent ಬೇಡ, premises ಬೇಕು.
ಅಫಿಷಿಯಲ್ ಅಕೌಂಟ್ ಗೆ ನಾವು ರೆಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಇವ್ರ ಅಫಿಷಿಯಲ್ ಅಕೌಂಟ್?
ಹೌದು, ಸೇಮ್ ಅಕೌಂಟ್.
ನಮ್ಮ ಅಫಿಷಿಯಲ್
There is an
ಅಕೌಂಟ್.
RBI report also, my lords. Annexure
A1 has created his signature and he has been authorized to withdraw and everything is running all the way.
ನಿಮ್ಗೆ ರೆಂಟ್ ಯಾರಿಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
account of the respondent society, my lords.
ಕಂಪ್ಲೇನೆಂಟ್ ಸೊಸೈಟಿ.
Please.
ಬಟ್ ಯಾವಾಗ ಸೇಲ್ ಆಗಿದ್ದೆ ಯಾವಾಗ?
But school was taken over by us, my lords, on 23/9/2024.
23/9/24. Sale deed?
There is no sale, my lords. It is trust, my lords. Trust is given to us.
Taken over. Yes. ಆಮೇಲೆ accused number 1 ಮಾಡಿದ್ದೇನು?
But accused number 1, my lords, let out the premises as a representative of the society to the accused 2 to 3, my lords, in 2020 itself. They were running the school by taking appropriate permissions. In 24, we took over the school, my lords. We are paying the rents regularly to the account of the society.
Rent ಬರ್ತಾ ಇದೆಯಲ್ಲ ಈಗ?
ಬರ್ತಾ ಇಲ್ಲ. Accused number 1 has manipulated the documents, accounts, everything.
No problem. We'll direct it to be
ಯಾವ
transferred to
account
you.
ಕೊಡ್ತಾರೆ
But
ಡೆಪಾಸಿಟ್?
they are squatting over the my property, society's property illegally, my lord, without any rhyme or reason.
2020.
ಅಲ್ಲ, who has entered, which agreement, sir, has let you stay there?
2020.
2020.
Who has entered into that agreement?
By accused 1 and accused 2 to 3, my lords. 2 and 3.
Accused 1, 2 and 3. Where the office, where the office bearers of the trust?
2 and 3 were the trustees, my lords.
Huh.
Accused one was the representative of the complaint society.
Hmm.
He let out the premises to.
Oh, he has fabricated everything or
He might
forged
have done,
everything.
but we are running a school bona fide, we are paying the rents. In fact, my lords, what they say that amount is not deposited to their account. My lords, may kindly see annexure E page 5.
ಬೇರೆ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಏನು suit ಹಾಕಿಲ್ಲ ಅವ್ರ ಮೇಲೆ.
ಮತ್ತೆ ಹೆಂಗೆ ಇದು?
In fact,
they are squatting over my property
Fighting over the
without
property
obtaining
ಅಂದ್ರೆ file a civil suit, what's the problem?
and without obtaining permission from the education board, they have shifted the abruptly to the my premises.
ಅದು complaint to the education department.
license charge sheet, it's a part of the charge sheet. License are part of the charge sheet.
License renewed.
Renewed by the appropriate authority.
Renewed in the sense in that earlier premises, not to my premises.
ಆಯ್ತು, now don't pay to accused number 1, pay it to the complainant society.
Whatever account, my lord.
Till we decide this matter.
Please, let them give the account details, my lords, I'll deposit to the same account.
The petitioner, the accused number 1 is said to be the representative of the complainant earlier. Accused number 2 and 3 are the trustees, former trustees,
2 and 3 former trustees.
Former trustees
Not of accused number 1 society, my lord. It's different, entirely different.
of a different society. The accused number 2 and 3 have accused number 2 and 3 have let out the said premises to the hands of accused number 4, 5 and 6, who are now running an educational institution. The respondent complainant would submit that the accused number 1 has manipulated or forged the documents pursuant to which the petitioners are squatting over the property. The learned counsel for the petitioner submits that they are running an educational institution there and would deposit the rent that to be paid to accused number 1 to the complainant society if all details of the society is furnished to the petitioners. Therefore, till a decision would be rendered in the case at hand, the petitioner shall deposit the rent to the complainant society to the account that the complainant society would furnish. This would, however, remain subject to the result of the present petitions. List the matter on 28th July.
Let there be an interim order, my lords. Now,
Interim order subsisting.
there's no interim order.
No interim order. In the light of the said direction, there shall be an interim order of further proceedings only insofar as the present petitioners and would not be taken, the interim order cannot be taken advantage of by accused number 1, 2 and 3. Proceedings against them would continue.
One fact I want to bring to my lord's notice, my lords. After the charge sheet is filed and summons is issued, my lords, on 17/6 and 19/6, my lord, the respondent police issues notice calling upon us for further for investigation, not even for further investigation.
Further investigation.
Further karitala. They say crime ide, you come for investigation, he is threatening us to arrest.
It will for extend madidinala.
Please, I wanted to bring that fact to the notice.
That's okay. You can't settle scores now. Yes.
Grateful.
Next.
Petition under offense under 420-409 IPC, my lord. My lord, their allegation is that, my lord, I have forged the document belongs to BDA and acquired the land. My lordship, their own complaint admits that my grandfather had purchased the property in 1958. Lordship, may kindly see the complaint at page number 15, my lord. ಕೊತ್ತನೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಇನ್ ಸೋ ದಲ್ಲಿ ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡು ಭೂ ಮಾಲೀಕರು ಭೂ ಪರಿಹಾರ ಹಣವನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪಡೆದುಕೊಂಡು.
Did you serve on Murugesh Charati?
Yes, we have served.
Where is it? Where is the acknowledgement?
Yes, acknowledgement. We have served, my lord.
Where?
Acknowledgement.
Print ಮಾಡಿಲ್ವಾ ಹೆಸರು ಅವ್ರದ್ದು? ಯಾರು ಹನುಮಂತರಾಯ served ಅದು?
We have served.
The registry to print the name of Murugesh Charati.
My lord, in connected matter, for same cause of action, 2 cases they registered in connected matter, your lordship, these 2.
The registry to print the name of Murugesh Charati as appearing for the respondent BDA. Tag this petition along with so and so. List them both in the fresh matters list on 15th July.
Much.
Next.
Take the appeal, my lords, on behalf of respondent number 2, my lord.
ಯಾವ್ದಿದು?
Lords, this is the matter where your lordships may recollect that blanket bail is granted as an anticipatory bail for offences punishable under section 4, 8, 10 and 12. Vachanananda. Lords, now I am told that in respect of this complaint, they have already filed the charge sheet.
Charge sheet is also filed, my lords. Let them serve me a copy, my lords, of the petition. I'll file my objections also, my lord.
Charge sheet ಹಾಕಿದ್ಮೇಲೆ regular bail ತಗೊಳ್ಳಿ ಹಂಗಾರೆ.
I have no.
I will cancel this, I will set aside this order, this bail could not have been granted. Will reserve liberty to take
Lordship's may
regular bail.
reserve, but no difficulty.
I have this matter on Monday, my lords. I'll also file my wakalat, my lords. Let them show me a copy, my lords, of the petition. Lordship, I have this matter on Monday, my lords.
He has the benefit of the order which he has secured.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿರೋದು ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಏನು ಹೋಗಲ್ಲ, ಬಟ್ ದಿ ಮ್ಯಾನರ್ ಇನ್ ವಿಚ್ ಇಟ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್, ಐ ವಿಲ್ ಸೆಟ್ ಇಟ್ ಅಸೈಡ್, ಐ ವಿಲ್ ರಿಸರ್ವ್ ಲಿಬರ್ಟಿ ಟು ಸೆಕ್ಯೂರ್
I pass the same, Lordship, I have this on matter on
ಸೆಕ್ಯೂರ್
Monday, my lords.
ಬೇಲ್. ಐ ವಿಲ್ ಸಿನ್ಸ್ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಇರೋದ್ರಿಂದ ಒಂದ್ 2 ವಾರ ನಾಟ್ ಟು ಅರೆಸ್ಟ್.
State also is challenged because the
They
grant
have
of
filed an
anticipatory
application, my
bail.
lords, before the
That's
same
also
court for cancellation of bail, my lords.
That's also.
This has to be cancelled.
Lords, that court actually posted the matter for orders and then again adjourned the matter to 30th for passing the orders.
No,
For
whatever.
passing the orders, the matter is
This
getting adjourned.
anticipatory bail cannot
Has to-
remain.
Yes.
That is, there can be no two thoughts about it.
I have this matter on Monday, my lords. I'll file my wakalat.
All right, you file your wakalat, but this, such anticipatory bails cannot be granted at all.
Lords, I'll make
And
my
it is what,
submissions.
sodomy?
Yes, my lords.
Yes, yes.
It's a case of sodomy, my lords.
The place to.
ಬೇಡ ಬಿಡಿ, ವಾಷಿಂಗ್ ಕೇಳಿದಾಗ ನೋಡ್ಕೊಡ. ಬೇಲ್ ಅಂತೂ ಕೊಡಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. ಅದು ಈ ತರ ಬೇಲ್.
Para 14, my lords, the manner in which the trial court
I
considers
already, I've already passed an order on
the
that,
lordships have
yes.
already observed it. my lords. It can
But
be disturbed.
the only thing is, since he has the benefit of anticipatory bail,
Have no
right or wrong,
difficulty. Lordships may
let him
extend
seek
it for a
regular
week or
bail.
10 days, my lords, within which time let him go and
10
seek
or
for.
15 days I will grant.
Very well.
Let him seek.
Lords, my lords, I have it on Monday, my lords. I'll file my wakalat. I'll have, my lords, let them show me a copy. I'll at least, my lords,
See,
go through the
I have
petition copy.
I have a counter offer, my lords. If he wants it on Monday, then your lordships may curtail that period to 1 week. Option
see.
is him. So now it's a take it or leave it offer.
Lords,
Allah, now that the charge
Just
sheet is
on the
also,
lights.
charge sheet is also filed.
Yes.
Regular bail ತಗೊಳ್ಳಿ. ಏನ್ ಮಾಡ್ತೀರಾ ಮಂಡೇ ಅವರಿಗೆ?
Allah, my lords, I'll at least go through the papers, my lord.
No papers are produced other than his bail order.
Criminal petition ಹಾಕಿದ್ದಾರೆ. I'll go through the papers, my lords. I'll
ಆಯ್ತು,
come on record at least, my lord. Lordship,
No
I have this.
problem. ಆಯ್ತು, ನಾಳೆಗೆ ಬನ್ನಿ. Yes. ಸಾಕು, overnight to
I
read.
just also wanted to bring to your lordship's notice, after this petition was filed, they have threatened the complainant, who is the petitioner before lordships. Complainant has again approached the police have registered a
So
second
on
FIR.
on merits, my lords, I'll also make submissions because, my lords, prior to filing this criminal bail petition, my lords, they hold a press meet, my lords, wherein they have made a press meet, they have made a statement, my lord, that they are going to file a complaint, my lord, against the respondent number 2. That was the apprehension, my lords, for the petition.
ಅದೇ ಕರೆಕ್ಟ್, 5 days ಮುಂಚೆ ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಾ?
My lords, that was the apprehension, my
ಅದು
lords.
the kind of bail that is granted, very impossible to
I'll
fathom.
place those materials on record. There was a
I'll-
press meet, my lords, which
I'll
was,
take,
my
I'll
lords,
take it tomorrow or day after, no problem.
Lordships. Monday,
Monday
my
ಬೇಡ.
lords. Those documents, my lords, I'll also.
ಪರವಾಗಿಲ್ಲ, you can get those documents.
Thursday, lordship.
Thursday, yes. Thursday, fresh matters.
Grateful.
Yes.
Copy of the petition, my lords.
Right now.
But you should be aware of the senior counsel's offer. Pruning of the date. Yes.
Grateful.
But ಈ ತರ ಬೇಲ್ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ರೆ ಅದು ಇದ್ರಲ್ಲಿ
ಚೆನ್ನಾಗಿದೆ ಇದೊಂಥರ ಬೇಲ್ ಆರ್ಡರ್. ಯಾರು ಎಲ್ಲಿ ಏನೇ ಕೇಸ್
you
ಹಾಕಿದ್ರು
have not left the boy.
Voice. It is, my lords.
Boys.
It is, my lords, it is at the instance of the trustees, my lord, of the mud. My lord, there was a dispute between the trustees and the Swamiji, my lords. They, my lord, expelled, my lord, the Swamiji out of the mud. My lords, and they hold a press meet, my lords, that they would file such a complaint, my lord, against the Swamiji.
The minor girls are not safe and minor boys are also not
But
safe.
this is a false complaint, my lord. At the face of it, my lord, I'll produce certain documents, my lord. The lordship may, my lords, peruse those documents, my lord. My lords, in fact, they have filed, my lords, an application. It was posted for orders, my lord. That is when, my lord, this criminal petition is filed, my lords.
ಆಯ್ತು. That's what I will ask him to take regular bail, whatever.
That I think will be the
We'll
fair
grant him some time because the benefit of the
Understand.
anticipatory bail is there. ಅಷ್ಟೇ.
Quay this matter.
Only this, ಇನ್ಯಾವುದಿದೆ?
There are 2 FIRs.
ಅದು ಬೇರೆ, ಅದು ಮಾಡ್ಕೊಳ್ಳಿ.
Quay this FIR, lordships.
Only
may
this
protect.
matter.
Very well, my lords.
How can I enter into, so I will be doing the same thing that the court has done.
So grateful. my lords.
Yes, sir.
That's true.
Thursday, fresh matters. I heard the learned senior counsel, Priya Ravishankar, counsel, and the learned SPP for the state. Yes, please. Santosh, ಏನಿದು?
13(1)R and S, my lord. After 4.5 months of the alleged incident, my lord, in the home, my lord, house of the accused ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಇರ್ಲಿ ಬಿಡಿ ಏನೀಗ? So what?
By no stretch of imagination, my lord,
How are you going to stretch imagination?
No,
sir?
they are saying it is in the house of the accused that the complainant have abused the complainant. And the house of the, I'm sorry, one Padma tenant opposite to the house of the page 20.
House of the complainant, page?
Page 20, ma'am. Opposite to the house of the complainant, they were residing, one namely Padma was a tenant there. The friend of Padma used to visit their house.
Yes, madam. Heard the learned counsel Santosh Nagrale appearing for the petitioner. The petitioners are accused, husband and wife.
They are the
The petitioners are accused 1 and 2. The second respondent is the complainant. The allegation is the one that has become punishable under section 31R and S of the Atrocities Act. A perusal at the complaint would indicate that the alleged abuses, taking the name of the caste of the complainant, are hurled within the four corners of a house, which can neither be a public place nor a place of public view, as obtaining under section 31R and S of the said Act. Permitting further proceedings would run foul of the judgment of the apex court in the case of
I mentioned it in the ground. In Keshav Mehta versus State of
That is old, sir. Gunjan versus so and so, 2026 SSC online SC page 834. Yes. Therefore, there shall be an interim order of stay of further proceedings, further investigation.
Please.
The petitioner till the next date of hearing. Yes, next.
Brief lawless.
For the petitioner, my lords. The offence is 196 clause 1A. The last hearing date, I was directed to file an affidavit.
Yes, sir.
I may be.
Mangalore. ನೋಡಿ ಸೇಮ್ ನೆನ್ನೆ ಅಫಿಡವಿಟ್ ತಗೊಂಡಲ್ಲ ಅದೇ ತರ ಇದೆಲ್ಲ ಯಾಕೆಂದ್ರೆ ಬ್ರೀಚ್ ಆಫ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಇಸ್ ಅ ಬಿಗ್ಗರ್ ಪೇಜ್ 10 ಅಲ್ಲಿ ಇದೆ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಇಟ್ಸ್ ಪ್ರೊವೊಕೇಶನ್ ಬಟ್ ಆದ್ರೂ ಹಾಕ್ಲೇ
remove all this social media
the petitioner is before the court seeking the following prayer. On an incident, on a post on platform X, within bracket Twitter, the petitioner is said to have posted certain derogatory statements that became the fulcrum of the crime in crime number 78 of 2025 for offences punishable under section 196(1)(a) and 353(2) of the IPC. The learned counsel for the petitioner undertook that such posts would not be made by the petitioner again and has filed an affidavit of undertaking before this court. The affidavit reads as follows. In the light of the affidavit, I deem it appropriate to obliterate the crime with a direction to the petitioner that all the posts that are now in her account which would depict such action shall be deleted. The learned counsel undertakes such deletion. For the aforesaid reasons, allowed quashed. In the light of the observations. It is needless to observe, that any breach of the undertaking and the affidavit that is made before this court will be viewed seriously.
My lords, in this. My lords, in this matter for petitioner, my lords, on the last date of hearing, my lords, I had undertaken to pay a sum of rupees 1,65,000 to the complainant, my lords.
ಹೌದು ವಾಪಸ್ ಅಷ್ಟು ಕೊಡಬೇಕಾಗಿದೆ.
I have arranged, my lords.
ಯಾವಾಗ?
I am ready with the money, my lords.
ಎಲ್ಲಿದೆ?
She has brought the cash, my lords. But the
ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
I don't have his account details, my lords.
ಆಯ್ತು ನೋಟಿಸ್ ಮಾಡಿಲ್ವಲ್ಲ?
Notice ಆಗಿದೆ, my lords, notice.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ? Serial number 18 ಆಯ್ತು.
16, my lord.
The respondent complainant, medical officer ಅಂತಿದೆ.
Yes, my lord.
The learned SPP ಅವರೇ.
In his individual capacity, the complaint is filed, my lord.
Even working as medical officer ಅಂತ ಇದೆ. District surgeon, but individual transaction.
Individual, my lord.
Serve ಮಾಡಕ್ಕೆ. The respondent complainant be served through the state by in the next 1 week. List the matter on 8th July. The complainant is present and submits that the amount that is to be returned is ready to be returned. If the account details of the complainant is available, it would be returned. Therefore, on that statement, further proceedings shall remain stayed. In that light, the interim protection granted shall continue till the next date of hearing.
Great, my lord.
Matter under the NDPS Act, my lord. Matter under the NDPS Act, it's 20.
NDPS?
Yes, my lord. So it's a covered matter, my lord.
Why?
Lords, 1 kg, 166 grams is seized, my lord, from the petitioner.
Ganja?
Yes, my lord. Lord, the issue that arises or the snag that is there in the prosecution's case is, number one, there is no quantitative, qualitative analysis in the entire charge sheet, my lord. Number one. Number two, my lords, when the weighment is conducted of this material which is seized, my lords, Lord, it is weighed along with a plastic cover.
Ade nodi. That is the learned HCGP is directed to accept notice for the respondent. Notice ಆಗಿದೆಯಾ?
Lord, notice is issued, the same directions which were issued 2 days, 2 days.
So it's list the matter, SPP ಅವರೇ ನೋಡಿ ಅದು. List the matter on 7th July, interim order subsisting will continue to 7th July, the fresh matters list.
Great.
Interim order subsisting will continue to the next date of hearing. Yes, next.
The anticipatory bail has been granted, my lord. That is called in question, my lord. It is read with 482. my lord.
ಅದೇ non-application of
Non-application of mind, my lord.
ಹೊಸ jurisprudence jurisdiction create
But
ಮಾಡಲ್ಲ.
what happened is, my lord, the orders are cyclo-styled orders. my lord.
Challenge it, challenge the bail.
No, that
Challenge
is
the
what we
bail
have
so
done, my
granted not on the ground of non-application of mind.
lord. No, my lord, we have challenged.
482
on
ಅಲ್ಲೇ.
that- my lord, we have challenged on that specific ground, my lord. There are judgments also which, my lord, this honorable court coordinate bench, my lord, exercised jurisdiction.
ಕೊಡಿ sir, under 482.
Not only 482,
Under
it is
482.
read with 439 clause 2. Therefore, it is maintainable, my lord. There is
Namaste.
no impediment. My lord, the 439 clause, my lord, 2.
ಹಾಕಿ 439 ಹಾಕಿ.
Normally, my lord, it will be
Sir, you
exercised.
filed the 439(2) petition for cancellation of bail before the concerned
Not
court.
cancellation, I am challenging the order. I am not seeking violation of any condition or, my lord,
ಆಯ್ತು, ಅದರ ರಿಸಲ್ಟ್ ಏನು?
result.
If I set it aside, ಏನ್ ರಿಸಲ್ಟ್ ಅದರದ್ದು?
It has to be reconsidered, my lord, in accordance with law. Now,
ಅಲ್ಲ,
the issue is
ಅದರ ರಿಸಲ್ಟ್ ಏನು?
cancellation.
ಅಲ್ಲ, cancellation ತಾನೆ.
But, my lord, the challenge is different.
ಯಾಕೆ
Cancellation, my lord.
ಬೇಲ್ ಕೋರ್ಟ್ ಹೋಗಕ್ಕೇನಂತ?
Court also, my lord.
ಸಾಲಿಡ್ ಬೇಲ್ ಕೋರ್ಟ್ ಹೋಗಕ್ಕೇನಂತ?
Bail court, no, it is not so, my lord, that since it is the order itself is, my lord, under challenge. No, there is no remedy, my lord. 439
No
clause 2
remedy.
is only cancellation.
ನೀವ್ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬಿಟ್ರೆ ಅದ್ ನೋ ರೆಮಿಡಿನಾ?
Cancellation, the parameters.
Just because of your ingenuity of filing a petition, will the thing become remediless?
The Supreme Court also said, my lord, since, my lord, it is a.
No,
the
this
nature
will
of
be
appeal.
creating another jurisdiction.
No,
No,
my
I
lord,
don't.
it is, this coordinate benches have, my lord, already
ಕೊಡಿ,
entertained this.
482 ಇದ್ರೆ
Yes,
ಕೊಟ್ಬಿಡಿ
yes,
sir.
absolutely.
ಕೊಡಿ sir.
ಕೊಡಿ.
Non-application of mind in a bail order will result in 482 petition, you just give me.
Yes, my lord.
petition was.
ಕೊಡಿ sir.
Yes.
Yes.
Petition.
Citations ಕೊಡಿ. ಎಲ್ಲಿದೆ? But now, my lord, along with the memo.
ಹಾ, ಏನಿದು?
Lord, your lordship may.
First one ಏನು?
First one, my lord.
That is application filed for cancellation of bail.
Yes, my lord. Second one. Page 11. Criminal petition number 6696 of 2020. Filed under section 482. Bail order has been set aside. In other compilation also, there are two judgments.
One minute, sir.
Yes.
This is set aside on merits, not on non-application of mind.
My lord, when it is
Anything?
set aside on merits,
No,
my lord,
no,
it will be on, my lord, the better footing. That's what my respectful submission.
Nothing.
Lord, the other judgments also, my lord, we have placed on record. Last time, my lord.
Non-application of mind ಯಾವ್ದು ಕೊಡಿ sir.
If, my lord, it is set aside on merits, my lord,
No,
non-application of mind and my lord,
No,
perverse
that is,
orders.
that, no, that is
My
the
lord,
ground.
cyclostyled,
ಆಮೇಲೆ
my lord, all these.
cyclostyled or whatever it is. ಆಮೇಲೆ ಅದನ್ನೇ ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿ cyclostyled orders and cancellation of bail ಕೇಳಿ. ಅದು ಕೇಳಕ್ಕೇನಂತ? Why are you fighting shy of a petition being filed before the court?
My lord, this court has got, my lord.
You forget about it. Power ಬಗ್ಗೆ ನಾ ಮಾತಾಡ್ತಾ ಇಲ್ಲ. It is discretionary. I will not exercise my discretion in this. Period.
My lord, only thing is, my lord, since it is a challenge, my lord, it is maintainable. We have filed here, my lord, that's.
Yeah,
it was filed long back,
sir,
my lord, it was pending for quite some time and we could not get it listed.
One minute. There are two things. I never said anything is not maintainable. Everything is maintainable.
Yes, my lord.
It is not
I'm grateful
entertainable.
for that.
It is not entertainable. There are two factors. One is maintainability, the other is entertainability. It is not entertainable. Because entertainability touches upon the discretion, I will not exercise my discretion. Bail order reason illa anta ನಾವು 482 ಕ್ವಾಶ್ ಮಾಡ್ತಾ ಕೂತ್ಕೊಂಡ್ರೆ ಅಷ್ಟೇ.
Cyclostyled orders are passed by this court, this trial court, my lord, in all matters. Kindly see the other orders passed. Cut and paste, my lord. With great respect, my lord, I am making this submission. Because non-application of mine totally. Matte cut and paste. Only two grounds, my lord, I am challenging. It's a financial embezzlement, my lord. The amount belonging to the tobacco board
ಅಲ್ಲ,
was
same
supposed to be
same
given to the
ಒಂದು
farmers.
ನಿಮಿಷ. The bail is granted to co-accused, is it?
ಇಲ್ಲ
ಮತ್ತೆ
ಬೇರೆ ಬೇರೆ ಕೇಸಲ್ಲಿ ಎಲ್ಲದರಲ್ಲೂ ಒಂದೇ ತರದ cyclostyled order.
ಬೇರೆ ಕೇಸ್ ಅಲ್ಲ.
Yes, yes, different crime numbers, my lord.
ಏನ್ cyclostyle?
Different crime numbers, my lord.
It's but there is no necessity to recover any property allegations. ಎಲ್ಲ ಅವ್ರದೇನಾ ಬೇರೆಯವ್ರದಾ?
ಅವ್ರದೇ ಒಂದೇ ಕೋರ್ಟ್ದು ಇಷ್ಟೇ ಇರುತ್ತೆ, ಎರಡೆರಡೇ ಲೈನ್ ಇರುತ್ತೆ, ಎಲ್ಲ ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಸೇಮ್ ಇದೆ. ಇನ್ನೂ ತೆಗೆದ್ರೆ ಇನ್ನೂ ಸಿಗುತ್ತೆ. ಲಾರ್ಡ್ಶಿಪ್ ಫೀಲ್ಸ್, my lord, I will place it that also on record. I can understand, my lord, I also appear, my lord, in number of cases, but my lord, something.
ಇಲ್ಲ ಬೇರೆ ಕ್ರೈಮ್ ಅಥವಾ ಸೇಮ್ ಒಫೆನ್ಸ್?
ಬೇರೆ ಕ್ರೈಮ್ ಅಲ್ಲಿ ಸೇಮ್ ಪ್ರಿಸೈಡಿಂಗ್ ಆಫೀಸರ್ ಗ್ರಾಂಟೆಡ್ ಬೇಲ್ only observing this similar paragraphs.
ಏನು ಆತರ ಏನಿಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲ, there are different orders, my lord, all similar. Same paragraphs also in two crime.
Because you want to challenge, you challenge it.
That can, even assuming that this is a case, my lord, that can be challenged before the bail court.
Not in for it. I'll reserve liberty, you challenge it.
No, lordship, we will file memo, my lord, your lordship may permit me to convert, because we have invoked 439 clause 2 also. Only for statistical purpose, number may be given. Lordship may dispose of this, my lord, renumber may be given. Because otherwise it has, my lord.
Because it's not that
to go,
I don't find blatant non-application of mind here. You come to page 12. 12, 13, what facts may have been shortly narrated, but doesn't mean that it is erroneous.
There is no narration of facts in any of these judgments, my lord. What?
Yeah, okay. On the other hand, ನೋಡಿ ಇದು page 12 ಬನ್ನಿ. Yes, SPP ಅವರೇ ನೋಡಿ ಇದು. ಅಲ್ಲ, ಬೇಲ್ಗೆ ಕಥೆ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ ಪೂರ್ತಿ.
I can understand, my lord.
ಮತ್ತೆ
But kindly see the
ಬೇಲಲ್ಲಿ
I request you lordship to come to page 16.
ನಾವೇ ಬರೆಯಕ್ ಹೋದ್ರೆ ಆಮೇಲೆ ಇವ್ರು ಮಿನಿ ಟ್ರಯಲ್ ಕಂಡಕ್ಟ್ ಮಾಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ.
Page 16 reasoning ಒಂದ್ಸರಿ ನೋಡ್ಬಿಟ್ರೆ
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿ.
Then, my lord, the difficulty is this, my lord. This was filed long back, my lord, and now matter is pending for quite some time. Now, if again, my lord, notice has to go, that will take, my lord, some more time. And, my lord, the investigation is completely halted, my lord.
Halted why?
They say, my lord, ED has seized the documents and they can't investigate.
That is not the concern of this court.
That may not be, but, my lord, again, ultimately, this is a money belongs
If you want
to
cancellation of bail, file 436, 439 2A.
My lord, this was filed on 8th July 2025. We moved it, my lord, it was not listed. They took time, my lord, a couple of occasions. Now, if it is, my lord, again, refiled.
In fact, your lordship in the day one made it very clear. And they.
ಅವತ್ತಿಂದಾನೇ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ನಾನು ಬಂದಾಗಿದ್ದಾನೆ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. This new jurisprudence will not create.
No, we will convert, my lord. That's what, my lord, your lordship.
You convert, not a problem.
Since we have invoked, nothing needs to be changed, my lord.
Learned senior counsel Shri Arun Shyam after arguing the matter at length, would seek leave of this court to convert the subject petition to a memo acute. subject petition to one of cancellation of bail as obtaining under ಏನದು 482
439 clause.
ಅದು ಹಳೇದಾಯ್ತು ಈಗ 482 482 yes of the BNSS permission so sought is granted for the sake of statistics. Yes.
Maybe posted before.
ಮೂವ್ ಮಾಡಿ ಅಲ್ಲಿ. Yes. ವಿಶ್ವೇಶ್ ಶೆಟ್ಟರ್ ಸಾಹೇಬ್ ಬಂದಲ್ವಾ? ಮೂವ್ ಮಾಡಿ. Yes.
ಅವಾಗ್ಲೂ ಅಷ್ಟೇ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ, ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ ಅಂತ.
ಅವ್ರ ಮುಂದೇನೋ ಅದ?
ಅವಾಗಲ್ಲ, ಹಿಂದೆ ಇದ್ದ.
ಹಿಂದೆ ಹೌದು. ಈಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ. ಇವಾಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ. Yes.
It's not possible. What
ಅದೇ
transfer?
ಇದು
Clean marking.
19 accounts.
Yes, sir. Your Lordship may see the account, current account has been opened by the petitioner. I'll place the KYC and other documents. Nothing in this bank statements. And week later, money from different scams came into his account.
Deposited into this account.
Yes, sir. In fact, not the type of scams which also have been, the type of scams account which he receives.
ಕೊಡಿ ಮೇಡಮ್.
It appears, my lord, that this account has been, is a 20-year-old boy opens a current account from an address which was not exist in 2014.
Oh, part-time job. Investment, cryptocurrency fraud. ಮತ್ತೆ ಮಿಕ್ಕಿದ ಅಕೌಂಟ್ ಯಾಕೆ ಡಿಮಾರ್ಕ್ ಮಾಡಿದ್ದೀರಾ?
Nobody has raised an objection, so it has happened. And in fact, my lord, we opens a bank account by producing Aadhaar card which was originated in 2014. Aadhaar address in Aadhaar card in 2014, my lord. The rent agreement has been produced. The rent agreement is.
Where is your Aadhaar card, sir?
My lord, page number.
And the lordship is a bank. I think the lordship may have to take cognizance of the manner in which bank account has been opened.
45.
This Aadhaar card is issued in 2016. The
2016.
Yes, ma'am. And the
You were 12 years old.
20.
Aadhaar card ಕೊಟ್ಟಾಗ
Yes, ma'am.
ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಹೆಂಗ್ ಓಪನ್ ಮಾಡಿದ್ರಿ?
At that time, it's not open.
When was bank account?
Bank account is open in 2025, but the rent agreement, my lord, is of 2025, and he was not even staying in that address.
At present, he was in this address only. Aadhaar card address only.
ಇದಕ್ಕೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ತಗೊಂಬನ್ನಿ.
I didn't.
ನಿಮಗೆ ಕೊಡಲ್ಲ ಸರ್. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
My lord, when I filed in trial court, I filed ಮಾಡಿದಾಗ I didn't get a notice. Now they issued for submitting of documents, my lord.
No problem. We'll dismiss this. All right. The petitioner is before the court calling in question an order dated 13/2/2026 in crime number 209 of 2025 passed by the concerned court rejecting the application filed by the petitioner under section 4, an application filed under section 497 read with 503 of the BNSS. The consequential direction of defreezement of the account of the petitioner is also sought. The petitioner, the petitioner, a boy of 20 years, is now before the court seeking a direction to defreeze the account that he holds in Central Bank of India, a current account. It is his case that about 19 accounts held by the petitioner, which were the subject matter of marking of lien, have all been demarked by the acts of the respective banks itself. It is only this account that has stood lien marked. The facts that led to the marking of the lien of the account of the petitioner is that a transaction happens on 3/9/2025 in Another Binashena. In cryptocurrency platform. Based upon the said transaction, immediately a crime comes to be registered by the cyber crime wing on in crime number 209 of 2025. Pursuant to the registration of the crime, the account of the petitioner, wherever it was directed to be frozen. The acts of such freezement falls upon the account of the petitioner in the Central Bank of India. The petitioner then files an application under section 497 and 503 of the BNSS seeking defreezement of the account. The concerned court rejects the said application on the said grounds, page 2021. The learned SPP has placed on record the papers of investigation conducted in crime number 209 of 2025 and would highlight the fact that the petitioner, a 20-year-old boy, has opened the current account in not one but 19 accounts. And
My lord, one account, 19 cases. 19 transactions.
in one account, has opened the subject account and has done about 19 transactions. All the 19 transactions are a suspect as they emanate of certain investment fraud or cryptocurrency fraud from various places of the nation. Therefore, he would submit that the petitioner has indulged himself in a part-time job fraud or an investment fraud or an OTP scam or cryptocurrency scam. The amounts that are received to the account of the petitioner have all emanated from the persons who are involved in the said frauds. Therefore, it is a case where it's a clear case of cyber crime perpetrated at the hands of the petitioner, albeit prima facie. Therefore, there is no warrant of directing the defreezement of the account of the petitioner. The order of the concerned court does not warrant any interference. The petition.
Your Lordship, this is the bank opening form. Everything is empty.
Adak munche does not warrant any bank opening form.
Actually, the KYC have produced all the documents. Except writing his mobile number and his name.
Page.
I put a flag below. I show it.
ಅಲ್ಲ ಇದು ಕಂಪ್ಲೇಂಟ್ ಆಯ್ತು ಕೊಡಿ ಎಲ್ಲಿದೆ last para munche. What shocks the conscience of the court is perusal at the application of the petitioner for opening a current account. Every place that has to be filled is left blank. For illustration, the date of birth of the petitioner is depicted as Bangalore. And every other thing is said as not applicable, except the mobile number and the name of the petitioner. Nothing else is found in the current account opening form. Central Bank of India is a bank which it's a bank by the government, which is a state under Article 12. The bank involved in banking transactions of opening of account cannot display such carelessness in opening of an account, current account in particular, without looking into the business of the account holder. The petitioner, as observed herein above, is 20 years old, opens a current account in a form that has nothing in it except the mobile number, the name of the father and mother.
Your father name is also not there.
Huh?
Father name is also not.
ಇಲ್ಲಿ ಹಿಂದೆ ಇದೆ. ಮದರ್ ಇದೆ, ಫಾದರ್ ಇಲ್ಲ. ಇಲ್ವೇನೋ ಯಾರಿಗ್ ಗೊತ್ತು. Except the name of the mother. Therefore, the banks are strictly warned. Banks should be strictly admonished in permitting opening of accounts of this nature, particularly the current accounts of this nature. We'll see in a case, correct cases.
In fact, at 4 o'clock, your lordship has one matter.
Do not.
That matter, I think.
Yes.
Some further developments in that.
Petition stands dismissed. Next. For the aforesaid reasons, petition would stand dismissed. Next.
I am for the respondent number 2. I am for the petition requesting for tomorrow, my lords. Senior is held up in Shimoga, my lords.
Shimoga?
On the
What's the matter? N Pradeep is
55 and 66, my lords. The allegation is that, my lords, tomorrow.
ಏನ್ ಹೇಳಿ?
The allegation is that.
ಆಯ್ತಾಯ್ತು ಹೇಳಿ. Wait.
The allegation is that the petitioner sent few emails from her company's email to her own personal email, my lords. Just 5 days before the registration of the FIR, she is given the show cause notice, and she appears in the internal investigation, my lords. In that internal investigation, she was forced to delete all the data that she allegedly be sent. So then after they issue the second show cause notice. Even before she files a reply to the second show cause notice, the FIR gets registered. And my lords, the matter is, my lords, and there is no allegation that it was an unauthorized data. So all the data that was sent from my company's email to my personal email that I was working on. The reason that I sent to my personal email is simple, my lords. It is a work from home, the model that I was working. So I was attended to do the work like 24/7, and there is no 9 to 6 work schedule for me. If the client calls me at 11 o'clock, I need to take his call and do the work. But this company, my lords, and there is no dedicated official phone, and I should use my personal phone for the company. But strangely, 3 months before this case, my lords, they tell, and you cannot access the company's email in your personal phone. But they don't see any the personal phone. I mean, they don't keep any company's phone. So the only way that I can access the company data is through sending the company data from my company's email to my personal email.
Why you left the job there, is it?
Yes, my lord. I left on 10th March 2026. So my resignation is approved, my lords.
Page. Where is the resignation? 10th March 26.
Yes, my lords.
Date of the complaint?
It is on 2/4/2026. And the first and they approved my resignation on 12/3/2026. And the first
where is the show cause notice?
My lords, one second.
Annexure C, madam.
Page
26.
23, is it?
26, madam.
26, the first show
Annexure
cause.
C.
One moment. You replied to that?
Yes, my lords. My reply in Annexure D, my lords.
Then?
And my lords, I was immediately.
Another show cause notice is issued?
Second show cause
like the second show cause notice issued, my lords.
That is on 2nd April.
Yes, my lords.
1st April. Yes.
2nd
It is
April.
1st April.
1st April. It's all right.
Even before I give reply to the show cause notice, they file a FIR.
1 minute. Why did you issue second show cause notice?
Lord, as a departmental proceedings you have given.
Yes.
Now,
File your objections.
I'll file my objections. My submission is this: 15,000 documents. She has downloaded, and 350 mails which she has deletes later. Matter is also investigated internally. It comes out that way. Then an independent forensic lab provides the same.
Produce all that.
I'll produce with the detailed objections. I'll produce.
You produce it.
Please.
The petitioner is before the court calling in question registration of a crime in crime number 146 of 2026. the petitioner was an employee of Sodexo for 11 years, having joined on 16th September 2015, and had to submit her resignation in the year 2026, i.e. on March the 10th, 2026. The resignation comes to be accepted on 12/3/2026. Nothing was found against the petitioner while the resignation was accepted. Or after the petitioner quits the job,
No, no, my
on
lord. Sorry, my lord. Once the resignation is accepted, the very next day we come to know of it, then the resignation is taken back. The acceptance.
Where is that?
Revoked. I will produce those documents, my lord. They have not produced it.
I wait.
None
Yeah,
have
you
been.
produce it.
None have been.
No problem. The learned,
Fairly applicable.
one nimsha, sir. The learned counsel for the respondent, Pradeep, would submit that the resignation, after coming to know of the acts of the alleged acts of the petitioner, the resignation was also withdrawn, and the said the orders would be placed before the court. The issue in the case is not with regard to the resignation. The company issues a show cause notice. The show cause notice is the first show cause notice is issued on what date?
2nd April.
No,
First show cause is
first one is on
27.
28 March 2026. The petitioner submits a detailed reply to the said show cause notice. This lands in a second show cause notice being issued on 1st April 2026. The petitioner was yet to reply to the second show cause notice issued on 1st April 2026. In the interregnum, before the reply could be submitted, a crime number 146 of 2026 is registered on the same cause of action.
The first show cause notice is on 27/3/2026. Her reply is on 28/3/2026.
All right.
Police complaint is made in April.
Correct. How though?
2/4.
Second show cause notice yak kotre?
Second show cause notice.
Why did you give? If you have the luxury of giving second show cause notice, you have the luxury of waiting for it.
Please.
Yes.
I'll leave it.
That's all. The second show cause notice was issued on 1st April 2026. Even before the ink on the second show cause notice could dry, the crime comes to be registered on the very next day for the aforesaid offences. The respondent company, having issued a second show cause notice the previous day, ought to have awaited the reply instead of setting the criminal law into motion on the same set of facts. On this score alone, till the reports are perused till the objections are filed by the respondent, further investigation shall remain stayed.
May observe that whatever information she has, she should not share it. At least some kind of.
Share it with whom?
With any external person. Well, the whole
Sir,
point is
I
about
did not
data. No,
in
it's always
No, if you come to
Stolen
know of it,
data,
you tell
that's
me,
the
we'll
whole-
dismiss it. Yes. It is
At
made
least-
clear that if the petitioner would precipitate the issue on the strength of the interim order, the matter would be viewed seriously. Next.
I appear for the petitioner. The crime came to be registered against the petitioner, crime number 7 of 2021, Annexure B, that crime pertains to the export of iron ore, total purchase of 4,56,000 metric tons. Annexure B is the investigation was conducted. I made available all the documents. The investigating officer considers each of the companies where I purchased, and he comes to the conclusion at page 46. And he says that I have made available all the documents such as invoice, permits, trip sheets, the forest pass, everything is made available, files a B report. It comes before the court, the complainant appears at page 48, he says, I have no objections to accept this B report. The learned judge keeps finding, then the state government constitute a committee headed by the law minister, as if he is going to be re-examining the investigation done. They pass an order annexure A, directing that all cases where B reports have been accepted, they should be re-investigated. Where they are not accepted, in case of 9 cases, that they have to be re-examined by the investigating officer. Now, on the basis of this government order, a notice is issued to me calling for re-investigation of the matter which has already been reinstated. Final B report has been filed before the court.
What is final B report?
my lord, B report saying that then the
There is
case-
only one B report.
One
What is
B
final B report?
Only the final report I'll say.
That's not a
B
final
report-
B report, all right.
Report in my favor, my lord.
Hmm.
Now, question is, my lord, whether the state has a power to
Hmm.
issue such directions to the investigating officer.
Hmm.
My lord, under 173(8), my lord, if the investigating officer finds fresh material, my lord, they have a power to reinvest, the further investigation.
Hmm.
Let the courts, my lord, from Vinay Tyagi held, my lord, reinvestigation is the domain of the courts under Article 226, Article 32, my lord. Now, the state government assumes that role, issues this government order, directs the investigating officer to re-examine all these B reports which have been filed.
Mhm. Hmm.
Status. So the government wanted whatever reason. My lord.
Maybe.
Yes. my lord.
Court has the power to direct reinvestigation.
No, the B report has not been accepted and not been closed.
All right. Now, how did you constitute a committee
That I like.
to reinvestigate into the matter when the court is seized of the matter?
The B report, my lord, the B report was filed before the court. Various
You have filed a B report. That is not the be all and end all of it. Fine, no problem. But once the B report is filed, if the court has not taken any action upon the B report, where is the question of you constituting a committee for further investigation, reinvestigate? Court has to direct. You could have made a requisition to the court itself.
I'll verify. my lord.
But the court will not have power to permit investigation by the hands of a new committee. It is only to the same investigating
The same
officer.
investigation.
Well, I should have come before this court.
No, it's the same investigation. It is not that investigation has been given to somebody else. Government only recommended.
Recommend ಈಗ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ ಯಾರು ಕಮಿಟಿನ
No.
SIT
SIT.
SIT ನೇ ಹಾಕಿದ್ದು.
Recommended to the SIT. Not
Now again to the SIT.
recommended to the SIT.
That
SIT will internal.
the only thing here is the court had to do it and not the government. That's all.
The only issue, my lord, even the acceptance of, assuming that my learned friend said that B report has been accepted based on a complaint acceptance. Complaint is a police officer. So the government has.
Complaint here ಮಾಡಬೇಕು ಅದೆಲ್ಲ I am not on that at all. When the matter is seized before the court, the government state cannot direct you further investigate, or it should have recommended. ಈಗ SIT ಗೆ recommend ಮಾಡಿದಾರಾ?
Only refer the go through the B report, my lord, then the
ಒಂದು
committee.
ನಿಮಿಷ ಈಗ SIT ಗೆ ಏನ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
Direction they recommend to.
ಒಂದು ನಿಮಿಷ ಏನ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
Page number 23. 29 ವಿಶೇಷ ತನಿಖಾ ತಂಡವು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ 29 ಪ್ರಕರಣದಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಸಲ್ಲಿಸಿದ್ದು, ಬಿ ರಿಪೋರ್ಟ್ ನಲ್ಲಿ ದಾಖಲಿಸಿದ ಕಾರಣಗಳನ್ನು ಅವಲೋಕಿಸಲಾಗಿ ಕೆಲವು ಪ್ರಕರಣದಲ್ಲಿ ನೀಡಲಾದ ಕಾರಣಗಳು ಮೇಲ್ನೋಟಕ್ಕೆ ಸಮಂಜಸವಾಗಿರುವುದನ್ನು ಉಪಸಮಿತಿಯು ಗಮನಿಸಿತು. ಆದ್ದರಿಂದ ಮತ್ತೊಮ್ಮೆ 29 ಪ್ರಕರಣದಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ನ್ನು ಮರುಪರಿಶೀಲಿಸಿ ವಿಶೇಷ ತನಿಖಾ ತಂಡವು ಕ್ರಮ ವಹಿಸುವುದು. ಈ ಬಗ್ಗೆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವವರೆಗೆ ವಿಶೇಷ ತನಿಖಾ ತಂಡ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಬಿ ರಿಪೋರ್ಟ್ಗಳನ್ನು ಸಲ್ಲಿಸಿರುವ 8 ಪ್ರಕರಣ ಬಿ ರಿಪೋರ್ಟ್ ಅನ್ನು ಪರಿಗಣಿಸದಂತೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕೋರಲು ವಿಶೇಷ ತನಿಖಾ ತಂಡವು ಕ್ರಮ ವಹಿಸುವುದು.
Yes, sir.
No, this investigation has already been completed.
That sir, investigation is not complete. B report accept ಆಗಿ close ಆಗಿದ್ರೆ ಹೇಳಿ.
Just kindly see the report.
Well, that's all. Report may be anything. Has it been accepted by the court?
The complainant appeared before the court.
Who is the complainant?
The
Police officer.
DYSP. He appeared before the court. Page
And said
48,
what?
Millet,
And said
that
what?
He said he has no objections to accept the B report.
Has an order of acceptance been passed?
No.
And it is postponed from 2022, Millet. And it is kept pending. When this matter is pending, Millet, now they have now, Millet, further investigation can be undertaken, Millet, if some
ಅಲ್ಲ
material.
ಅದನ್ನೇ ಕೋರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
But secondly, Millet, the SIT itself has no jurisdiction. Millet.
Why?
As per the order of Supreme Court.
ಏನು
it is more than
50,000 metric tons ಗಿಂತ ಮೇಲೆ ಇದೆಯಾ? Then we will hand it over to CBI.
For that also, my lord.
Straight away we will hand it over to CBI. Because up to 50,000 metric tons, it is SIT.
Yes.
Beyond 50,000 metric tons in terms of Samaja Parivartana Samudaya,
Yes.
it is CBI. We will hand it over to CBI.
Because of this is
Let's kindly see, Millet, is according to the
ನಿಮಗೆ
complaint.
CBI ಬೇಕಾ SIT ಬೇಕಾ?
Millet, the SIT has already investigated. Now, if your lordship could see the complaint.
No, you tell me.
says-
If you want it to be transferred to CBI, we'll immediately do it.
That's not, question is, Millet, whether the state government has a power to review the B report submitted by the investigating officer to the court, Millet. Court has the power, Millet, it can pass an order, then it can either accept, Millet, there are three, one, court has not done, it is pending before the court.
No problem.
When the matter is pending before the court, whether the state government has a jurisdiction to interfere with the proceedings before the court.
It has not interfered with the proceedings before the court at all.
Kindly see the order, my lord.
Who is the complainant?
Complainant is DYSP, my lord.
Aita.
Yes.
It has recommended to the DYSP, wherever B reports are filed, you go before the court and contest it.
My lord, kindly see what it says is, I'll read, my lord. ವಿಶೇಷ ತಂಡವು 29 ಬಿ ರಿಪೋರ್ಟ್ ಸಲ್ಲಿಸಿದ್ದು ಬಿ ರಿಪೋರ್ಟಿನಲ್ಲಿ ದಾಖಲಿಸಿದ ಕಾರಣಗಳನ್ನು ಅವಲೋಕಿಸಿ ಕೆಲವು ಪ್ರಕರಣಗಳಲ್ಲಿ ನೀಡಲಾದ ಕಾರಣಗಳು ಮೇಲ್ನೋಟಕ್ಕೆ ಸಂಬಂಧಿಸವಾಗಿರುವುದಿಲ್ಲ. They themselves come to the conclusion that the report submitted by the investigating officer is not proper.
It is akin to a protest petition and nothing else.
Protest petition can be filed by the complainant.
You complainant ಮಾಡ್ತಾರೀಗ.
No, they have not filed any protest petition.
Now they will file.
He has submitted that we have no objection to accept
Has he submitted in writing?
But he has kindly, as a court records the order, kindly see page 48.
Where is the?
Kindly see page 48, my lord.
And how did you submit without the
It's virtual.
approval of the competent authority? Yes, Prasad?
Yes, sir. Information Vivekananda Tulsigiri is
Say,
present.
so and so is present, submit a no objection to accept B report.
Recording alla nadiyalla. Not oral statements. You can't escape the clutches of law on these trivial grounds.
Once again, I am issued, call upon to produce the very same document which I
No
have made
problem.
available.
Whatever it is, if it's further investigation, we will not scuttle it.
It's not further in virtually the
Sir, we
investigation.
will not scuttle further investigation, nor we will stifle the right of the state to do it.
Investigating officer, my lord, has a jurisdiction to further investigate, provided he finds a fresh material to investigate.
I'll pass the order at 2:30.
Yes.
ಇದು ಇದರಲ್ಲಿ ಮೇಡಮ್, ಈಗ ಅರುಣಾಚಲ್ ಶಿವಕುಮಾರ್ ರಿಕೆಟ್ ಮಾಡಿದ್ನಲ್ಲ, ಈಗ ಒಂದು ಪ್ರದೀಪ್ ಅಪಿಯರ್ ಆದ್ಮೇಲೆ ಅದರಲ್ಲಿ
And I have two judgments I'll make.
ಮಧ್ಯಾಹ್ನ ಕೊಡಿ. The law, I am aware that it's only the court, but they have not meddled with that. It is akin to direction or recommendation to file a protest petition. Nothing is wrong with that. If there is anything, you can convince me otherwise.
Permission, serial number.
ಯಾಕೆ 24 ಏನು vacating stay ಇದೆ, don't ask time.
My lord, serial number.
ಮಧ್ಯಾಹ್ನ ರೀಚ್ ಆದಾಗ
My lord, serial number 28, my lord. Serial number 28.
vacating stay ಇದೆಯಾ?
ಇಲ್ಲ, vacating stay. Review petition, my lord. Review petition ಆಗಿದೆ. I will get to.
ಅದು ಬಿಡಿ ಅದು. ಹಾ.
Quick, my lord.
ಬರಲ್ವಾ?
ಏನು ಹುಷಾರಿಲ್ಲ.
ಯಾರಿಗೂ ಹುಷಾರಿಲ್ಲ? ಕೃಷ್ಣ? All right. At 28 ಅಲ್ಲಿ madam, at the request of the counsel K. Krishna, list the matter on ಯಾವತ್ತು ಬೇಕು? 18th? ಅಲ್ಲ, 16 July.
27.
50?
27.
ಹಾ.
27. Lord, effort for mediation, it is settled.
Settle ಆಯ್ತಾ?
Formal agreement has to be drawn. So 2nd of July, my lords will report the settlement.
List on 2nd July to report settlement. The parties to the list submit the settlement has been arrived at. On the what is needed is reporting the settlement list on 2nd July 4 p.m. to report settlement. All matters, huh? 27.
27 and on.
Errad matter. Next. ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್, ಪೇಜ್ ವೈಸ್ ಕರೆದ್ಬಿಡಿ. ಆರ್ಡರ್ಸ್ ಬೇಡ.
Appearing for respond number 2, we have filed wakalat today. Can we request time of 3 weeks to file
Entry ಮಾಡಿದ್ಯಾ?
objections?
Yes, at the request of the counsel appearing for the second respondent, list the matter after 2 weeks in
Time allotted.
3 weeks to file statement, who seeks time to file statement of objections. The interim order subsisting will continue till the.
Another humble submission.
Ah.
We have the name of the respondent appearing, counsel for respondent, Kritika Raghavan. We wanted to appear on the cause list.
What's your name, madam?
Kritika Raghavan.
So and so. Registry to delete the name of Vidyalata as appearing for the second respondent and print the name of so and so. Yes.
My lord, 39, my lord.
Serial number
Serial number
39, I request for some time, my lord.
No, my
because-
lord, child's
No, ma'am.
fees is not being paid, my lord, and my hospital
I
fees,
am
Yeah,
ready.
we will be thrown into the
Time
street.
ಕೇಳಬೇಡಿ madam, ಸುಮ್ನೆ ರೀ. Yes.
Serial number 64.
Reach ಆದಾಗ ಕೊಡುವ.
Serial number 64.
Reach.
64.
ಏನ್ ಬೇಕು?
Next week.
ರೆಸ್ಪಾಂಡೆಂಟ್
ಅಲ್ಲ, petition.
ಆಗ್ತದೆ.
ಎರಡಿದೆ connect.
ಅಲ್ಲ, ಅದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಆಮೇಲೆ ಕರಿತೀನಿ. ಆರ್ಡರ್ಸ್ ಬೇಡ.
ಅಲ್ಲ, admission ಇದೆ.
ಅವೈಟ್ ಸರ್ವಿಸ್ ಇದೆ
64.
ಅದರಲ್ಲಿ.
4, my lord.
Post immediately after service of notice upon the respondent. Interim order if any. ಇರ್ಲಿ.
Next week.
So and so.
Next week ಒಂದು.
Interim order if any shall continue to the next date of hearing.
Next week.
ಏಯ್ ಬರ್ದಾಯ್ತು, ಈಗ ಬಿಡ್ರಾಗಲ್ಲ. ಅದು ಬ್ಯಾಂಕ್ಗೂ ಬೇಕು, ಸುಮ್ಮನೆ ಇರಿ. ನಿಮ್ಗೆ ಏನ್ ತೊಂದರೆ ಆಗಲ್ಲ.
64 date ಒಂದು date.
ಬೇಡ ಬೇಡ, ಇವತ್ತು ಡೇಟ್. ಇವತ್ತು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕು ಅಂದ್ರೆ ನೋಟ್ ಡೇಟ್.
ಹಾಗಾದ್ರೆ ಬೇಡ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಕೊಟ್ರೆ ಹೇಗಿದ್ರು
ಅಲ್ಲ, entry ಮಾಡ್ರಿ, ಇಲ್ಲ.
ಹಾಗಾದ್ರೆ ಇರಿ.
ಇರ್ಲಿ. ಮೇಡಮ್ ಅದು ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲ. 64 ಕೇಳಿ.
Madam.
What's? Huh? ಏನ್ urgency? ಹಾ. ಸೆಕೆಂಡ್ ಕಂಪ್ಲೇಂಟ್ ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ. ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಅಲ್ಲ ಎಲ್ಲಾರ್ದು ತಗೋಬೇಕಲ್ಲ ಅವಾಗ. ಕೊಡಿ ನೋಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ವಿಲ್ ಸಿ. ಕೊಟ್ಟಿರಿ. ಅದು ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್.
Manager is here. Only issue that bank manager is saying that there is.
Who is that bank manager who refuses to obey the order of the court? We will issue contempt.
My lord, I'm here
ಒಂದ್ಸರಿ ಸರ್ವಿಸ್ ರಿಜಿಸ್ಟರ್ ಎಂಟರ್ ಆಗಿ ಪ್ರಮೋಷನ್ ಎಲ್ಲ ನಿಂತ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. What does she think of herself?
My lord, with your lordship's kind leave, my lord,
Yes.
I'm representing the bank manager.
Yes.
My lord,
When I
here-
passed an order to open the locker and draw an inventory, how can she say we will not open
I
it?
understand that, my lord. There is an order to open the locker. When
Yes.
there is an order to open the locker.
Whatever order is there, that has to be passed to obey the orders of the court.
Lordship, allow me to explain in
No.
the procedure. My lord,
This is not,
then it will be
you can't explain dereliction or violation of the order of the court.
difficult for us if
For
there
what?
is no specific order for breaking open the locker. That
Breaking,
should be there.
you want,
But we have no keys.
opening the lock would mean what?
ಬೇಕಲ್ವಾ?
ಯಾವ್ದು ಬೇಕಲ್ವಾ?
We have
ಅಲ್ಲ,
to have
opening the lock ಅಂದ್ರೆ ಏನು ಅರ್ಥ?
Opening the lock ಅಂದ್ರೆ it is with the key.
With the key. ಈಗ ಕೀ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ?
Key ಇಲ್ಲ ಅಂತಂದ್ರೆ there should be a direction by the honorable court.
All
to
right,
break
you,
open.
ಆಯ್ತು, you should have filed an application seeking clarification.
But we have given the reply.
What
I don't know
reply?
whether they have brought it
What
to the
reply?
notice to
What
this
reply?
honorable court.
What's the name of the lady? Branch manager? Manager, who is she?
Manager.
My lords, in the bank, they asked around 7,000 to the IO, my lords, to pay whatever the balance amount
What balance amount?
that the accused was supposed to be paying, my lords. In the bank, my lords, it is all on records.
And my lord, we
No
have
problem,
to.
we'll refer it to the contempt court.
Please, my
Lord,
lords.
one
Right away.
submission, my lord, if
Yes.
there is an order by this honorable court to break open, we will open it.
I
We
have
are not-
said open. How you open it is your lookout.
Lord, that cannot be
No,
because
that's
we
all right.
have to
I will pass an order now.
My lord,
We will pass an order, refer it to the contempt court. You answer everything in the contempt.
Lord, this
Yes.
honorable court allow us to explain the procedure. There will be a
No
contract.
explanation of willful recalcitrance. Straight away. I have passed an order to open the lock.
My lord,
How
let
you
us-
open the lock
let-
is yours.
Let it be clarified that.
What
to break
clarification
open-
you want?
Break open.
What?
Lord, unless there is a.
No,
case,
no,
we
what
can't
clarification you have now?
open. Your
the-
lordship may clarify that to break open the lock.
No, now inventory should be drawn, what is found in the lockers of the bank. All right? Now, how you open the bank locker?
Lord, according to our understanding,
Ah.
opening means with the lock, with the key. If it is.
And where is
if-
the order?
Secret.
What has she passed? What order has she passed?
She returned that letter to the investigation officer.
We are ready to open the locker, and to open the locker, key held by the customer is required. In the absence of the customer's key, breaking open the lock, who has to be done? Who will bear the cost of breaking open the locker? There is no specific direction. So breaking open is okay, but cost should be paid.
We'll incur the cost
No,
of
no.
around,
Cost should be paid.
cost has to
Correct,
be
he
paid.
will pay the cost.
Yes. And.
When has he said he will
and
not pay the cost?
Let there be a direction to break open, my lord.
No, no, no. You have already accepted, that it should be opened, break open. Now what you say is that cost should be paid. Cost, have you denied payment of cost?
No, my
Entered
lords.
into a
My lords,
contract
client
with
is
the
having around
customer.
2 crores of FD, my lords. Because of that interest, this is what the bank manager is doing that, my lords. In support of the accused.
That is incorrect
This
submissions.
court
We will not,
on,
we will never
he has
disobey
FT,
the
my
court
lord.
orders.
This court on 3/6/2026 had passed the This court on 3/6/2026 had passed the following order. This court had unequivocally directed the state to open the lockers of the bank that are indicated in the petition. The state, it was further directed that state shall cause opening of the lockers, draw up an inventory of what is found in the lockers in the bank and that are indicated in the petition, and take the inventory into their custody as observed by drawing the said inventory, and place the inventory before this court on the next date of hearing. The state shall also, it was indicated that the state would also take copies of the inventories of the logbook, entry and exit of persons who have operated the locker, and place the copies on, before the court on the next date. The petitioner, learned counsel for the petitioner and the learned SPP on 18/6/2026 submitted to the court that the branch manager is not cooperating with the orders of the court to open the locker. Therefore, this court on 18/6/2026 had passed the following order. The bank manager before whom the the investigating officer appeared and directed implementation of the order of the court communicates to the investigating officer, which reads as follows. With regard to the opening of the locker, the breaking open of the locker in the absence of the key was not a problem, but who will bear the cost of breaking open the locker, as there is no specific direction to break open the lockers, and as such it would be required for a specific direction to break open the lockers, along with the details of who will bear the cost. The petitioner is ready and willing to bear the cost of how the bank locker should be opened. Who operates that locker?
My lords, nobody, my lords. It is compliant with 102 magistrate control is there, my lords. Because it was seized during crime investigation. So 102 is complied. It is
no, you are who?
I am for the wife, my lords.
The husband is no more, is it?
No, husband
Then?
is there, my lord. He is not the party because he is an accused.
Wait.
Because he is an accused, I have not made part in further investigation, my lord.
You are the wife of whose locker is that?
Accused number 1 and 2, my lord. Mohammed Shahid is husband and mother-in-law is number 2, my lord. It is a joint locker.
Our locker nimge yaak ಬೇಕು?
My lord, all the my jewelry is there in the lockers, my lord.
Who? 1 minute.
During investigation.
Who said so?
My lord, this is
Who
what
said that the lockers contain your jewelry?
complainant has given all the documents to the IO. During investigation, when it was in the crime stage, I was freeze the lockers because previous time he has opened it.
Who has opened it?
He has used it, my lord, lockers. The
Husband has used it. Now the keys are with the husband.
One key is with the husband, one key is with the bank manager.
You take, why have you not made him a party here?
My lord, we have given the notice to him also, my lord. IO has given the notice to him to appear.
In the presence of the husband, you open the locker.
My lord, accused will not come, my lord.
Why will not come? The investigating officer will see to that the accused comes.
Oh, obliged, my lord.
He has the key, right?
He has the key, my lord.
Yes, the so and so. Breaking open the locker. The locker is belonging to the joint account.
No. It is an individual locker.
Husband's.
Husband and mother-in-law.
The locker belongs to the husband and the mother-in-law. The petitioner is the wife, who is now seeking to complain that the jewelry that is found inside the locker belongs to her. The matter is still at this. The proceedings are still pending, in which these items are also the subject matter of crime. Therefore, the accused presence, i.e. the mother-in-law or the husband, be sought by the investigating officer, and in the presence of the respondent complainant, the locker be opened and all the jewelry that is there in the locker be kept in the custody of the magistrate by drawing up an inventory. It need not be handed over to the complainant nor to the accused. Towards that step, even breaking open bekagalla. Towards that step, the investigating officer, towards the said, the investigating officer shall take steps towards that. So wife wants to take away the jewelry, is it?
My lord, everything is there.
Ain't
His
got-
husband has taken away, my lord. All the
How do
jewelry.
you know it is his? It is yours?
My lord, previously has used it, my lord. Because of that, I was freezed it, my lord.
ನೀವು husband and wife ಕಾಟದಲ್ಲಿ ಇವ್ರನ್ನ ಹೇಳ್ತೀರಾ ಅಷ್ಟೇ.
They are not
I
obeying the court orders.
would
my
have
lord.
sent this to contempt now. This is not correct.
My lord.
That order itself I should not have passed. Listening to the complainant. The proceedings are pending.
Yes, my lord.
ನಿಮ್ಮ husband and wife ಜಗಳದಲ್ಲಿ finish ಮಾಡ್ಬಿಡ್ತೀರಾ ಇವ್ರನ್ನ.
My lord, Charge sheet is filed without opening of the lockers, my lord.
That's all right. That's a matter that you argue, that we'll see. That doesn't mean, inventory draw ಮಾಡಿ, whatever jewels are there, you take into your custody and keep it in the custody of the.
Belongs to her, my lord. Maybe the locker contents.
No,
could be
now
clear.
it belongs to whom is a different thing. The entire locker, whatever jewelry is there, they will take charge of it. ಆಮೇಲೆ after the trial is over, they will give it, we'll see.
They're worried about the clients.
We are
Our
not
clients
worried.
to.
ನಮ್ಮ
they're
ಏನು ಅವ್ರ ಕ್ಲೈಂಟ್ಗೆ ಏನು ಹೋಗಲ್ವಲ್ಲ ಅದು?
Allow, let their, protecting the interest of their
have
client.
to protect the bank's interest,
No,
not.
no, that, there's no mistake in what she says. All right. That order itself I should not have passed. No, if the reply kotra is definitely contempt. Who will bear the charges? All that is not correct.
Officer ಕೊಡ್ಬೇಕಾದ್ರೆ ಅವರಿಗೆ ಹೆಂಗ್
No,
ಕೊಡ್ಬೇಕಂತ
that's all right, but you should not be worried about what happens to the money when, who pays the money when the order of the court is there. But here it is, I did not realize that it is wife trying to take away the jewelry. But not obeying the order of the court is not correct.
No, it is not an intentional disobeying, my lord. Only thing like break open ಅಂತ ಇಲ್ದಿದ್ದಾಗ it will be difficult for the banks to.
No,
open
this
it
is,
without
I
keys.
thought the husband is no more. And the bank is dodging to give back the jewelry. Husband is there.
Husband is there. Mother-in-law is also.
Mislead ಮಾಡ್ಬಿಡ್ತಾರೆ, then they'll take
No,
the
no,
orders
no, I
and
am
they'll
not
interpret.
misled in my
mislead
petition,
ಏನಿಲ್ಲ.
my lord. ನಾನು
ಆ
ಎಲ್ಲ
ಥರ ಏನ್
ಬರ್ದಿದ್ದೀನಿ,
ಮಾಡಲ್ಲ.
ಎಲ್ಲ ಹಾಕಿದ್ದೀನಿ.
ಅವೇ mislead ಮಾಡಲ್ಲ. It's okay.
Oblige.
Anyway, yes. ಅದು our presence, what's the name of the officer?
Meera Rao.
ನಿಮ್ಗೆ ಗೊತ್ತಾ?
ನಾನು.
Yes. So and so. Is present before the court. The presence of the said officer in future proceedings is dispensed with. Yes.
Please.
ಅದು ಯಾರು? ಯಾವ್ದದು?
Directors of Razor Pay, my lords.
ASG?
ASG sir is coming.
Where is he?
He's coming.
He's coming. Ask him to come. Yes.
May we come and say submissions, my lords. I had given a note, 11 points for consideration in this case, my lords. The directors of Razor Pay, their arrears as accused 8 and 9. Razor Pay is not made a party.
ಸಿವಿ ನಾಗೇಶ್ ಸರ್ ಇದ್ರಲ್ಲ ಅದೇ ತಾನೇ?
How the same, my lords. Could I request my lords to have the note, my lords, 11 points which were there in that note? The entire investigation, my lords, is basically against certain companies whose directors are from China, my lords. And virtually they were lending money at exorbitant interest rates. And they were beneficiaries of what they have received. Now, how they went about it was, my lords, they used to enter into agreements with non-banking
ಮತ್ತೆ
financial.
learned ASG has come.
Yes.
ಅವ್ರು ನೋಟ್ ಮಾಡ್ಕೊಂಡು. Yes, yes.
I've seen these 11 points.
How they used to go about it is, my lords, these companies used to enter into agreements with non-banking financial companies. Now, my lords, lending of monies could be done only by non-banking financial companies. So the Chinese, so-called Chinese companies enter into agreements with them. And then, my lords, they would lure people to take certain amounts for exorbitant interest. Now, my lords, this was noticed and an order was passed to investigate about 33 companies. Now, this order which is passed for investigation would be under 212 of the Companies Act, my lords.
Correct. 212 is SFIO.
SFIO.
This is SFIO.
SFI. So the order which was passed naming 33 companies. Now, as amongst the 33 companies, investigation was done against one company called Mad Elephant, my lords. Mad Elephant. And while investigating into that company, my lords, the investigating officer would finally file his investigation report, not just against Mad Elephant and its directors, the non-banking financial company and their directors, but would include an intermediary, which is Razor Pay, my lords, and in that only against 2 directors, but not the company. This is how the array takes place in the investigation report. Now, based on that, my lords, they would get the approval of central government and then file a complaint before the court on which cognizance is taken. Now, the whole petition which we have now, we are looking at is, my lords, only insofar as accused 8 and 9, for which, my lords, 11 points for consideration. Now, the allegation against Razor Pay is you were negligent. The whole allegation is one under 166 of the Companies Act, punishable with fine, my lords, to say you should have been little more careful while onboarding certain companies. This is the allegation. Now, my lords, if the note is now noticed, my lords, the 11 points which we have taken up.
Yes,
My
sir.
lords, in the first page of the note, just the genesis of the case is there. And how the allegation against Razor Pay is one of negligence, which my lords would get at page 3, my lords. So, 4 aspects which we get in the report. Negligence in merchant onboarding. So, no adequate KYC or due diligence or monitoring. My lords, could I just pause here for a minute, my lords? Now, this company, my lords, Mad Elephant, they would have their own bankers, a set of bankers dealing with their accounts, my lords. The responsibility insofar as KYC is concerned is of those bankers. Now, none of those bankers are accused, my lords, now. But then they would make only an intermediary who has nothing to do with that as an accused on the ground that you are negligent while onboarding. Now, that is the first allegation. Second, my lords, they would say failure to follow RBI directions, which I will point out, my lords, there was nothing insofar as our role is concerned, my lords, from the RBI directories.
But you are accused 8 and 9.
8 and 9, 2 directors, my lords. Company is not an accused.
Correct.
Then third is, my lords, they say there was operational laxity. That means you should have been slightly more careful before you onboarded them. And then, my lords, whole allegation against us, negligence, simpliciter, not, my lords, negligence coupled with 447 would have been different, but this is not the case.
No, that is, you're saying negligence coupled with fraud.
Yes, my lords. Then it is different. Then we wouldn't have the aspect of even limitation, my lords. If it is negligence simpliciter, one of the grounds which we have taken is it's barred by limitation.
6 months.
Yes, my lords, on the basis of that. So, my lords, the legal contentions which we have taken, the first legal contention is lack of jurisdiction under 212. My lords, I will point out between 206 to 212 how the code, it's a code in itself and the safeguards given there. And I will point out, my lords, in this case, those safeguards have been not followed at all. Then, my lords, lack of jurisdiction is the first point. Section 166 is wholly inapplicable and misconceived insofar as this intermediary is concerned, my lords. Then third point, negligence simpliciter is not an offense because, my lords, mens rea act, even in IPC, my lords, it should be negligence coupled with rashness or anything else. Simpliciter, when we look at it, my lords, negligence would not be an offense. It could be a tort, my lords, but not an offense and a crime. Then, my lords, the fourth aspect is no vicarious liability in criminal jurisprudence, my lords.
Company is not made.
Company is not. Fifth is it's barred by limitation. I'll be able to demonstrate, my lords, the so-called offenses is of the year 2019 and 2020. But the investigation itself commences in 2022 because that's the date of relevance, not the date when cognizance is taken, because cognizance is in 2026. I'm not taking that. So the date when you commence your investigation or you know about it. Then, my lords, the next point would be no ingredients of criminal offense disclosed so far as negligence is concerned. The seventh aspect is mens rea and nexus. That would be lacking. Then, my lords, KYC obligation was not on the intermediary but on the bankers as it discloses from their own investigation report, but they don't make the bankers at all a party to this report. Then selective and discriminative prosecution is number 9. Then Razor Pay is an intermediary. That, my lords, I would say would be covered by the view taken by this honorable court also. Section
Supreme Court
79,
also.
my lords,
Yes.
79 would protect them. Then cognizance taken without mandatory pre-cognizance. My lords, this is a slightly gray area, as I will point out, my lords, 223, whether it is applicable to offences under the Companies Act or not. Because now under the PMLA also,
It has been made applicable.
it has been made applicable. But here, my lords, because of the usage of language where they say the ultimate report which is filed is in the nature of a police report. In the section 212, we get that, my lords. So when it comes to filing the complaint, do we view it to be a complaint like that of 2D or do we view it to be a report under 173. That is an aspect, my lords, which is slightly gray, my lords, would be my respectful submission. So on the basis of this 11 contentions, my lords, can I commence with the Companies Act 206 till 212, my lords? I will just point out how mandatorily what steps to be taken, my lords. Yeah. Could I again request, my lords, yesterday my lords saw the Companies Act, but just for my continuity of 206.
But you should finish
Yes, my lords, I
fast.
will. And my lords, probably if this aspect is accepted, my lords, we don't have to see the others. Because my lords, my understanding.
Because we are in 482.
Yes, my lords, my
So
understanding.
it's not that we are an appeal.
My lords,
Yes.
my understanding of the provision there is, my lords, how this all commences would be a complaint to a registrar. Now, registrar, my lords, of companies would give an opportunity to persons and then he would formulate a report. Now, registrar has also been given the power under 209 for search and seizure, my lords, and then he gives a report under 208. Now, after this 208 report, my lords, central government has two options. One is you can order an investigation under 210. Two, in very serious offenses, my lords, based on your opinion, which has to be reflected in the order, you can give it to the serious fraud investigating officer. Now, two judgments that covers that issue completely in my respectful submission. One of the division bench of Bombay and one 2025 judgment of Delhi, my lords, where they say what exactly this order should contain. Because this order which is passed by the central government should reflect the reason why you're giving it to the special, serious finance investigating officer. My lords, I'll point that out because that may be of great relevance to say in this case, it is lacking. They don't even point out. Now, in this case, my lords, understandable against the company to whom you have given the investigation to, 33 companies. Now, if you want to include someone more, my lords, in my respectful submission, 219 of the Companies Act would be of some relevance. Could 219 be seen, my lords? Now, in the course of investigation, they feel some other entity also needs to be investigated. Then you will have to write to the central government. Central government will have to give you permission to investigate the other corporates and only then go about it.
Now, what is this investigation under? It is done by the SFIO under section 212.
Post order passed under 2121.
Correct. By the
Order.
government.
Yes,
By the government.
Now we have to test that order first.
That's all.
Yes,
You take me to that order.
please.
Yes.
Page 91, my lords. Now, as I pointed out, my lords, a report of the ROC after ROC giving opportunity to persons is mandatory. Now, kindly notice how this order is passed. Page 91, order dated 9/9/2022. Whereas the central government is empowered under section 2121C of the Companies Act to order investigation into the affairs of a company. And whereas ROC Delhi has submitted a confidential report, please make a note of this, my lords, submitted a confidential report. Now, there's no concept of a confidential report. A report is only under 208 after opportunity is given to persons likely to be affected. Now, kindly notice this is a confidential report that while conducting the inquiry into some companies referred by the Ministry of Home Affairs, they unearthed the racket of paper companies with dummy directors being created by Jillian Consultants India Private Limited and its wholly owned subsidiary, Finity Private Limited. And it was observed that about 30 companies are using the email ID of Jillian Consultant India Private Limited. It was also observed by the ROC that another company, so and so, having its registered office at Hyderabad, is also involved in, since some payments to some of the dummy directors were routed through HUSYS, and some transactions were also noted between so and so. Whereas the
What is the legal submission on this?
My lords, kindly
No
notice,
reasons?
First 208, no report. Reflected in the order.
208.
Report, my
Under
lords.
208, there is no report.
Yes, my lords.
All right. Yes.
And can I?
I'm sorry to interject, but validity of none of those orders are under challenge. What is under challenge is only
No.
of the order.
No, I'm sorry.
No,
I'll
this
point
order
out-
is under challenge?
No, my lords, I will point out.
No, 1 minute. No, this order is under challenge?
My lords, paragraph 23 of my petition itself, we start with this. This order
Prayer. What's your prayer?
for quashment of the entire proceedings.
Entire proceedings.
Entire
Before
proceedings.
this special court.
My lords,
No, that would cover this also. It's all right.
my
yes.
lords, in my note, I have extracted my contention and their reply. If my lords would have the second note, my lords.
No,
so
that's
that-
okay. You carry on. Yes.
So, my lords, my first contention is the mandate under section 208, a report to be given after opportunity of hearing has not been followed, my lords. Now, this contention probably, my lords, could even come to the aid of the companies who are named herein. But for me, my lords, I'm not even named in this order. Now, this.
Now come to 208.
Yes, my lords. 208.
8.
My lords, 7 parts starting from 206.
That's from 206.
Yes, my lords, chapter
Now,
14.
206 and 207.
Yes, my lords, I'll point out the steps there.
Mandate that
Mandate.
you should be heard.
Yes, my lords.
All right.
Kindly
yes.
notice, my lords.
So that forms a report under 208.
Yes, my lords, and the
So
power to
now,
search and seizure under 209.
Unless, now you tell me, SFIO can be entrusted with a particular thing only if there is a report made under 208 and the 208 precedes 206 and 207. Where?
Well, it's from the reading of this. Could I point out the
No,
steps
it-
under this?
Otherwise, it can't go to SFIO at all.
Well, lords, if it is going to SFIO, it should be in public interest where the usage of the word or is there. It should be pointed out, my lords. Now, so far as I'm concerned, I'm not
The-
even named in that
The
order.
only issue is public interest.
Yes, my lords, and my lords, I'm not even named in that order of the central government. My lords, if central government thought it fit on the basis of the ROC report indicating that I should be investigated, that will become part of the order. Now, my lords, central government on the basis of a confidential report felt 33 companies have to be investigated. And out of the 33 companies, now the investigation report is only against company number 13, and non-banking financial companies. Incidentally, I am arrayed as A8 and A9. And why? I am an intermediary. My lords, please, can I just point out the steps there, my lords? 206, first step, my lords, is under 206(1). Once they get an information, then they give an opportunity to have a say. That is step number 1, my lords, under 206. Kindly notice step 2, 206, section D4 may be noticed, my lords. That would be the second step. When they're doing the investigation, if they find it is fraudulent or unlawful purpose, the usage of the words are in 4, my lords. If the registrar is satisfied on the basis of information available with or furnished to him or on a representation made to him by any person that the business of a company is being carried on for a fraudulent or unlawful purpose, then he gives an opportunity. Second step, my lords. Step 3, my lords would know he would have the powers of a civil court, my lords, which we get in 207(3). All the powers of a civil court to gather all information that is required. And step 4 would be search and seizure under 209, the power which is there with the ROC. And the 5th step would be the report under 208. Then on this report under 208, my lords, it is submitted to the central government. And as I pointed out, 210 may be noticed, my lords. Central government can order an investigation. And if they feel that this is a very serious offense, it has to go under 212. Now, 212, 1 may be noticed, my lords. 212, subsection 1. Because, my lords, A, B, C on receipt of a report of a registrar or inspector under 208. Now they say here.
I've seen all the 4
My lords, now they say here confidential report. In my respectful submission, my lords, if they're going on 2121A, which they say they're going under, there's no concept of a confidential report, but a report given under 208, for which, my lords, opportunity of being heard to the affected parties, that is not done. So, my lords, if that is not done, this order which has been passed under 2121 has to go. This would be the first aspect of the. And, my lords, to support this contention of mine, my lords, 2 judgments that I'm relying on, one of the division bench of Bombay and other of the Delhi. If my lords would have the note which I gave on the previous occasion, specifically under 212 with the judgments, I gave another note, my lords.
I have it.
Yes,
Yes.
please notice in that note, my lords, scope of 212 of the Companies Act, my lords should notice that the first page therein.
Yes.
Last time,
ಇದೆ.
a note there. Even the judgment I have extracted there. My lords, the scope of 212 may be noticed there, which I just pointed out now. And the ground which I have taken in the petition I have extracted.
Now, there is no proceedings initiated under between section 216 to 210?
To 206 to 208 is not done.
No proceedings
No,
initiated?
never been called.
No, that's a different thing. The straight away it is given to the SFIO?
And they say it's a
Is that your case?
Yes, my lords, it's a confidential report given by the ROC is what is mentioned in the order.
Yes, all right.
So my lords, if it's a confidential report by the ROC, ROC would have had to follow the mandate of 206 to 208, which is not done.
All right.
Because
So
I cross-checked, my
according
lords.
to you, there is nothing initiated except the matter being handed over to the SFIO?
So far as
That's what, yes.
I'm so far as Razorpay is concerned, yes, my lords, there's nothing initiated against us.
Anyway.
And because even the order of the central government makes it obvious that nothing had been initiated against Razorpay, because order itself is against 33 other companies, not against Razorpay. So I had nothing to
Why
do.
I asked is, if, Kamath sir, if proceedings are initiated under the Companies Act, say 206 to 210, and while doing that investigation, out of serendipity, if you find some skullduggery by them, you can straight away put it to the SFIO. Correct. Now, without going to those steps of putting it through the rigmarole of procedure into 206 to 210, straight away you can give it to SFIO on one circumstance, public interest. So you have given it under that circumstance?
Yes.
All right. Yes.
And a public interest against 33 companies, that may be
Correct.
necessary, because not against me.
Correct.
Even central government, my lords, even in public interest, would not confer power and jurisdiction on SFIO insofar as I am concerned. They gave it in only insofar as the 33 companies are concerned. Now, my lords, please, in the note, my lords, where I have extracted my pleading, my lords may have page 2, the ground that I've taken in the petition I've extracted.
Correct. But do you mean to say that procedure under 206 to 210 has to be followed to send it to 212?
Unless, my lords, unless.
I'm afraid.
No, we'll see, my lords. We'll test it on the basis of the 2 judgments that I'm relying on. Because, my lords, the judgments have gone to the extent of saying the opinion word which is used in 212 assumes great importance, and that opinion has to be backed by what has been done earlier. And that is how the opinions were quashed in those 2 cases. I will point that out. So, my lords, ground may be noticed, my lords, that I've taken in my pleading. In second page, grounds taken in the petition regarding 212.
Yes,
I've extracted paragraph 24, my lords,
Yes,
along with the
correct.
heading therein.
Yes,
And
yes.
response given in the statement of objection, page 3 may be noticed. This is the objection so far as
Yes,
212
yes.
is concerned. Virtually to say we can investigate anything. Then, my lords, interpretation of section 212 of the Companies Act, Parmeshwar Das Agarwal versus Additional Director, 2016 SEC Online Bombay, 9276. Now, my lords, I will point out from that judgment the importance of this order under 212. My lords, with the judgments are given along with that. Further down, my lords, the judgment commences at
Yes.
page 1, decided on 5th October 2016. Please notice, my lords, what was under challenge is an opinion given under 212. The very first paragraph therein, proceedings relating to investigation ordered by the respondent, and after going through the same, to quash and set aside the order dated 6th May 2016, which is an opinion given to conduct investigation. The relevant portion, my lords, in this judgment, discussion on, kindly notice paragraph 30, my lords, 30 at page 11.
Yes.
Line about 6 therein, paragraph 30. Mr. So-and-so relied upon the entire scheme contained in the Indian Companies Act and the Companies Act 2013. he submits that the power akin to section 235 of the Companies Act 1956 and now to be found in the Companies Act 2013, where section 212 has been exercised. That has been exercised on the footing that the report of the registrar enables the central government to appoint inspectors to investigate affairs of the company and to report thereon. It is in these circumstances that the power has been exercised. The grounds which have been set up in the report, which forms the basis for the ultimate step, can be said to be real and existing. It is not at the behest of any group that the central government has acted. SFIO steps into the picture only because central government formed the requisite opinion. The grounds or the contents of the report enabled the central government to form that opinion. The opinion is reasonable. The discretion has been exercised by applying correct judicial principles. There is no deviation from the same. For these reasons, petition is premature. This court should not interfere. This is specifically the contention that was taken. Now, answering this, my lords, the court would say, my lords, the court even deals with the earlier Companies Act, the same kind of provision which was there. And thereafter, paragraph 36 at page 16 may be noticed, my lords. 36, page 16.
Yes.
Therefore, the central government has to form an opinion that their circumstances suggested as above, and the central government, before it acts, has to comply with the statutory prerequisites. The above dictum of the Honorable Supreme Court was also applied in the case of so and so. My lords gets that portion.
Yes.
And then, my lords, at paragraph 40 at page 22, 40 and 41 would be of relevance, my lords.
Yes.
At page 22. Thus, the principle is that there has to be an opinion formed. That opinion may be subjective, but the existence of circumstances relevant to the inference as to the sine qua non for action must be demonstrable. This may be of vital importance, my lords, so far as the razor pay is concerned.
Yes, sir.
My lords, paragraph 40, 41, and then, my lords, still 43. Those are the relevant. I do. I hope the mark.
High Court aaytu, Bombay High Court another judgment aaytu.
And Delhi. Delhi, my lords, recently.
Second is Delhi.
First is Bombay.
First is Division Bench of Bombay, SLP dismissed. Amele second is Delhi, Delhi
Senior
High Court
Council,
single judge. Again,
I think we reiterated
correct.
the same arguments.
Another judgment.
And the opinion was set aside.
Justice Bharati Dongre's another judge.
Yes, my lords.
Yes. No, all paragraphs seen.
Yeah, my lords, flagged and marked the relevant paragraphs.
Yes.
So, my lords, in this context, my lords, if this opinion or order under 2121 is seen, my lords, nothing indicative in so far as razor pay is concerned. And if there's nothing indicating razor pay as to how the directors without the company are made accused 8 and 9 is not known. Now, based on this opinion, investigation took place. Now, in the investigation report, if my lords would now notice the investigation.
Where do I get the report?
My lords, it's at page 63, my lords. Where is the report starting? Starting of the report. I'm sorry, I'm just one minute. Page investigation report. Give me the investigation report. Investigation order. Investigation report 31/7/2020. Complaint. This is a complaint. No. They've got a separate report. Report is where? Then we'll come to the complaint. I'm sorry, my lords. I'll just point out from the report.
Prosecution complaint baralva. Yes.
We gave the report 31/7/2024. What way is it on? My lords, it's part of the complaint as an annexure. It's produced here as at the page.
Page.
I'll just give the page, my lords. Report. 108, my lords.
Starts from that. It's a part
It's
of
a
the complaint.
108 in petition. Because with your complaint, you had annexed. Yes, you had annexed.
Investigation report of Mad Elephant.
Mad Elephant. They were the 13th accused in the order, my lords.
Correct, correct. I saw the other accused also, Omelette. Omelette Technologies. Correct ಆಗಿ ಹಾಕಿದ್ದೀರಾ.
My lords, 108 ಅಲ್ಲಿ, 108 ಅಲ್ಲಿ, please notice the provision under which it is done, under 212 of the Companies Act, my lords. In the matter of so and so and 32 others, so you're reflecting it back to the 33 companies to which you got your opinion or order of the central government. 212, my lords, and this is dated 31/7/2024. Now the relevant portion insofar as the payment aggregator is concerned, my lords. And also I may say, my lords, along with me, there were other payment aggregators, but they're not arrayed as accused. Only I have been arrayed as accused. And all the bankers who were supposed to do the KYC, they're not arrayed as accused.
Who are the other accused here?
Here,
For
my
8
lords,
and 9, how many accused are there?
totally 9. 8 and 9 are directors.
1 to 7 yaru?
My lords, 1 is Mad Elephant. 2, 3, 4 are its directors. 5 will be the non-banking financial company with whom Mad Elephant had an agreement. Then 6 and
8 and 9
7,
is-
6 and 7 are their directors.
8 and 9 intermediaries.
Without razor pay, only 8 and 9 directors
Intermediaries.
as intermediaries. And I'll point out here, the allegation is against razor pay for being negligent, but now you make only the directors as parties. That's why one of the grounds that has
So
been taken.
company is not made.
Not made a party, my lords. Now, my lords, in paragraph, in page 114, the summary at paragraph 1, in that 9/9/2022 is the order which we just read, my lords. Remaining orders that we get here are appointment of inspectors. Now they initially appoint 4 inspectors. They want to change again. They need orders. Those are the orders, my lords, as required under the act. So other than this one order of 9/9, we don't have an order to include razor pay as a company to be investigated into. Company under investigation. That's how they put it, my lords. I was not a company under investigation. Then, my lords, the entire narration in the report is against Mad Elephant, where they make razor pay a party is 11, my lords, paragraph 11. And in fact, to the extent of saying in razor pay, there was 18.72 crores, which they wrote to razor pay, and it was frozen and kept for the purpose of investigation, my lords. That we get it at paragraph 9 at page 115, paragraph 11, my lords, may note
So
it. be
all
noticed.
the transactions of these companies are routed through this intermediaries. That is the allegation.
No.
Then?
My lords, how it works is the Mad Elephant with their bankers. Bankers would have checked, are
Correct.
supposed to check. Then, my lords, they have entered into agreement with the non-banking financial companies. Now, correctly, my lords, it's only these non-banking financial companies which could have lent money. And everything should have been done by these non-banking financial companies. But rather than that, Mad Elephant, my lords, they used to lend money directly, bypassing the non-banking financial companies.
But with all this, how are you responsible?
My lords, what
No, payment.
aggregators
See, you are a
become in the
payment.
what?
You are a payment aggregator.
Aggregator.
Money passes through you.
Yes, my lords.
You facilitate passage of money.
Yes, my lords.
Whose money is
My-
what is
no,
not
not our
concerned.
concern at all, because 79 is a protection which we get under the IT Act. And also, my lords, all that is done in so far as the intermediaries are concerned, why they come into picture is, my lords, instead of a bank doing 1,000 transactions a day, which is not possible for them, that is where we have aggregators which support that cause. Now, in this case, number of aggregators were there, my lords. Amongst them, one was Razorpay. That is their case. So they're saying you as Razorpay, you permitted certain transaction, but you should have done KYC. Now, KYC is not my responsibility at all, my lords. KYC is the responsibility of their banker. I am only a payment aggregator. So if I'm a payment aggregator, under 79, you could not have proceeded against me at all. And especially in the scheme of the Companies Act, where you never had an inquiry by the ROC, you never gave me an opportunity. Maybe I'd have explained there itself before the consent. So, my lords, the only allegation against me is, kindly notice paragraph 11 at page 115. The investigation revealed that there was negligence on the part of Razorpay at the time of merchant onboarding. This is the allegation against Razorpay. So negligence under 166.
So you, of course, negligence under 166. And do you have the responsibility of knowing who is sending the money, to whom it is being sent.
No, my lords, at that point of time, 2019, 2020,
So
there was,
for illustration, the money is used for terrorist activities.
my lords, kindly note,
And somebody passes through you
my
everything.
lords, kindly notice paragraph 13, my lords. Despite there being no statutory requirement, paragraph 13 in my petition, we point out what are the things we collected, what are the documents. This is just to safeguard
So
ourselves.
you collect something.
Yes, my lords. Please notice paragraph
So you
13,
collect something which is akin to KYC.
which is, yes, my lord, though KYC is not required for me to do. Though KYC is not required for me to do, because KYC is the responsibility of the banker as it was in existence then. So despite that, only for us to have certain safeguards, my lords, if paragraph 13, maybe notice what
Did you undertake those safeguards here also?
we did. My lords, that's, my lords, paragraph 13 would have noted, what is it that we collected at that point of time? And now, my lords, what amount was there in our account, they wrote a letter to me, we kept it under freeze. Now their whole allegation is, my lords, this mad elephant made about 56 crores as profits out of lending money. 18.76 crores was lying in Razor Pay, which Razor Pay on a letter written by the investigating officer kept under freeze.
Now, how long do you hold this money?
My lords, there's a window of about 3 days, my lords. Window of about 3 days.
Now
when
about 100 crores is transacted with Razor Pay. It is kept for about 3 days. What is that you gain out of it?
My lords, for every transaction, we get a commission, my lords. How intermediaries work.
No,
is
by
on every-
commission that I know.
That's all.
But keeping for 3 days will not change the
No, no,
commission?
no,
All right.
because there's some window, my lords, payment window is there. That goes up to about 3 days. Am I right? 48 days, 48 hours. So say about 3 days maximum.
All right.
3 days
Fine.
maximum.
No, that's besides the
I
point,
know,
but
just
I want to
to,
know.
how it works, my lords.
Yes.
My lords, if paragraph 13.
So it is not that the entire responsibility of KYC is with the non-banking financial corporation. Some of it you also have to
No,
do.
my lords, if the responsibility of KYC is not with
No,
the non-banking.
KYC in a statutory format, yes, they will do. But akin to KYC, you also will bring some
My lords,
documents.
2019 and 2020, at the time when this transaction took place, my lords, there was no responsibility on these aggregators. There was no responsibility, my lords. The responsibility is not on that non-banking financial company, but the bankers of Mad Elephant. Now, the bankers of Mad Elephant, my lords, we have
These
the
are
list of their
the,
bankers. They had the responsibility at the
No,
time.
Mad Elephant is it's a Chinese company.
Yes, directors are supposed to be from China, my lords, in
China.
the course of investigation. My lords, Mad Elephant, they had their bankers as Yes Bank, ICIC Bank, and other banks, which is reflected in the report itself. Now, they had responsibility of KYC. They're not accused now, my lords. And even payment aggregators, along with me, my lords, we had Cash Free, Paytm, and other payment aggregators. None of them are accused. How did you pick up 2 directors, my lords, in this whole array when they were not even subject matter of investigation?
Let the ASG answer.
Yes, my lords. Paragraph 13, Ali, what all we took. Now, my lords, with this backdrop, please notice the contentions, my lords, 11th contentions.
That we'll see. Let him answer this. Yes, ASG sir. You don't worry about it. Our complete ಸಾಯಂಕಾಲ ಮಾಡ್ತಾರೆ. ನೀವು ಮಾಡಿ. Yes.
My lords, the summary of charge which they put.
Where is that?
My lords, at page 350, 350. 350, summary of charge, my lords. They've done a table there. The
Yes.
section should assume importance, my lords, there. As against Mad Elephant, section 447, fraud, my lords. And for the financial year.
You are 8 and 9.
I'm
Ibru-
8 and,
Oh, it's only 166.
yes, my lords, without Razor Pay also being a company, without being a party, just 166. And 166 is punishable with fine. And if it's punishable with fine, my lords, and if the charge is 166 simpliciter, obviously, my lords, within 6 months is when they can start investigation.
Yes, ASG sir. We'll
And-
hear him. Yes, sir.
Lord, I'd like to begin by saying, when you deal with a mad elephant, there is a strong possibility you'll get trampled over. And that is what has happened with this petitioner.
So the Razor Pay should not have dealt with them.
Lord,
Yes.
broadly, the issue was that during 2020-22, there were a lot of these apps which are giving away loans very fraudulently on very high interest rate. Some of them going up to about 200%. And then there was a public furor there. So in public interest, an investigation was ordered, and beginning with the company called Jillian and all this omelette and other stuff. And then finally, which resulted in the order passed under section 212. Can we have a quick look at that order? It's quite a short order. May
No,
take
he has taken me through that order.
Hello, a couple of sentences in that.
Yes. Page 91 and C2.
Page 91.
Yes.
If your lordships could kindly go to page 91. Sometimes these machines get stuck.
It's file code la?
But 91, particularly after the initial recital, please have a look at page 93, 91, my learned friend has
93, correct. Now the central
last
government.
page of that order.
Yes, now the central government.
Yes, now the central government hereby directs SFIO to conduct the investigation of the above 33 companies under 2121C of the Companies
In public
Act.
interest.
In public interest. My lordship wanted to know why you did it. In public interest.
In public
The
interest.
scope of the investigation will be to unearth, now this is very important, the racket of dummy directors and fake companies and the purpose behind forming a web and routing of money. But in this case, the business of the petitioner is playing a financial conduit. But I'm not alleging that the petitioner ought to have known that they are fraud companies.
Correct.
It's not about that. I'm not even saying they are party to that. But then the fact of the matter is that the nature of business is that they're a conduit for the financial aspect. They act as the conduit. Now, my lord, if I were to take your lordship to a couple of provisions under the Companies Act, would your lordship take up the Companies Act? I would like to read a few provisions because ultimately we are prosecuting the accused 8 and 9 who are now petitioners before lordship because of their failure to discharge duties. The company is not involved here. The directors, there are certain imposition of duties on the directors statutorily. It is the failure to discharge those duties. In that regard, may I draw your lordship's attention
But
first?
how can you draw vicarious liability? On
No, it is not vicarious, direct.
Hmm.
This is direct liability, which is why let me take your lordship through the provisions of law. Can we begin with section 134 of the Companies Act? Just to show how there can be, there are certain duties which are imposed on the directors. Please have a look at 134, financial statement, board report, etc.
Which clause?
I read 3 and then the 1 says, financial statement including the consolidated financial statement, if any, shall be approved by the board of directors before they are signed on behalf of the board by the chairperson of the company, where is authorized so-and-so, which one so-and-so. Then 3, there shall be attached to the statement laid before a company in a general meeting, a report by its board of directors, which shall include clause C, directors' responsibility statement. The board of directors is the brain of the company. They are the ones who run the business. Now, what are the contents of this director's statements responsibility? That can be found in subsection 5. The director's responsibility statement referred to in clause C of subsection 3 shall state, then may I take your lordship directly to F. The directors had devised proper systems to ensure compliance with the provisions of all applicable laws and that such systems were adequate and operating effectively.
They have taken care of.
I'll come to that. Those are questions of fact. Those are questions of. So by statutorily, there is imposition of duties on the board of directors. They are not just, the directors are not there just for the ceremonial sake. They are there to ensure that certain internal systems are put in place, certain compliances are made, which is why now, if there is a failure in discharge of these duties, what is the consequence? Now, first the imposition of duties. Please now turn to page section 166. Subject to the provisions of this act, a director of a company shall act in accordance with the articles of the company. Now, 2 is important, subsection 2. A director of the company shall act in good faith in order to promote the objects of the company for the benefits of its members as a whole and in the best interest of the company, its employees, the shareholders, the community, and for protection of the environment. A director of the company shall exercise his duties with due and reasonable care, skill, diligence, and exercise and shall exercise independent judgment. Now there is imposition of certain duties which is on the directors under subsection 2 and 3. In the event there is a failure, what is the consequence? Lord, subsection
7.
If a director of a company contravenes the provisions of this section, such a director shall be punishable with fine which shall not be less than 1 lakh rupees, but which may extend up to 5 lakh rupees. Therefore, my lord, here the allegation is that towards the duty which these directors owe to its own company of putting in place certain internal controls, certain policies to ensure that every legislation is complied with and the business is carried on in accordance with law. Please also have a look at section 179.
Powers of the board.
Yes, the board of directors of a company shall be entitled to exercise all such powers and to do all such acts, things as the company is authorized and exercised to do. And then there are whole lot of powers. So the entire right from designing putting in place the policy, internal controls, how the business has to be carried on is put in by them. Why this is stated so scattered across the Companies Act is there needs to be some responsibility fixing. There cannot be a situation when somebody says, it is not my responsibility. In this case, the one Mr. Thoratti, I think he was the financial director, he is one of the financial officers. He was examined. He said, no, there is no responsibility on me. So then who was the person who was responsible to check, who will check the KYC, who will check the documents, who will do the due diligence of onboarding of the companies? We do not know, it could be some terror funding, but have you done, at least when you onboarded, have you ensured that all those documents are available? Now, where the directors failed is noted in the investigation report. Now, may I take your lordship to directly to that part of the investigation report where there is a description of the failure of the two directors who are now before lordships.
Direct liability.
Yes, no, direct liability. Lord, the investigation report itself begins at page 108. The relevant part is at para 4.153 onwards.
108.
It begins at 108. I'll furnish the number. Paragraph 4.153 is the relevant of the report.
Report. 340.
Mm-hmm.
4.1. Basis of data received from
340. 340 is the reason. Role of the payment aggregator, 4.151. The COA had arrangement with 3 different payment gateways, aggregators, namely Razorpay, 197 communication, cash free payment. Out of the aforesaid 3 payment gateways, the COA had major transaction with Razorpay itself amounting to approximately 130 crore, and the total amount volume of transaction with Paytm was 62 lakh, cash free was 6.4 lakhs only. KYC documents pertaining to the COI such as incorporation certificate, PAN card, etc. submitted at the time of onboarding are not signed, unattested by any of the authorized directors or KMP of the COI. Also, it was noted that no board resolution was attached or submitted to Razorpay seeking to open any account to avail any such services from Razorpay. On review of other documents supporting submitted by Razorpay pertaining to merchants onboarding of the COI, it was noted that there was a copy of a tri-party agreement entered into between COI, Extend Financial Services, Razorpay itself. The said agreement was available in incomplete form. Only 2 pages were available, that too signed by only 2 parties. Later, when asked to provide complete agreement, Razorpay was not able to furnish any such agreement available with it. Mad Elephant was onboarded on the platform of Razorpay using the KYC of dummy directors of Mad Elephant, namely Rajkumar. However, once the MIDs were activated, the control of the MIDs were transferred to Chinese national and director of Mad Elephant, namely Ku Yangpeng. The director named Rajkumar mentioned in this statement had he never submitted a statement that he had never submitted or signed any of his KYC for the purpose of availing any kind of payment aggregator or payment gateway service in the capacity of the director of Mad Elephant, the signature on the KYC submitted is forged. Then, my lord, regarding the statement, there is a statement of the petitioner recorded at 4.15(7). And then there is, if I may take your lordship to page 344, there is the statement of that other senior director of risk management. His job responsibility is risk management.
341, I think, statement of
yes,
petitioner.
341, yes, 342 for to save time, I'll skip that now. And
yes.
The statement of the other person called Bhanu Chandrasekhar Authority is at 4.158 at page 344. He is the risk management director, and he at page 345. Page 345, he says, first bullet point, he is the principal officer nominated with FIU India, but for the said period, that is December 2019 to November 2020, he was not the principal officer responsible for the KYC checks or compliance in case of Mad Elephant. He is not aware of the statement given by Harshil Mathur, who is the other director. Then he says, Payment and Settlement System Act, which comes under the purview of RBI and RBI guidelines on the regulation of payment aggregator and directions for opening of accounts and settlement of payment for electronic payment system involving so and so are applicable to Razorpay. He concedes that they are applicable. And then 4.160, my lord, at page number 347. Section 21F of the PSS Act defines a payment system to mean a system that enables payment to be effected between a payer and the beneficiary involving clearing, payment or settlement service of or all of them, but does not include a stock exchange. Then next sentence, it is further stated by way of an explanation that a payment system includes the system enabling credit card operation, debit card operation, smart card operation, money transfer operation or similar operations. All systems carrying out either clearing or settlement or payment operation, or all of them are all regarded as payment system. All entities operating such system will be known as system providers, and Razorpay was one. Also, all entities operating money transfer systems or card payment system or similar systems fall within the definition of a system provider. To decide whether a particular entity operates the payment system, it must perform either the clearing or settlement or payment function or all of them. Basis the data received from Razorpay, statement of the CEO and the co-founder recorded on oath, and understanding of the object clause of Razorpay as well as the definition of payment system as per the PSS Act, it is clearly evident that Razorpay has provided.
It is against them. Yes.
Lord, so therefore, my lord, to answer the first limb, that there were the statutorily certain imposition of duties. These directors were required to ensure that there is a policy, that there are internal control systems, particularly for onboarding of companies which provide financial services. In this case, Mad Elephant, in association with Exten, was issuing loans. They were entering into financial transactions, and Razorpay offered itself as a payment gateway, as a financial conduit. Now, these directors, since the company is a legal person, it is only natural persons like the directors who can put in place certain system. And I read out to your lordship sections 134 and other provisions of law, including 166, which requires that these directors to put in place certain systems in place. In this case, our allegation is that those systems were not in place. It is because those systems were not in place, we have considered that they have failed to discharge their duties towards their own company, which is Razorpay.
Now, you left off all the other 33 companies?
No, but wherever we have found, we have prosecuted. Mad Elephant, we have prosecuted.
Mad Elephant,
wherever, because there we are prosecuting them for 447, which is fraud. They are not for 166. It is for fraud. So prosecutions have to be.
There are 33 companies, Chinese companies, what you said.
Against those whom there is clear evidence available, we have prosecuted. If we have not prosecuted anybody, we have not found evidence in the fraud. And moreover, my lord, there is no question of any negative equality here. I mean,
I'm not on that.
the petitioner has to. So therefore, my lord, to answer this.
Avarnyak bitpitidira anta.
I get it. Therefore, my lord, it is not, my lord, for Razorpay's failure that we are prosecuting them. It is for the failure of these two directors. being directors, they should have ensured that certain policies were put in place.
But is it not the company also responsible equally?
Maybe for something else, but this, my lord, these two directors were responsible. Now, a company does not get incorporated along with certain internal policies. Those policies are put in place only by the human directors, which is why the law contemplates that. Well, otherwise what happens is, if section 166, 2 and 3 are read as just governance ideals, then, my lord, subsection 7 becomes completely odious. They are not just governance ideals. They are statutory duties which is imposed. Not these days, directors exercise vast financial powers, in the sense there are companies which deal with public money. So therefore, putting in place policies which are effective, which are compliant with the legislations, for example, compliant with the Payment and Settlements Act, of 2007. There should have been compliance with that. There is no policy or internal controls which were set, and that is exactly what the risk management director says. He says, I was not the principal officer. Then who was the principal officer who should have verified that there was compliance? So there was nobody in that position. Therefore, my lord, it is a failure. Rest, my lord, all the special court has to investigate. It's a matter of trial. Issues like mens rea cannot be gone into at this stage. These are all settled positions.
Yes, all right. Heard reserved.
My lord, there is one written submissions that we have.
It
is ready. Give a copy.
One recommendation which was done in the report, my lords. Please notice a recommendation at page 352. The investigating officer, what he recommends at page 352. 5.1, my lords. That's a non-banking financial company. How to proceed against them. His recommendation. Now 5.5 is recommendation. Please notice there, my lords, the investigation reveals that there was negligence on the part of the payment aggregators, payment gateway. In view of the above, RBI may be recommended to take necessary action and strengthen the regulatory framework to be followed by, this is the recommendation. And when it comes to the banks, my lords, ICICI Bank, the investigation reveals that there was gross negligence in respect of KYC norms and sharing of confidential information of the customers with third party on the part of officials of ICICI Bank. Gross negligence, they're not an accused. So what they say is,
why have you left them?
5.6 may be
ICICI
noticed.
Bank, why have you left them?
All the bankers are left out. Only payment aggregators end, my lords, who come. 5.6 at page 353.
Okay. Maybe, my lord, it's a
Now, we are in the
No,
nature
when
of
they-
investigation that
based upon a particular report, you draw them.
Yes.
Based on the same report which projects gross negligence on other banks, you leave them. Why?
Not I don't have immediate instructions, my lord, whether they have prosecuted them or not, my lord.
No, they are not accused anyway in this.
His statement has to be verified, my lord. I do not have.
No, accused 1 to 9 ಅಲ್ಲಿ ಇವರಂತೂ ಇಲ್ಲ.
My lord,
they're not there.
I am not aware of any action taken, my lord. Maybe at this
No,
point in time,
why do you leave that?
maybe subsequently they have not found any material to proceed.
So this
ಅಲ್ಲ
is the report.
ರಿಪೋರ್ಟ್ ಮೇಲೆ ಇವ್ರನ್ನ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡ್ತೀರಾ, ಅದೇ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಬೇರೆಯವ್ರನ್ನ ಬಿಡ್ತೀರಾ.
Complaint is based on this report.
But I will get instructions on that. No, there is one aspect which I missed out. Would your lordship take up subsection 14 of 2 and 2? Subsection 14 of 2 and 2. Because my learned friend said we should have prosecuted only the Mad Elephant and other companies. On receipt, subsection 14.
I am there.
On receipt of investigation report, the central government may, after examination of the report, direct the SFIO to initiate prosecution against the company, its officer, employees who or have been in employment of the company. What follows is important. Or any other person directly or indirectly connected with the affairs. So these two directors, by providing the conduit services, were connected with that. But there are a couple of other important questions which my learned friend has raised. Which he has not argued. So therefore I'm not
limitation, obviously 6 months for you to complete it. 166.
I would like to, if he has not argued, therefore I am not answering. Limitation, I have in my written submissions, I have covered. Limitation, I mean, it is from the date of knowledge. From the date of knowledge, it is within limitation.
Date of offense to the date of complaint.
Yes. Date of offense to the date of
Three
complaint.
points, my lord. Number one,
Knowledge ಅಂತ ತಗೊಂಡ್ಬಿಟ್ರೆ
Knowledge,
20 years old incident yesterday I got to know
the
ಅನ್ಬೋದು.
time taken for obtaining the sanction, and moreover, my lord, it's a common complaint which is filed. So when a common complaint is filed, you proceed on the basis of the offense which has the higher offense, higher punishment. Anyway, I have covered those. And as far as the cognizance taking, my lord, the report filed under 212 is equivalent to a police report. So therefore, the Companies Act has got a built-in provision, so BNSS will not apply. The cognizance can be taken by the special court on the basis of the report filed by the SFIO, which is equivalent to a police report.
That's exactly what is considered in Paramjit Kaur.
True, Parvinder will not apply. It is that
Parvinder Kaur.
Sanjabij judgment would apply.
Parvinder Kaur. And in fact, in the order of
Sanjabij Tari would apply.
Malats, in the order of the central government permitting the investigation, very clearly they say, if you are investigating anyone else, get permission under 219. It is very clearly mentioned in the order itself.
It is covered. The sanction is given for these two.
I'm sorry, sanction is different. Power for investigation is different. 212 and 219 is power and jurisdiction to investigate. And they say in the order, if you want to investigate someone else, 219, take permission from us. That they don't do.
Yes. Not reserved.
When is it posted?
Whatever you want to file.
You given the.
What, madam?
We have given authorities as well.
ಅಲ್ಲ ಬೇರೆ
Now with you.
ಅವರನ್ನ ಯಾವಾಗ್ಲೂ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ.
When is it posted?
So since we had some time, Lordship adjourned from last week to this time, so we were fully prepared. So we have met all the 11 points which my learned friend has raised.
It's posted next on 27th.
Oh, 27th July. I'm aware. Yes. Before that.
And
That
one aspect, my lords, one
That's like
aspect
scoring.
on, my lords.
That's like scoring
And
15
also-
runs in 60 balls for your lords.
My lords, also on the aspect of the cognizance order, my lords, the cognizance order is not cognizance under 166 taken against me. Common for
Correct,
all.
it's a common.
That itself has to go. But the first point 212, my lords, which I pointed out, my lords, it should not aid the other persons in mad elephant. So that's why, even if it is not on that aspect of it, the other aspects, my lords, are there. Because if it is on 212, probably everyone will get benefited out of it.
Let me see.
Yes,
No, the examination and consideration will be only qua 8 and 9.
yes.
We are
8
not,
and 9, that's the
we are
reason.
not
Yes.
entering into other accused
no, my lords,
who are
my
alleged of fraud and other things.
That's the reason I just
The only consideration is only qua 8 and 9.
deeply obliged, my lords.
We'll see. Yes. 27th July ಅಲ್ಲ next.
Still in June.
ನಮ್ದೆಲ್ಲ ರಿಟರ್ನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಿ, my lords, whatever.
ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ?
ಈ ಕೊಟ್ವಲ್ಲ.
ಈಗ ಕೊಟ್ಟಿದ್ರು.
We have also furnished a list of authorities. You have mentioned it in the brackets.
Everything will be considered. Yes.
Deeply obliged.
ಇನ್ಯಾವುದಿದೆ? ASG ಅವ್ರದ್ದು ಇನ್ಯಾವ್ದಾರು ಇದೆಯಾ?
There is one, the DRDO, that dog issue.
Oh, madam is here.
Yeah.
Vaishali madam.
Lord, Lord, in this matter, let me quickly take your lordship through what the allegations are. Lord, please have a look at the complaint, page 21.
Now, what is your allegation?
Lord,
what is the allegation against you?
It's a one-pager complaint, Lord. I'll just read it. Page 21. I'm sorry, my lord, it is in manuscript. ಅಲ್ಲಿ ಮೂರನೇ ಲೈನು. DRDO ಫೇಸ್ 2ರ ವಸತಿ ಆವರಣದಲ್ಲಿ 3 ಬೀದಿ ನಾಯಿಗಳು ಸ್ಥಳಾಂತರಿಸಿರುವ ಬಗ್ಗೆ ದೂರನ್ನು ದಿನಾಂಕ 6/3/26ರಂದು BBMP ವಾಟ್ಸ್ಆಪ್ ಗ್ರೂಪ್ ನಲ್ಲಿ ಬಂದಿರುತ್ತದೆ. ದಿನಾಂಕ 7/3ರಂದು ಸ್ಥಳಾಂತರಿಸುವ ಬಗ್ಗೆ ತುರಿತು ಮರುದಿನ ಅಲ್ಲಿಗೆ ಭೇಟಿ ನೀಡಲಾಯಿತು. ಅಲ್ಲಿ ದಿನಾಂಕ 5/3ರಂದು 3 ಬೀದಿ ನಾಯಿಗಳು ಬಹಳ ಹಿಂಸೆಯಿಂದ ಕಟ್ಟಿ ಚೀಲದಲ್ಲಿ ಕಟ್ಟಿ ಬೇರೆ ಕಡೆ ಸ್ಥಳಾಂತರಿಸಲು ಪ್ರಯತ್ನ ಮಾಡಿದ್ದು ಗಮನಕ್ಕೆ ಬಂದು ಅಲ್ಲಿರುವ ಜನರು ದಿನಾಂಕ 5/3ರಂದು ಸುಮಾರು 11ರಿಂದ 12 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಈ ಕ್ಷೇತ್ರದಲ್ಲಿ 3 ಕಾರ್ಮಿಕರು ಪಾಲ್ಗೊಂಡಿದ್ದು ಅವರ ಹೆಸರುಗಳು ಗೊತ್ತಿರುವುದಿಲ್ಲ ಮತ್ತು ಅವರುಗಳನ್ನು ಕೆಲಸದಿಂದ ತೆಗೆದು ಹಾಕಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಲಾಗಿದೆ. ಮತ್ತು ಸ್ಥಳೀಯ ಸ್ಥಳೀಯರು ನೋಡಿದ 3 ಬೀದಿ ನಾಯಿಗಳು ಪುನಃ ಬಿಡುಗಡೆಯಾಗಿರುತ್ತದೆ. ನಾನು DRDO phase 2
ಪುನಃ ಬಿಡುಗಡೆ ಆಗಿರುತ್ತದೆ ಅಂದ್ರೆ ಎಲ್ಲಿ?
ಅದೇ ಏರಿಯಲ್ಲಿ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅಂದ್ರೆ they were trying to remove the dogs from that area.
So inside the campus of the DRDO,
Yes.
you wanted to get rid of these dogs.
Not me, not me. Some 3 ಅಪರಿಚಿತ ಜನರು. Some 3.
ನೀವಲ್ಲ.
ನಾವಲ್ಲ. The allegation is that 3 ಅಪರಿಚಿತ ಜನರು. In fact, I'll take your lordship through the affair. 3 strangers. And then the dogs are let off. That is what the complaint says. ನಾನು DRDO phase 2 ಭೇಟಿ ನೀಡಿದಾಗ ಅಲ್ಲಿರುವ ಆಹಾರ ನೀಡುವವರು 10 ದಿನಗಳಿಂದ 24 ಬೀದಿ ನಾಯಿಗಳಿಗೆ ಕಾಣೆಯಾಗಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. ಪ್ರಕರಣದಲ್ಲಿ ಕುರಿತು ಮಾಧ್ಯಮದಲ್ಲಿ ಪ್ರಕಟವಾಗಿರುತ್ತದೆ. ಬೀದಿ ನಾಯಿಗಳು ಸ್ಥಳಾಂತರ ABC 23 ನಿಯಮ ಹಾಗೂ PCA 1960 ಪ್ರಕಾರ ನಿಷೇಧಿಸಲಾಗಿದೆ. ಹಾಗಾಗಿ ಈ ಪ್ರಕರಣ ಕುರಿತು ತನಿಖೆ ನಡೆಸಲು ಹಾಗೂ BNS so and so ಪ್ರಾವಿಷನ್ ಅವ್ರು ಯಾವುದಾದ್ರು ಇವ್ರು ಹಾಗೆ ಅಚ್ಚಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಪ್ರಕಾರ ಕೆಳಗೆ ಕಂಡವರ ವಿರುದ್ಧ FIR ದಾಖಲಿಸಲು ಹಾಗೂ ಕಾನೂನು ರೀತ್ಯ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಮೂಲಸಿದೆ. ಅವರು ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಯಾರ್ಯಾರು ಅಂತ. The first one is our officer. The second one is our supervisor. The third one is unknown person. Based on this, the FIR is lodged, which your lordships will see. The FIR is under BNS 240. 240 is giving false evidence. There is no such allegation, the false evidence. Then next is 325, mischief by killing or maiming animal. There is no such allegation in the complaint. Then 270, public nuisance. Doesn't meet that requirement. Then 61(1), which is criminal conspiracy. There is no such allegation. And then section 11 PC Act, treating animals with cruelty, for which the maximum penalty is 50 rupees fine. So based on this, the FIR is registered. Now the FIR also notes that 3 ಅಪರಿಚಿತ ಜನರು. So when the allegation is against 3 unknown people, there is no question of vicariously making our officers responsible. So therefore, by application of the first subclause of para 120 of Bhajan Lal, on the face of it, my lord, the complaint does not make out a case against any of the accused. The 2 writ petitions before your lordships, who are the accused, there is no case punishable offense which is made out against them, even on a acceptance of the plain reading of the complaint, because it does not. It says 3 ಅಪರಿಚಿತ ಜನರು.
Now, what is this page 44?
I'm sorry. I'm sorry, not just one minute. Page 44. This is complaint by the. So my respectful submission is, Lord, there has to be an investigation. Animals cannot be treated with cruelty. All the legislations which apply, animals have equal right like human beings.
Correct.
They have to survive. But then that does not mean you prosecute an officer who is not involved in it. You please find out who those 3 unknown people are. Some people claim that they have taken video. The prosecution is free to find out who those 3 strangers are and let them be prosecuted. Why our officers who had got nothing to do with it? There is no question of vicarious liability.
Now, who gave the complaint to BBMP?
The BBMP officer, he's on the basis of hearsay, he has given the complaint.
One moment.
One can make out, my lord, his name is Biradara. Vivek Bidrakar anta. On the basis of some WhatsApp group communication, he has lodged the complaint. Lord, he himself says he came to know the complaint is based on hearsay by this Vivek Bidrakar. The incident is supposed to have taken place on 5th March 2026. He goes to the spot on 7th March. The basis of his complaint is a communication or discussion on a WhatsApp group.
No, you are drawn in to the web of crime only because it was the dogs were in the
yes.
premises of the
it is a large community. It is a large community. It's a DRDO township. In the township, there are stray dogs. Some people may have attempted to shift them. Now we do not know who they are. They are strangers to us as well.
Yes, madam.
And Lord, one more submission is that there is some intervening application.
No, don't worry about that. That has to go to the first court. PIL allied. There is not a PIL for public to intervene here.
It's filed as though it is a PIL.
No, don't worry about it. Yes.
Lordship, may kindly see.
They say that this is the DRDO, the Defense and Research Development Office.
On
And
merits,
they
madam.
say, yes.
On merits.
No, but they say, no, three unknown persons, the investigation, your lordship has permitted it to go on. This DRDO, we made the estate officer and the other officer as party. No one can enter the premises without an entry in the book. So are they saying that they did not know that who has entered all we have sought for from your lordship is let the investigation go on. No precipitative action against 1 and 2, even against those officers. But if at this stage your lordship were to quash this, then 100% it is like giving a clean sheet to those two officers. Tomorrow, even if they find something wrong against them, they will not prosecute them. So all we have said, no precipitative action against them. Let investigation go on. If tomorrow something was to be found against them, someone has to be responsible. This is, if someone comes into my house, an offense takes place, I can hardly say I'm not responsible. I
No,
do
that's
not know
all
what's
right. That
happening.
we'll see,
This is
yes.
the DRDO. Tomorrow, the same thing, if this were to be done, these kind of illegal dog catchers will go into every society, and the persons in charge will say, we do not know. They've come and taken the dogs and gone. On one breath, they say they should be treated with respect. If your lordship were to see the pen drive, even a person who is not a dog lover, it would melt his heart.
Who has
It
shot?
is
Who has
horrible.
shot that video?
The neighbors, and in fact, they are pleading with them to release them. In plastic packets, they've been dumped. Their heads have been hit. They're bleeding.
The dogs.
The dogs, it's all
But
there.
who has done that?
Those three
Who
dog
has
catchers
done
have done it.
Huh.
Where
Who are those dog catchers inside the DRDO?
Yes, that is what we want to know. The investigation has to go on. Their photographs have been produced. The
Hmm.
two officers who are, one is the estate officer and the person who takes it, the entry and exit.
Hmm.
They have to be investigated. Thereafter, once the investigation goes on and they find out who's what, let them take action as per the law. Until then, let precipitative action not be taken. That's all we have sought for.
State has to say anything?
Two things. One, my lord, your lordship, may I request your lordship to annex B, page 23.
Hmm.
This is the BBMP notice issued to the DRDO asking.
The BBMP notice.
Yes.
Asking
to
what?
DRDO, asking them to explain on what context the dogs have been captured and then dealt with it.
Hmm.
For that, my lord, the committee has been constituted by DRDO, which your lordship will find at Annexure C.
Hmm.
They are not denying that incident took place in DRDO. They're saying that we have not done it, and the dogs of DRDO employees are not missing. To substantiate this, my lord, they in fact, my lord, at page 31, complaints have been filed by the DRDO. Your lordship may see
To
the
whom?
dates, to the estate manager by the residents of DRDO. Your lordship may see the date of complaint, my lord, 14th March. This is after registration of case.
Oh. Hmm. The other one is 10th March.
Yes, my lord.
When was the complaint registered?
Complaint registered on 7th, the 9th March.
Hmm.
So the only issue, my lord, that the videographs are available, my lord. CCTV footages are exist. Your lordship can see that manner in which dogs have been dealt with. We are not saying that ABCD has done a crime. Somebody has done a crime. It has to be investigated. They may be tomorrow, may be witnesses. We are not saying that they are accused people.
Where do I get that CCTV footage or something? Yeah.
The photographs are
CCTV
produced.
is also there.
Photographs.
Photographs, some of the photographs are produced. Where are they? Annexure R?
Show that video.
R1.
Show that video.
And the, where is it? Where is it? Is there CCTV?
A tractor has came in and dogs have been put in plastic bag.
The whole idea was to suffocate them, and none of them have come back. 21 dogs with photographs I have produced. And where they be, if they've been relocated, let them tell
How
us.
does these dogs get into the DRDO?
They get in everywhere, your lordship. You go to the Freedom Park, there are as many dogs as
They have all freedom.
Yes, absolutely. God didn't make the world only for us.
Yes.
If
Lord, as
And
my
produce it
learned
in a
SP,
pen drive.
my learned friend SPP said, at best, my lord, these two petitioners can be witnesses.
We'll see.
They will go and cooperate with the investigating authorities in investigation.
It needs investigation.
It needs investigation. It needs
Absolutely
investigation.
needs investigation.
All that I'm
No
saying is,
doubt
my lord, in column number 6, if your lordship sees in the FIR.
We'll see what is your role as an accused or a witness.
Yes, yes.
But
So,
investigation is a must.
Against item number 3, that is those people, my lord, the unknown people,
Whatever it
investigation has
is,
to go on.
animal is an animal, unethical treatment to that.
I stand by it, my lord. All these, they have an equal right to live along with us.
Your lordship may keep the petition pending. Let the investigation happen. We may not even file a charge sheet against them if they have nothing to do with this.
Investigation ಆಗ್ಬೇಕು. So nobody will trouble you.
Yes.
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 Let the investigation go on. If you place the final report before it is filed before the concerned court to this court. And don't
No problem.
trouble them at all.
You will instruct me.
Yes.
Yes.
That is. ಅಲ್ಲ ಏನಾಗುತ್ತೆ ಕ್ರೈಮ್ ನೇ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಟ್ರೆ
No, my lord, my request also would be to quash it only against A1, A2. Let A3, let it continue.
ಅಲ್ಲ A3 is unknown person.
That is the
That
scope
is
of
why
investigation
investigation is needed.
True.
See,
No,
you if there is
A1,
any
A2 can be witnesses
ಅಲ್ಲ,
in
if
the investigation.
you are estate officers.
Yes.
See, if there is any statement to be recorded of yours, it will be recorded. You
No, my
cooperate.
lord, that even if the proceedings are quashed, I can still appear before the authority.
ಅದೇನಾಗ್ಬಿಡುತ್ತೆ ಕ್ವಾಶ್ ಆಗ್ಬಿಟ್ರೆ you will say, no, I cannot, I don't even cooperate. ಅಂದ್ರೆ nobody can tell you are bound to do it ಅಂತ. ಅದಕ್ಕೆ now I'll direct that there no coercive, no precipitative action against these two. A3 you find out who is it and continue the investigation, file the final report before this court. I'll grant you 6 weeks time.
Very well.
We will finish.
That should be enough. The will pass in order. Yes. ಈಗಲೇ ಮಾಡಿ. The petitioner, but ನೀವು ಹಾಕಿರೋ ಸಿಕ್ಕಿದ offense ಎಲ್ಲ ಹಾಕಿದ್ರಿ ಯಾವುದಕ್ಕೂ applicable.
May not be correct. We will. That,
What is this?
I understand.
False evidence ಏನ್ ಬಂತು, maiming, have they done that? Public nuisance ಏನ್ ಬಂತು?
Conspiracy.
Conspiracy. ಏನ್ ಬೇಕಾದ್ರೆ ಹಾಕ್ಬೋದು ಅಂತ.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರಂತ ಆ ಕಂಪ್ಲೇಂಟ್ ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ಇವರು ಅದನ್ನೇ ಅಚ್ಚಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes.
I will take care of that. Your lordship.
The petitioner, two estate officers of the Defense Research and Development Organization, stand at the doors of this court, calling in question registration of a crime in crime number 153 of 2026. Registration of the crime has sprung on a very strange circumstance. A sprawling campus of the DRDO in the city of Bangalore witnesses certain stray dogs in it. The stray dogs were to be taken away, not by the estate officers or by any of the officers of the DRDO. It transpires that on a particular day, i.e. 9/3/2026, three dogs ಮಾತ್ರನಾ ಇಲ್ಲಿ? 3 or how many?
Yes.
No, wait.
Three were released back. We are saying 21.
Totally about 21 dogs, which are termed as street dogs, were taken away. Anything?
Missing ಅಂತ ಬರ್ದಿದೆ ಸ್ವಾಮಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ 21 dogs are missing.
So and so. 21 dogs which were on the streets of on the interior inner roads of the campus hyphen of the DRDO went missing. Went missing was the complaint registered, but it transpires that they were taken away in an unethical manner and they are not found.
No.
And are not to be found even today. Therefore, the case is of 21 missing dogs which are not found not found even today. The estate officers, petitioners in the case at hand, were drawn as accused along with accused number 3 depicting the said accused to be an unknown person which was requiring investigation. At that juncture, the officers are before the court. This court had granted stay of further investigation, which has led to filing of the application seeking vacation of the interim order. The learned counsel for the learned ASG, Shri Arvind Kamath, would take this court through the crime so registered and would submit that the offences alleged against these two estate officers, to say the least, is preposterous. For the reason that the learned ASG would submit that false evidence as obtaining under 240, maiming of animals as obtaining at 325, public nuisance as obtaining under 270, and criminal conspiracy as obtaining under 61(1) of the BNS cannot even remotely connect to unknown acts of these petitioners. Be that as it may, the learned ASG would also submit that investigation is necessary as to who came into the DRDO and took away the dogs and what is the state of the dogs today. Therefore, would submit that the petitioners cannot be held responsible for what has happened to the dogs. Per contra, the learned counsel, Srimati Vaishali Hegde, appearing for the BBMP, would refute the submissions in contending that none can enter the campus of the DRDO without permission. Therefore, who entered, who took away the dogs, and where are the dogs today is a matter that would require investigation. This is what the learned ASG would also submit. The learned SPP would contend the crimes so registered may have been erroneously drawn by the police, but investigation must be permitted in the case at hand as to what has happened to the 21 dogs. 21 dogs that were in the campus that were last seen in the campus of the DRDO and have become unseen today. Therefore, in the light of the submissions, contra submissions, and the submissions of the SPP, I deem it appropriate to permit investigation in crime number 153 of 2026, not for all the offences that are loosely laid, but offences that would really come about, that would truly come about on investigation. The petitioners who are the estate officers of the DRDO shall not be harassed nor coercive steps taken against them on whatsoever ground, but they will cooperate with the investigation in finding out or in helping the prosecution to arrive at the truth. The investigation report of such investigation will be filed before this court before it is filed before the concerned court, and on permission being granted by this court would be placed before the concerned court. The period of investigation, the investigation shall stand complete within 6 weeks. Within 6 weeks from today. 6 weeks between date. That should suffice. August 1st, 6 weeks, fine. List the matter on August 11th at 2:30 p.m. for the hearing. August 11th. That should be enough, SPP.
Yes.
85, na? ಏನ್ ಮಾಡಿದ್ರಿ? ಆಯ್ತು. ಇಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಮುಗಿಸ್ಬಿಡೋಣ ಒಂದೇ ನಿಮಿಷ ಪ್ಲೀಸ್, ಇಲ್ಲರೆ ಕ್ರೌಡ್ ವಿಲ್.
48 ಪಾಸ್ವರ್ಡ್
ಯಾಕೆ ಇರಿ ಇರಿ. ಎಸ್ ಸೂರಜ್, ಸಾರಿ ಸೆಟಲ್ಮೆಂಟ್. ಎಸ್
In this matter, I don't know what settlement they are.
Serial number 80, my lord. In this, all these batch of matters, my lord, for non-payment of PF, my lord, was the issue. We have paid the entire monies, my lord. We have settled the dispute with the
That doesn't
persons.
absolve them of the offense which is already committed.
madam.
In all matters,
ಕೊಡಿ.
produce the memo also, my lord.
The satisfaction of prosecution, what do you get? Ultimately ದುಡ್ಡು ಹೋಗ್ಬೇಕಾಗಿತ್ತು, ಅವ್ರಿಗೆ ಹೋಗಿದೆ.
And in the earlier occasion, your lordship has quashed the
Correct,
proceedings.
I have quashed the proceedings.
Yes, ma'am. Yes.
ಅವ್ರು ಕಾಪಿ ಕೊಡ್ಬೇಕು ತಾನೆ ಮುಂಚೆನೆ.
ಅದೇ ಈಗ ಕೊಟ್ಟು
ಏನ್
ಈಗ
ನೀವು?
ಅವರು ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Madam appeared, my lord.
ಮೇಡಮ್ ಬೇಡ ಅಂದ್ರ?
By way of 2 DDs, my lord, we have discharged the entire liability, my lord, 81 lakhs 86,000.
Why you did not pay earlier?
But in fact, my lord, we were still under the impression, my lord, and we still are that we have paid excess PF, but my lord, to settle the dispute, we don't want to drag it further. We have paid whatever is due, my lord, because it is harming our company's reputation also, my lord.
If there are any other dues, madam, you can proceed. I'll reserve liberty. The petitioners in these cases, all these cases arise out of the proceedings instituted by the respondent for non-payment of dues of the employees, non-payment of provident fund dues of the employees. During the subsistence of the proceedings, it transpires that the entire 81 lakhs due that was there has been cleared by the petitioners. In that light, it would be even if the proceedings are permitted to continue, it would be an exercise in futility bearing no utility, for the reason that it would end in acquittal. In that light, wherefore I deem it appropriate to obliterate the proceedings in the light of.
End up in acquittal basically, because if it is proved, then they will be prosecuted.
What is proved, madam, ultimately? So and so, the learned counsel appearing for the respondent, Srimati Nandita Haldipur, would submit that if there are any other dues for the employees pending, then the court must reserve liberty for revival of the prosecution. They said liberty is always available. They said submission merits acceptance. For the aforesaid reasons, the following order, allow obliterated. Liberty is reserved to the respondent department to get the proceedings revived. The proceedings would get automatically revived if the authorities would find that the employees are short paid or there are any other dues to be paid.
Deeply obliged.
Grateful.
So it's listed for reporting settlement, my lords.
It is listed, sir.
Lords, we did not move any memo for settlement, my lords. Neither have we got any instructions from.
Interim order idea?
Please, my lords. Interim order ಇದೆ. ಎರಡಲ್ಲೂ ಇದೆ.
List the matter after 4 weeks. Interim order subsisting will continue to the next date of hearing. Remove it from the status of reporting settlement.
Grateful,
Yes.
my lords.
Appearing for petition.
Agil settlement ilva? List
We'll
after
take
4 weeks.
We will take
Yes.
instruction from parties. Ma'am.
Next.
Please.
My lords, it is settled, my lords.
Offense in.
498, my lords.
All right.
In
Yes.
family court, divorce is
Aye,
granted.
Right.
Great, man. There are 2 petitions connected. There are 2 petitions.
Right. Yes.
Before let the senior counsel start, my lordship, please see this document.
Kodi. Digital arrest.
But after the last hearing date,
ಈಗ ಇದು ಡಿಜಿಟಲ್ ಅರೆಸ್ಟ್ ಎಲ್ಲ ಕೇಸ್ ಜಾಸ್ತಿ ಆಗಿ ಡಿಜಿಟಲ್ ಅನ್ರೆಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
Lords, I just wanted to say this, my lords.
ಅದೇನ್ ಸೀರಿಯಸ್ ಆಗಿದ್ದೀರಾ?
We are very serious about this. I'll just no atarana ಇಲ್ಲ atar ಏನಿಲ್ಲ.
150 cases of the same bank. They have to be.
Lords, I'll just indicate this, my lords. We have taken the data from across the country. In how many cases the personal loans are utilized by the parties? More than 98% of the cases are those cases where they have taken the loan, they have paid the monies. Some cases, 0.62% of the total number of the cases where the loans are obtained, there are grievances or allegations of the kind. That means out of 100 people, 99 people or 99.5% of the people are those people who are getting the benefit of this loan transaction. The reason why we are telling this is, if something is so beneficial to the larger section of the society who are utilizing this,
These trivialities should be ignored.
if there is some possibility of a misuse, then we should also stand guard. Now what we have done as a bank, what we have done, two things which we have done. By default, they are under option 1. Option 1 is as what your lordship said, the bank account transactions are locked. If he adds a beneficiary, he cannot transact till the 24 hours. All these options are available in option 1. This they are entitled to waive because the terms and conditions is available when they click this option. From option 1 to special option, when they click the option, then this restriction is not available. Then next what happens? Now we have a software called as Falcon in our system. Falcon anta one software ide. The moment any person adds more than 2 beneficiaries in a given account, automatically Falcon blocks the accounts from transacting automatically. Then there is a standard operating procedure. These things keep happening because there may be people who may be transacting with multiple people. So after the adding of the beneficiaries, the accounts will not be opened till such time there is a customer call. Either we will call them or they will call them. After taking the credentials and the purpose, thereafterwards the bank accounts are released. This is the standard procedure. But if you go by the percentages with which this is being done, hundreds and thousands of people are getting benefited by virtue of this personal loan. They are making use of it because salaried class, my lords, by the end of the month, we have seen from the data, the highest personal loans which are being taken is by the end of the month. And next month, in the next 2-3 months, they are clearing the loans. This is how we are seeing the transactions. But if your lordships, my lords, we are also having concern, my lords, in the manner in which it is being done. As long as, my lords, in the usual course of the banking business, this is essentially, my lords, how it happens in every bank. There is no exception to it that there is only one bank which is involved. Every bank account, my lords, is subjected to the same options. The very same kind of procedures are followed with every bank. My lords, if the RBI comes in, the reason why I made the submission on the last occasion is only for this reason. If for any reason the RBI is to be made as a party, and if they come out with some remedial measures as to how they want to regulate this to handle this digital arrest, then it's a different matter because it's a matter of social concern. There's a larger public interest which is involved because the number of this digital arrest cases or the digital fraud cases is increasing day by day. But of course, I am told now, my lords, that it is on the decline after some time. It's
because of a particular reason.
Yes, now it is on the decline.
Your Lordship may see the table, my lord, which are given. This is the cases which my learned friend has given last time. The first table, my lord, the occurrence date, your Lordship may see.
18/12/2023.
The first one.
Ide?
Oh, occurrence date, my lord. 6/12/2023.
Oh, 6/12/2023.
And the loan has been granted between 8:59 AM to 10:45, and loan has been disbursed. It's also loan.
Loan transaction.
And next page, my lord. This is on 25/4/2024.
So all are loan transactions.
Your Lordship may see that.
But user location Cambodia yake?
Because that's where the IP address has been originated.
Where the
all the
fraudsters are located, my lords. Cambodia, Laos, and Myanmar. 3 countries are where all these scam compounds are located. Where
even in Estonia.
Estonia also.
Early senior mentioned it. I think
even in India for that matter, my lords. Even
also
in West Bengal, people have been captured.
My lords, I have a concern because something which should really concern me, lords. All persons who have stakes in the matter should really be concerned with this issue. And my lords, I have produced the RBI notification, which specifically provides. This is not the only bank. Every single bank is authorized by the RBI to extend his personal loans based on the banking transactions of a concerned customer. And most of the cases, now your lordship is coming across the cases which is less than 1% of the total number of cases throughout the country. That's the data which we have collected. Now what is happening is, if 100 people are getting benefited, the 101st people getting defrauded, the benefit of this should not be taken away. But if the RBI wants to regulate it, no difficulty.
Athara nodidre 498 statute book in ತೆಗೆದುಬಿಡಬೇಕು.
No, that's the reason why I said, my lords, your lordships have been standing guard.
Law being misused does not make the law bad.
Not bad. That's the reason why I said, my lord, whatever we have done, whatever we are facilitating is for the good. Everybody is utilizing it. Especially I had indicated, particularly the salaried class, the salary accounts and all. This is what we find classically in the salary accounts. In the salary accounts, at the end of the month, there is a withdrawal of a personal loan. They apply it and they take it. They get it into their account and they spend it. Of course, the next succeeding months, they are paying it.
May I submit?
Something like a credit card, they are using it. No, it's everybody. It's something like which is being used very frequently by everyone concerned. But 1 or 2 persons, who might have suffered the injury of the kind, definitely raises a matter of concern. But RBI has permitted this.
I have given a list of about 150 similar cases.
We'll see what the SPP also has learned. SPP also has given.
32 cases I myself have given, which are of the online pre-approved loans.
No, correct. That is on-rate pre-approved loans. That is, as they learned senior counsel, out of thousands and thousands of.
Here, every one of the ones that I have given, my lords, pertain to ICICI Bank. One time it happens to me. What am I labeled as? Foolish?
No, we'll direct the bank to bring in some measures that would control all this.
Millards, we have no difficulty to do anything now. The challenge.
But Suraj,
They can't.
to attribute fraud is a little difficult.
No, my lords,
See, it is a transaction. It is not you alone who has availed this loan. As I said, thousands have availed this loan of immediate release of funds for purposes that are needed. Then if you are, they have to plug in the loopholes. That does not mean that scheme itself should be taken away.
In one financial year.
One thing we have come out here is this is not a case of typical digital arrest.
One financial year, 14 lakh customers have availed this facility. 14 lakh customers have availed this facility. Maybe about 200, 250 people have suffered this kind of
This is not a typical case of digital arrest. It is only digital unrest.
If I may submit, there are two types. One is that where I have funds in my account. The second situation is where people have made to take a loan and then transfer it to the fraudsters. The fraudsters sitting in Cambodia, are playing fraud. But,
no, let us see.
But for them to do.
Now, one more thing. This investigation is needed. It's a different thing. But investigation not for his loan. Where these fraudsters sit in Cambodia, Estonia, or Myanmar, or whatever it is, alleged fraudsters, their IP address is projected in the bank. When that IP address is seen, is there no mechanism that the the transaction would not go through?
We will not get the IP addresses, Millards. What happens? The accounts which they are giving, these accounts are local accounts.
No, accounts may be local accounts.
IP address we will never get.
When internet protocols come, that is the IP address comes.
Never get. Millards, the transaction is only between me and the customer. The difficulty is, me and the customer, we are the only people who are interacting. We are the only people who are shaking hands. Now, if he tells
digitally
we are shaking hands. Millards, there is something called as Reserve Bank of India Digital Lending Directions of 2025. Millards, this is dated 8th of May 2025. After all these things took place, RBI has directed how it should be done. Millards, in that chapter 3, conduct and customer protection requirements. Now the only question is whether we have done this, because RBI has passed some guidelines and regulations similar to what we have done. Option 1, special option, Falcon software, where we block it the moment there is more than 2 beneficiaries added. Whatever is required in terms of this, we have also produced the notifications of the other banks, including the nationalized banks, where it specifically says that this is the manner and mode in which the personal loans will be disbursed. And as a matter of fact, this digital adjust, of course, enough and more materials have come out. The bank website, the moment they look into this, we can demonstrate. There is one pop-up message which comes up saying that beware of digital arrest.
That is now, not in 2024 when this happened.
No, he is not.
All of these.
You have not seen the pop-up.
Have you seen the pop-up?
Program itself is in 25.
I've seen different pop-ups.
What this pop-up? Program itself for digital arrest is 2025.
Page 62, Millards, is the.
Yes.
Page 62, Millards, is where we have produced this. That's all said and done. We are cooperating because we also have concern. Certainly the bank is also concerned with the fact that we should also not become subjected to these kind of litigations. We are running banking business. We are not coming here for the purpose of litigating against them. But now, if a person subjects himself to this circumstance, he cannot come against the bank and say that don't recover the money.
No, that can't.
That's essentially, my lords, what we are telling.
See,
My lords, for everything we are ready
Sir,
to cooperate.
1 minute, the money, 1 minute, the money is sent to your account,
Yes, please.
correct? You have given it to someone else?
I have not wanted to take the loan. I had no need for the loan. I am
Why
doing,
did you take it?
I am doing everything under digital gunpoint, my lords. Absolutely everything is not under my control, and that I am covered by decisions. Already it's.
Sir, decision is on the facts.
Allah, the decision also says that coercion can be by a third party, need not be by a party to a contract. That's what settled law 110 years back, not today. The Contract Act, my lords, is 1872, my lords. In 1918, my lords, the full bench of Madras High Court would hold. That is then followed subsequently also.
That coercion is different, sir.
Allah, any sort of coercion, lords. This,
No.
This essentially, my lords, is a situation of coercion, my lords. I am coerced into taking a loan, which I don't want. I have no need for. I am basically being punished for my good record. I have a good record. I am entitled to a pre-approved
Very
loan.
good defense, my lords.
No,
Section
no,
27.
no.
He can go there.
No, it's
Very
a
good
void
defense.
contract. It's a void contract. I don't need to go and defend myself. They have to go to civil court and
I'm so
initiate
happy that
recovery
under section
against-
482 your lordships will start declaring contracts as void. We welcome this move actually.
No, my
I
lord may see
appreciate-
it, my lords.
This is the kind of law which we
1
also
minute.
want.
If this submission of yours is seriously taken note of,
Yes, please, my lord.
now they have to go before the civil court and establish that it was not under coercion, then start recovery of loan. I think we'll be opening Pandora's box.
No, my lords. My lords may just take Contract Act, my lords.
Anyway, those are rudimentary principles. Don't try to.
Allah, if I may just reiterate
If
the
he,
difference
if he
between-
points out a judgment
You
saying
need
that
not tell
when we
this
are
court,
contracting.
you
between-
need not tell this court the principles,
I
which
understand.
principles are too rudimentary.
I understand, my lords. I understand. Allah, why I'm saying it is in terms of the decisions as well. I just pass that on.
Even decisions, sir.
I may just point it out.
On a concept that is too rudimentary, you need a decision to explain that.
No, but it is specifically disputed that a third party cannot vitiate my contract between you.
We'll see.
Very well can.
We'll answer your digital arrest thing, but could you SPP, sir?
My lords, I even wanted to say this, my lords, under the Contract Act, if at my instance somebody threatens, or by virtue of a threat which is administered, I get the benefit. That in such circumstances, it has been said, my lord, that coercion can be taken note of. My lords, judgments 4, 5, and 6, which I have already given, my lords, along with my memo of citations, I have marked the relevant paragraphs. Of course, this India, State Bank of India versus Vallabh Chaumukh, my lord, Baumukh has been referred to, my lords, in these three judgments, where it says that these are all the things which is, because this is not something where he is requiring some investigation in a particular manner. If he has a complaint, let him seek for investigation, no difficulty about it. He has got an investigation to be done. He coming before the court and say that I was subjected to a digital arrest, therefore don't recover money from him, my lords, is having far-reaching consequences. We are entitled to recover the money from them. And at the most, it's a defense. He has to go and establish it. It's a matter of fact which he has to do this.
We'll see. We'll answer all his.
Well, one issue I think your lordship may notice that all these things, a loan has been obtained, transferred within 2 hours, 3 hours, maximum 4 hours. I think your lordship may have to.
By whom? By the bank?
No, bank is
Correct. How though?
Bank has dispersed the loan to the.
No, if there are thousands and thousands of beneficiaries to that.
14 lakhs.
No, what I'm saying, Lord, is when this short span things happen, maybe bank should report.
No, we'll see. We'll try to.
In fact, my lords, I've given a note today, my lords, which is the lapses of the bank specific. Which clearly point out.
No, they are not accepting that they are perfect. They are also evolving procedures to curb this menace.
Going a step forward, my lords. I'm saying they are
Lords,
equally culpable.
we are
in
running
this.
a business.
I do it one
We are
time.
having a. You hear, buddy.
Allah, here I am called negligent, I am called foolish, I am called all sorts of.
Foolish ಅಂತೇನು ಹೇಳಿಲ್ಲ.
I took offense to that, my lord. Then my lord said, not you, my client. So in such a situation, my lord, I am called all sorts of adjectives. That's the first time such a thing is happening to me. The bank repeatedly, I am not the first, my lord, I am not the last. Repeatedly, the same thing has happened to the same bank to their customers over and over again. What have they learned from it? What have they done to stop it from happening to me? When my transactions were being stopped, when the first 5 transactions were stopped, my lord, why did they then allow the 6th transaction in 13 seconds? In 6 years, I've never taken a loan. In 6 years, I've never had transactions above 1 lakh, 2 lakhs. Suddenly, in the same day, multiple transactions are 20 lakhs. How do you allow it? RBI mandates that banks should monitor transaction velocity. This, my lords, is entirely contrary to my velocity for the last 6 years with that bank. They have my entire history. Straight away, there should have been a red flag. Stop me from doing it. At any point at that time, my lords, there was absolutely no digital arrest, this thing, my lords, campaigns, etc., in 2024. Today there is, 2025 onwards there is. There was no customer awareness in 24. That's when it all started. 23 and 24 is when this whole thing started, my lords, and which is why Supreme Court took cognizance suo motu in 25. October 25 is when Supreme Court for the first time raised it. Just before that, the Rajasthan division bench took suo motu cognizance.
We'll see. Yes, we'll answer all your
150 FIRs of ICICI Bank, my lords. ICICI in Bangalore that I know of. I'm not even a police or a prosecuting agency, my lords.
Where did you get that info?
Online, my lords. Just on an FIR search, I've been able to find so many. If the police digs deeper and gives the retired, it must be in thousands, my lords, for all we know. Out of that, 32 are loans.
We'll see. We'll answer all that.
My lords, they are not the cases of digital arrest, UPI frauds. Because there are multiple types of frauds which has come up, where the money may be transacted.
No, we may or may not look at it in the angle of digital arrest, but something has to be done. Will.
Lords, no difficulty, my lords, it should be done. As a matter of fact, of course, lords, if the person has been subjected to digital arrest, then he has undergone this process. This is not the first case where somebody has done this. In every other case, where there is a digital arrest, this has been undergone. So far as the bank is concerned, the bank takes all unreasonable care. So now what is that all unreasonable care? Everything is given to the control of the customer. I just wanted to say this. He may say that there is a continuous duress and so on and so forth. Everything is given to his control. Now, what is the further thing which we do is, we give a call to him, or he has to give a call to us to ensure that his account gets activated because he has added multiple beneficiaries. We have the conversation, which we will definitely part it when the investigation is being conducted, where he says, this is for property transactions. I am adding these beneficiaries. Please activate. We activate. We have asked him, what is the purpose? Now let us assume, my lords, that I don't do this. Now the personal loan is disbursed. He is in dire straits. He has gone to some place. He does not have money. He does not have a credit card. Personal loan he applies. Immediately we have credited into his account. He has gone with his girlfriend and he wants to make a bill payment of 5,000, 6,000 rupees. We don't release the money because we say that no.
How do you know he has gone?
I'm just making a submission, my lords. Then every customer who is beneficiary of such kind of transactions will be put to hardship. There may be 1 or 2 such cases, my lords. As I submitted, 14 lakh customers in one single year have availed the benefit of the personal loan.
Let's see.
My lords,
We'll answer
just see
it.
one question. My lords posed to the bank last date. 24 hours early, how did you allow more than?
I've given the answer.
That we'll answer.
I've given a document from their own website. Just 1 second, my lords.
Ivat kottidira.
Ivat kottidini note jete.
Then kotra namgu kotra.
Nimgu kottidini sir. 1 page note ide. Lords may take document 1. This is their own FAQs. This was printed yesterday, my lords. How much can I transfer in the first 24 hours after adding a payee? I come under general banking, my lords. I'm not a privileged banker. I'm not wealth, global, private, so and so. 1 lakh. This is their own website.
1 lakh. Privilege 2 lakhs.
Privilege 2 lakh. The highest is 10 lakhs in any case. Here 20 lakhs is allowed within 46 seconds and 13 seconds. Last one, iMobile app activation 10,000.
That's what I had known.
Exactly, my lord.
Lords, that's the reason why I said he is producing what is convenient. Everything is available. If he has clicked the website and found what is the facilities, I'm just saying this, what are the facilities extended in the special option, the submission he would not have made. Something he is telling less more than what he knows.
He's telling less more than what
he knows.
Oh, I've understood less more than what, sir.
Thanks. Please, my lord. Great.
My lord, may see those 2 decisions of the Madras High Court.
We'll answer
which
it. Yes.
Specifically says even third party can induce a party to contract, and that can also be vitiated for coercion. So the legal aspect of whether I can be liable for a contract between the 2 of us, where they have not the ones who played or coerced me, that, my lords, is already answered. That also, my lords, 528, my lords, is it's made for a case like this, my lords. Entirely, this would be an abuse of process to permit a victim to further be victimized by allowing recovery proceedings in a quasi-criminal case.
We'll see. Yes. Reserved.
Interim order may be.
Interim order will continue to the disposal of the petition.
Obliged.
SPP ಅವರು ನೀವು ಕೊಟ್ಟಿದ್ದು ಇಲ್ಲೇ ಇದೆ. Yes.
Only talks about time gap.
233 ಇದೆಯಾ? ಹ್ಮ್. Is in judicial custody?
Yes, my lord.
Oh, this 69.
Yes.
Promised to marry.
My lord, I have
You're
taken.
marrying?
Yes, my lord, I have taken undertaking from this accused number 1. Yesterday I went to the prison and
But how old is he?
19 years.
I wanted to verify that the girl's age. She's
present.
She's
Girl is there only.
No, I verified it, Mother. She's also.
20.
Date of incident,
Date of incident?
she was 18 years.
18 years. We'll release him from prison now. We'll stay this, release him from prison and marriageable age bandaga ಮಾಡೋಣ. The petitioner is before the court. How many accused? Obrena?
3 accused, my lord.
Why father and mother is there?
Illa illa, mother and aunt.
The petitioners accused 1, 2 and 3 are before the court calling in question registration of a crime and crime number 201 of 2026 registered for offences punishable under section 69 inter alia. The accused number 1, a boy of 19 years, is now in prison. The reason is that he was in love with the complainant, who is also 19 years. Therefore, this the love between the accused number 1 and the complainant has landed the members of the family as well under the vortex of crime. The petitioner, the petitioner and the accused number 1 and the respondent complainant have now approached the court on the score that they were in love and they are willing to get married to each other. In these circumstances, whether the marriage would be permitted or not in the light of the boy being 19 years old would be considered at a later point in time. There being no act of the petitioner accused number 1 of sexual assault upon the complainant and it being consensual relationship of both 19 years old between the two, I deem it appropriate to stay all further proceedings in crime number 201 of 2026 and further deem it appropriate to release the boy of 19 years from prison, who has been now taken into judicial custody on account of the offense punishable under section 64 and 69, which would be rape and sexual relationship on the pretext of promise of marriage. As a boy of 19 years in prison would be more dangerous than being outside. More so in the light of the fact, as observed here and above, that he has not indulged in anything except falling in love with the complainant, who the complainant who is present before the court also endorses that they were in love with each other and are wanting to get married. In that light, the registry of this, in that light, further proceedings shall remain stayed. The registry is directed to communicate to the prison authorities through electronic mail for release of the petitioner for the release of accused number 1 from judicial custody without brooking any delay. The marriage or otherwise on the settlement would be considered on the next date. List the matter on 29th at 29th July. My lord, charge sheet also has to be stayed. All proceedings in CC so and so. Charge sheet ಮುಂಚೆನೇ ಹಾಕಿದ್ದೀರಾ?
ಈಗ ಒಂದು 3-4 days back they have filed.
ಎಲ್ಲಿದೆ CC?
We'll file. It's here.
ಕೊಡಿ.
Please.
Proceedings in crime number so and all further actions taken thereto, including proceedings in CC so and so, shall remain stayed. The boy accused number 1 shall be released from prison forthwith. Amal Bariri to be communicated by electronic mail to the authorities to enable his release.
Please.
P21st, it could not have been an offense at all.
ಯಾವುದು?
Age of 21st. It could not have been offended.
That's what, ilwala. Then I have to permit them marriage of underage. Yes, marriageable age is increased now. We'll see.
Much obliged.
Yes. But your undertaking is here, madam. The boy escapes ಆಮೇಲೆ
ಇಲ್ಲ my lord. I have in the
ಅದಕ್ಕೆ ಕ್ರೈಮ್ ಇನ್ನೂ ಇದೆ, ಸ್ಟೇ ಆಗಿದೆ ಅಷ್ಟೇ. Yes. Further hearing, yes. List on 30th at 30th July at 2:30 PM for further hearing. Yes.
My lord, the offences are
madam.
329, 189.
Sorry?
The offences, my lord, are 329 and 189 of the BNS. That's unlawful assembly and criminal trespass. My lord, the
Suit pending
complainant.
ಇದೆಯಾ?
Yes. The suit was after the complaint, my lord. I just want to explain to your lordships. There was an agreement of sale that was entered into in the year 2024. We just requested the complainant to act upon the and to register the agreement of sale in our favor. And we've also deposited about 10 lakhs with the complainant. The refusal to, she wants us to be vacate the premises. So therefore this complaint is filed. Your lordships may see the complaint, my lord, at page 19.
One moment, madam. Page?
19, an extra B, my lord. Incident of 27/12/25, my lord, she
Yes.
herself says approximately 15-20% forcefully entered into the premises. And the next page, my lord, page 20, I suspect the following persons may be involved, and she names only these 4 people, the present petitioners before lordships.
These are the persons with whom agreement of sale is entered into?
These, my lord. They're the plaintiffs in the suit, my lord.
And plaintiffs in the suit.
These, my lord.
Heard the learned counsel. The petitioners accused 1 to 4 are at the doors of the court calling in question proceedings in crime number 25 of 2026. The fulcrum of the allegation is, the backdrop to the allegation is an agreement of sale being entered into between the complainant and which all the petitioners and the accused number 1. The agreement is not taken to its logical conclusion. Therefore, the complainant institutes a suit even, albeit after the registration of the crime in OS 2849 of 2026 against
Petitioner institutes the suit. The petitioner.
Petitioner.
Yes.
The petitioners institute the petitioners institute a suit in OS 2849 of 2026 against the complainant and others, be that as it may. In the complaint, the allegation is that about 15 to 20 people barge into the building premises and have indulged in ingredients of the offences so alleged. Contradictory statement is made in the very complaint that these petitioners are the ones that are involved. It cannot be lost sight of the fact that the petition for accused number 1 and the complainant had entered into an agreement of sale which has become the subject matter of the suit. In that light, further investigation qua these petitioners shall remain stayed. Yes. I heard so. Yes. Next. One HCGP, 2 emergent notice, returnable by the 16th of July. Yes.
This is a case where I file a civil case, get an injunction order. There is a violation of the injunction order by the respondent complainant. We file a miscellaneous case. In the miscellaneous case, specific direction is issued to the police, the same police, saying that they should be allowed to access the lift and all the facilities which we are owners of. The respondent and her family used to be originally the owners who developed these houses and sold it to us. They were creating problems in full enjoyment of this property. It is at this stage only.
79 is the offense under 79.
Please, my lord, what has happened is kindly see the background. See page number 70, my lord. Page 70. 69 is the relevant page. in this very complainant is a party and she has been issued directions by the to the Girinagar police saying they should be allowed to use the lift. What she does is she names everyone in an omnibus case and files this.
Lift,
Clearly a case of abuse of power.
lift usage problem.
Lift use. And constantly pestering them. You're not able to live peacefully.
Staircase ilva?
No, 5 floor ಇದೆ.
ಎಷ್ಟಿದೆ?
5 floor ಇದೆ.
How old are you?
My lord, it's not just one, my lord. There are people aged, kindly see, my lord. There are people older than me. There is
Others, if you go up and come down, you'll be healthy.
my lords, this is I have owned the property. I'm not even a tenant. I am the owner. I have got the right. I get a miscellaneous order specifically against this respondent. And because we get that order, she cannot bear this and she files this.
Heard the learned counsel, Nitin Ramesh, appearing for the petitioner. The accused 1, 2.
Petitioners.
Petitioners ಹೇಳಿದ್ದು. The accused 1 to 10 are before the court calling in question registration of a crime in crime number 187 of 2026. The backdrop, as has become necessary to indicate in every case, is a civil suit filed by these petitioners against the complainant in OS 8519 of 2025. The usage of lift in the particular apartment complex becomes the burning issue. Therefore, the petitioner files an application before the concerned civil court in Miscellaneous 332 of 2026 seeking opening of the lift, permitting operating of the lift. Stern warning is issued to the complainant not to interfere and open the lift for its usage. Immediately thereafter springs the crime, naming all and sundry in the apartment complex as accused. If this would be permitted, it would be permitting misuse of the criminal justice system, albeit prima facie. Therefore, there shall be an interim order of stay of further proceedings, further investigation by the petitioner to the next date of hearing. Withdrawal, Rajat. For withdrawal. Adondena ellana?
Happy for the petitions, my lord. That is a matter pertaining to matrimonial dispute, my lord. What has happened is this: 2022, the marriage is solemnized. 2026, a complaint for dowry.
498 ena?
498, my lord.
Madhyake 2 move madidre?
My lord, the petitioner number 2 and 3 are medical ill patients, my lord.
Medically illa?
Petitioner number 3 is diagnosed with 4th stage brain tumor, my lord. Now she is dragged into this web of allegations only on the sole allegation that she's abused the respondent number 2.
Accused number 1 yaru?
Accused number 1 is petitioner number 1 husband.
Our healthy ಆಗಿದಾರಲ್ವಾ?
My lord, what has happened is this: he's the only child looking after the parents, my lord. Now if he's dragged,
bail ತಗೊಂಡಿಲ್ವಾ?
No, my lord. Bail, he's contacted one advocate in the judicial Kolar, my lord. I don't know what is the status of the application there. But what has happened is this: after 2020, after the marriage, 2025, mother-in-law is diagnosed with post-stage brain tumor. 2026 February, father is underwent surgery for melanoma right leg, my lord. After this, they were under medical care on a regular basis. The respondent number 2 did not want to stay with the parents.
That's all right.
Living.
2 and 3 will straight away stay.
Not even the husband. What will happen now is if some coercive action is taken against him, then he's the only son who's taking care of the parents now. My lord, if your lordship sees the complaint, my lord.
Only
no
son.
Specific allegations, my lord.
Only son.
Only son.
Are you sure?
Yes, my lord. Your lordship, that is coming in forth in the complaint itself at Annexure B, my lord, page number 25. Vague and omnibus allegations, only because he did not utter to her demands for a separate living, this sprung into action, my lord. She resides in Bangalore, she goes back to Kolar.
You secure bail. I will grant stay to the others.
Lord, some course, let them not take any, I'll cooperate with the investigation, my lord, let them not take any coercive action.
Nothing, you secure bail, yes.
Lord, some protection of your lordship, and
One,
he's the only
two,
son who's taking care of the parents.
One, there shall be an interim order of stay insofar as the accused number 2 and 3, the mother-in-law and the father-in-law are concerned. Insofar as the husband is concerned, liberty is reserved to the petitioner to move the court in the event any coercive steps are taken against him. This should suffice.
Grateful, my lord.
Yes. For withdrawal antide madam. Only the first matter.
A joint memo has been filed, my lord.
Where?
Parties.
Joint memo where?
We'll file it.
You will file it?
Yes.
When?
It's with the respondent.
When will you file? Ajit, ನೀವಿದ್ದೀರಾ?
The matter is settled, my lord.
ಆಯ್ತು, where?
There is a joint memo. Joint memo. Petition will.
Settled where?
My lord, we are reporting settlement. My lord. This was. May I just pass this on?
498 ಏನಾ?
ಅಲ್ಲ.
ಮತ್ತೆ?
ಅಲ್ಲ. Not cheating, not breach of trust.
ಆಯ್ತು. POCSO ಅಲ್ಲ ತಾನೆ?
POCSO. All economic offences. They have now agreed not to refund the money.
We made the payment also, my lord.
Made?
Yes.
Already made?
Yes, yes.
All
And
right, yes.
some portion of the amount has been.
All right, yes.
But the petitioner is yet to sign the.
Sign ಮಾಡಿದ್ಮೇಲೆ ಆರ್ಡರ್ ಅಷ್ಟೇ. ಇದು ಸೈನ್ ಮಾಡಿಲ್ವಾ ಸೆಟಲ್ಮೆಂಟ್? Yes. Parties are here?
Parties are here.
You have to sign it here. ಇಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ something else will come up.
Parties are here.
Yes.
Matter is under investigation. And,
No problem.
During course of investigation, the police have recovered around 2.3 crores from his bank accounts. There, of course, an application is currently pending before the learned magistrate.
No, this settles the issue.
That settles the issues.
So I will direct the learned magistrate to dispose
Very
the
well,
application
very
in terms of the settlement.
In terms of the
I'll barcode. The learned counsel appearing for the respondent submits that an application under 497 and 503 is pending before the concerned court seeking release of the amount of 2.3 crores that is now in the custody of the police. In the light of the settlement arrived at between the parties and the closure of the present proceedings, the learned magistrate taking note of the settlement shall dispose the said application with an outer limit of 1 week from the date of receipt or from the date of presentation of the subject order before the court. Yes.
Great. So
Both matters. 6 and 7 both?
No, for the 7, my lord, we are
There's only one
filing withdrawal.
Withdraw. Thank you, sir. Yes. 7 withdrawn.
So great.
Yes.
The father name change. They want to withdraw it.
ಹೌದಾ?
IO has changed. Investigation.
IO has changed. ಅದೇ
Investigation ಆದರೆ
ಸಂಜೀವಪ್ಪ.
ಸಂಜೀವಪ್ಪ. Please. I'm filing withdrawal.
There many skeletons would have come out of the cupboard.
ಏನಿಲ್ಲ. Created scene, my lord.
Sorry. Yes. In terms of the memo withdrawn, the investigation will continue.
Please, much obliged.
ಇದೇ ತಾನೆ 1978 ಅಲ್ಲಿ ಸತ್ತೋಗಿರೋ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ 2016 ಅಲ್ಲಿ ಮಾಡಿಫಿಕೇಶನ್. ಅಲಿಯಾಸ್.
Two different ಸಂಜೀವಪ್ಪ, my lord.
Different ಸಂಜೀವ್. ಅಲಿಯಾಸ್. ಮುಗಿಸ್ಬಿಡೋಣ. Just run through the list.
Sorry to interrupt, my lord. There was one matter.
ನಿತಿನ್, ಇದನ್ನು ತಗೊಳ್ಳಿ, ಅದು ಪಾಸ್ ಓವರ್ ತಗೊಳ್ಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಏನಾಯ್ತಲ್ಲ ಅದು?
4, my lord. List 2, serial number 4.
ಸರಿ. Yes.
ಅದರ ಒಂದು report was submitted by the police, my lord, on the last date.
ಇದೆ ಇಲ್ಲಿ. Will permit investigation.
No, my lord, if I could just mention on 2 points. The very section that has been invoked as against me, my lord, is 125. As far as 125, my lord, if I could just, before I get into that, my lord, I would just point out on one document that they have submitted, after which, my lord, I will go through. The statement of objections that is submitted, my lord, there is a doctor report. If I could just take my lord's attention to page number 9, my lord, the report dated 9/8/2025. last but one paragraph. Patient reviewed. ಆ paragraph my lord.
ಹೇಳಿ.
ಅದರಲ್ಲಿ the last line. Anterior segment examination and fundus examinations were normal in left eye in telekondide. I'm just coming, I'm briefing it precise point. My lord, ಮೇಲ್ಗಡೆ page number 8, that is the next report, 23/9/2025. Para number 2. Last line again, my lord. The left eye is normal. Now kindly, my lord, the disability certificate, my lord. And the disability certificate, my lord, it says blind, complete blindness. Yeah, my lord, I understand, my lord, that when they make a submission, my lord, stating that the child has had an effect on the eye, and the child is, when he says, my lord, that the child is completely blind, I understand the approach, my lord, that this court is taking, but I just like to point out that the very certificate that is issued based on the report that says that the left eye, in fact, they say that the right eye is affected. Further reviews, they have told that the child is supposed to attend. The left eye is perfectly normal. In fact, the report says both the eyes, my lord. The disability certificate that is issued, it says right eye is chronic hardy and left eye myopia. And my learned friend says that the child is blind. My lord, my point coming to this, my lord, before I get into further things, my lord, I would like to point out similar case, my lord, but 125 was not invoked. In that, my lord, section 75 of the JJ Act was invoked.
Yes, sir.
I could read out para number 8, my lord. On a plain reading of the first part, this is also in terms of an school management, my lord, the allegation was raised against the chairman, where a child was affected. Para number 8, my lord. On a plain reading of the first part of the section 75 of the JJ Act, person who can be punished for cruelty to a child must be shown to have either the actual charge of the child or control over the child. The reference to the child in section 75 is to the victim of the offense. The appellant was the chairman of the managing committee which runs a school, which has classes from KG to 12th standard. Therefore, it is impossible to even allege that the appellant, being the chairman of the managing committee, had the actual charge of all the children studying in the school run by the institution. It cannot be said that he had control over all the children in the school. He may have control over the management of the institution which runs the school. That does not give him control over every child studying in the school. While consider the applicability of section 75 of the JJ Act, we are not concerned with the moral responsibility of the school's management. Assuming that the appellant was morally responsible, section 75 of the JJ Act could not be applied unless it is shown that the appellant had the actual charge of the victim child or control over the victim child. My lord, insofar as my case, my lord, if I could just point out on the complaint.
Yes, sir.
It states, my lord. The last part, the allegation as against me is my child had gone to that school. My lord, insofar as 125 to be applied, my lord, if since they say that while it was under when the child was being transported from the school to the home, ಆ ಸಂದರ್ಭದಲ್ಲಿ ಇಂಥ ಒಂದು ಇನ್ಸಿಡೆಂಟ್ ನಡೆದಿದೆ ಅಂತ ಹೇಳೋ ಸಂದರ್ಭದಲ್ಲಿ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಶೋನ್ ಆಸ್ ಟು ವಾಟ್ ಇಸ್ ದ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆನ್ ಮೈ ಪಾರ್ಟ್ as far as the institution is concerned, my lord, or the management is concerned, what is the negligence on my part has to be shown. Unless otherwise there is some negligence that can cause the entire incident, my lord, I cannot be prosecuted for it. As far as one more point, my lord, that I would like to say, according to their own complaint, my lord, there are other children. Now the child is not studying in the said school. According to the complaint, my lord, there were other children who actually brought ಒಟ್ಟಿಗೆ ಕೂತಿದ್ದ ಮಗುವಿನ ಕೈಯಲ್ಲಿ ಇದ್ದದ್ದು ಅಂತ ಹೇಳಿಕೊಂಡಿರೋದು my lord. Now that child is also ideally going to be dragged into this, not only the part that I am being pulled into it. My primary contention before this honorable court would be that, my lord, section 125 ಅಲ್ಲಿ when something is to be charged as against me, my lord, ಈಗ CCTV camera, they said that attender ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಕೊಂಡು, attender with attendance register and everything, they are also aware that the attender was there. Attender idru, driver, if the driver had driven in a very negligent manner which had caused an accident and ಅದರಲ್ಲಿ ಮಕ್ಕಳಿಗೆ ಡ್ಯಾಮೇಜ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರೆ that's a different scenario, my lord.
CCTV ಇಲ್ಲವಾ?
ಇದೆ, my lord, CCTV is there. In fact, my lord, the incident took place on first.
CCTV last time
that is not the truth.
CCTV work
ನೀವು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇಟ್ಟಿರೋ CCTV ತರನಾ?
ಹಾಗೆಲ್ಲ my lord, if I could just point out,
ಅದಿರುತ್ತೆ, ವರ್ಕ್ ಆಗಲ್ಲ.
ಹಾಗೆಲ್ಲ ಒಂದನೇ ತಾರೀಕಿಗೆ ಇನ್ಸಿಡೆಂಟ್ ನಡೀತದೆ of the 8th month. When they say, my lord, that the CCTV is not working, I'm just trying to convey my end, my lord. On 1/8 the incident takes place, my lord. On 5/9 they file a complaint, my lord. according to the regulations that is been prescribed for the institutions, my lord, schools and all the other educational institutions, not only educational institutions, my lord, in fact, for the public authorities also, the law mandates that, my lord, for 30 days, I am supposed to store the footage. If they would have filed a complaint, my lord, to me, as the institution, my lord, stating that an incident like this has taken place, CCTV footages have to be secured. Then if I would not have secured that, that is a different scenario, my lord. Now that FIR is registered, my lord, subsequent to having registered the FIR, if the police would have told that the footages have to be secured also, it would not be practically possible because it is after around 45 days post that. And I'm not aware, my lord, if the police have actually issued a notice asking me to secure the CCTV footages even at this point of time. My only point, my lord, that yes, even though there has been an incident, my lord, as far as I am concerned, management is concerned, there is no responsibility that I have violated. If there was any responsibility that I have violated, my lord, prosecuting me would make sense. Insofar as their complaint itself, my lord, if I can just say, the mother, the parent had given a complaint. Yaro, makkalu yaro, bannada minchanu ಎರಚಿದರು ಎಂದು ನನಗೆ ಹೇಳಿದನು. Group of kids, my lord, ಅವರು ನಾನು ಅದನ್ನ ತಡೆ ಹಿಡಿಲಿಕ್ಕೆ ಆಗ್ತಿದ್ದ ಒಂದೇ ಒಂದು ಸಿನಾರಿಯೋ, if I could just state, my lord, that would, if at all, that is the point, my lord, I understand. The only scenario I could have avoided this is that ಪ್ರತಿ ದಿನ ನಾನು ಪ್ರತಿಯೊಂದು ಮಕ್ಕಳದು ಬ್ಯಾಗ್ ಚೆಕ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. That is the only possible option I have. As far as that, I could have avoided this scenario. That's all my submission.
Handed over the government order.
In order?
For safety measurements of the
measures.
Page number 6. Page number 6, transportation.
Act idu rules. Which rule?
Page number 6, section 1C, transportation.
Rule. 1C, transportation.
1C, point 4. Attendant. There is a teacher or an attendant, preferably for a female attendant,
accompanying children in the school bus till the last stop.
It was there, with attendance register, it's there.
Next, my lord, there is a responsible person security to oversee the movement of vehicles in front of school for drop pick up.
School ಹೆಸರು ದಿವ್ಯ ಜ್ಯೋತಿ.
If I could
ದಿವ್ಯ
just
ಜ್ಯೋತಿನೇ ಹೋಗ್ಬಿಟ್ಟಿದೆ child ಗೆ.
If I could state, my lord, I in fact made an entire list of documents to produce.
For what?
If I just, entire list of documents to produce, all the way from CBSE guidelines till state guidelines, my lord. All their regulations. I went through it after the previous.
You must understand the result of what has happened.
I understand that, my lord. So what could I have done differently?
No, empathy, sir, empathy or sympathy will not work in such things.
What could I have done differently is what my learned friend has
That we will see.
They have not taken any first aid, my lord. Your Honor, may I see? As per the incident, they have at least minimum first aid. They have not provided.
Disability certificate.
I have produced the certificate along with my objections.
In the statement of objections,
Page
6, my lord.
Page 6.
Affected body part, both eyes.
Both eyes. It's the
Case of blindness, 40% disability in her certificate, permanent as per the guidelines so and so. And the other eye is less, is it?
other eye is a short
sighted.
40% of the disability on the whole body.
That is eyes.
Not my lord. The 40% disability is comparing the total body.
Correct, sir. The 40% of the disability to the whole body because of what has happened to the eye.
Please.
Yes.
That is where my lord, I pointed out that in that paragraph in which doctor report he says the left eye is normal, 6 out of 6. I could just read that another then the very next page.
One kannu hogidiyalla.
Hagella. Ondu kannu sa in so far as this report is concerned, if I could just, I understand, my lord, but I'm just trying to put across that the very report that they have submitted says that the child is supposed to come forward for reviews. What is the current circumstances of the child? That they do not put forward except for this report, the disability certificate.
Sir, in such circumstances, even one child is a child too many.
I agree with it, with what my honorable court says. But my only question is, what I did not do that has led to the negligence? The law says that I should have a CCTV. The law says I should have a attender. The law
Everything
says
you had.
I had. According to their complaint, the complaint may they say that ಪಕ್ಕದಲ್ಲಿದ್ದ ಮಗು ಅದನ್ನ ಇದು ಮಾಡಿತು. Next stop ಅಲ್ಲಿ gets down and goes.
ಇದು ಬರೀ ಹಾಗೆ ನೋಡ್ಲಿಕ್ಕಿಲ್ಲ. Yes. The petitioner, the management of Divya Jyoti School is before the court calling in question registration of a crime in crime number 94 of 2025, registered for offence punishable under section 125A of the BNS. The crime comes to be BNS registered on 5/9/2025. The son of the second respondent complainant was a student studying in the petitioner school -- Divya Jyoti English Medium School in which class? Which class, sir? How class?
Sixth.
In the 6th standard. On 1/8/2025, the son of the complainant travels in the school bus along with several other children. Inside the bus, another child is said to have sprayed confetti, which confetti or colored sparklers as the case would be, which results in the son of the complainant losing eyesight. Losing eyesight would not mean that the son of the complainant became 100% blind, but became blind for resulted in disability of 40% to the entire body and one of the eyes getting completely blind. On this incident of the son of the complainant, a boy of 6th standard getting blindness as what is observed here and above, seeks to register a complaint before the concerned court, before the jurisdictional police on 5/9/2025, alleging that the management of the school has not taken care of an attendant to be present in the bus and the CCTV not working and the CCTV not installed in the bus, which has led to another student carrying the said confetti and spraying it on the eyes of the son of the complainant. This results in registration of a crime in crime number 94 of 2025. The registration of the crime had led the petitioner to this court in the subject petition. The coordinate bench, in terms of its order dated 27/10/2025, grants stay of further investigation against the petitioner school, and the said interim order is subsisting even today. The matter is heard at this stage. The learned counsel Nitin, appearing for the petitioner, submits that all the necessary precautions had been taken by presence of an attender in the bus, the installation of a CCTV, and what other steps had to be taken is what other steps had to be taken is not, the school is not aware. And the unfortunate incident though has happened where the child has lost its eye, the management cannot be hauled for the act of another child or act that has happened inside a school bus after the hours of the school is his submission. He would seek quashment of the proceedings. Contrariwise, the learned HCGP would take this court through the papers of investigation to demonstrate that the CCTV, though was installed, was not functioning. The attender was not present, and therefore these are matters which have to be investigated into, more so in the light of the fact of a child losing the eye. The learned counsel appearing for the complainant would would take this court through the statement of objections so filed to contend that that this management of the school, which was all time responsible for the safety of the children from the start of the school till each child would reach the house, is solely responsible for what has happened for the child. He would take this court to disability certificate to demonstrate that a child which is studying in the 6th standard even before would see the life has lost the eye, and therefore would submit these are matters for investigation in the least to fix responsibility, as if this would be quashed without investigation. All further actions that the complainant would want to take, even on compensation, could get jeopardized. I have given my anxious consideration to the submissions made by the respective learned counsel, so and so. The aforenarrated facts link in the chain of events are all a matter of record. It would suffice if the narration would commence from an incident that happens on 1/8/2025, where the school bus number 5 of the school of the petitioner, in which several children travel. The children, there are about 2 or 3 children who had carried the spray hyphen the confetti or colored sparklers, as the case would be, and have sprayed the said confetti on the eyes of the son of the complainant, or have played with the colored sparklers inside the bus. This resulted in immediate blindness to the immediate loss of sight to the child, i.e., the son of the complainant. When the child came out crying of the bus of burning sensation when he was dropped at the house, the mother realizes that there is something more than what met the eye, and therefore takes the child to the doctor only to know that the child has child has become disabled by loss of sight of 40% to one of the eyes, and ophthalmic dysfunction to the other eye. Based upon this, a complaint comes to be registered on 5/9/2025. The complaint reads as follows. The fulcrum of the complaint is what is narrated here in above. The allegation is that the school, which at all times had to take care of the child from the pickup from the school till the drop to the house, has acted negligently in not providing an attender in the bus, nor the CCTV.
That is not there in the complaint.
CCTV, yeah.
CCTV will attender will complaint. Only thing that they read in the complaint.
Notice ಕಳ್ಸಿದೀವಿ, but
ಆಯ್ತು sir. The allegation is that the management has not taken care of the children inside the bus, as submitted by the inside the bus. Therefore, one fact that is stark is that the child has suffered disability. The sufferance of disability is not that it is curable. The child which is aged about 12 years has suffered a permanent disability to the eye. Who is responsible is the question that is to be investigated into. The school management cannot show hands off or be left off the hook at this stage in bringing it to books if the school is responsible for not taking care of the child safety or safety of every children that travel in the bus. Therefore, the investigation cannot be nipped in the bud, as is contended by the counsel for the petitioner. The allegation may be of section 125A now, as it is only in the stage of FIR, and FIR is settled principle of law, is not an encyclopedia of offences. Whether there was an attender, whether the CCTV was installed, CCTV was functioning, as to who were the others who were involved in in burning colored sparklers or spraying confetti on the eye of the son of the complainant, all have to be investigated into. The investigation cannot be scuttled. The right of the child cannot be stifled, at least in bringing the persons who are perpetrators of this to books. In that light, finding no merit in this petition at this juncture, the petition stands rejected. Investigation must ensue.
Fourth standard. Student in fourth standard at the time.
Fourth standard, yes.
Grateful, madam.
171 ಏರಿ ಸರ್. ಯಾಕೆ ತುಂಬಾ ಅರ್ಜೆಂಟ್ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ? ಇಲ್ಲ ತಾನೆ? ಅಯ್ಯೋ ಇರ್ಲಿ, ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಹಂಗಿದ್ರೆ. ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ? ಹಂಗಾರೆ ಸ್ಟೇ ಕೊಡ್ತೀನಿ ಬಿಡಿ. ಒಂದೇ ನಿಮಿಷ ತಾಳಿ.
25th last date.
Wait sir. Yes.
My lords, petitioner is account number 7, my lords. The case of the complainant.
ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತು?
I got late, my lords. I got late.
You got late?
I apologize.
Yes.
My lords, the case of the complainant is that complainant alleges that he gets a link on Telegram, my lords. He opens it, then he gets an offer that he has to book tickets. Then he books tickets, he pays some amount, and in return of that, he gets multiple amounts, and he keeps on paying it. And to the
part-time job fraud.
Yes, to the tune of 25 lakhs, he pays, my lords.
Yes.
The only role against present accused is that he.
Accused number 7.
Accused number 7.
ನಿಮ್ಮ ಅಕೌಂಟ್ ದುಡ್ಡು ಬಂದುಂಟಲ್ಲ.
25,000 has been credited to my lords before.
ಅದಕ್ಕೆ part-time job fraud, part amount has come to you.
25,000 has come, my lords.
No problem.
The main thing is that before registration of FIR, I myself have gone and registered a complaint with my bank.
Offense is the best force of defense.
My lords may see annexure A at page number 22. My lords. I myself have gone before the complainant and complained to my bank that my account is being illegally used and unauthorized transactions are taking place. And when my bank doesn't act upon that, I also go to cyber cell and give a complaint before the complainant goes and files an FIR.
Notice ಮಾಡಿದೀನಿ. 1 HCGP 2 emergent notice. Who is the complainant?
Complainant is respondent 2, my lords.
Emergent notice to the respondent returnable by 16 July.
Further, my lords, the only allegation against me is that money has been credited to my account. There is no allegation of inducement or there is no allegation of impersonation.
But yes, this is a larger conspiracy. We will see. Yes.
I myself have gone and given the complaint before.
ಅದಕ್ಕೆ ಹೇಳಿದ offense is the best force of defense. Yes. Let's see. On HCGP to emergent notice. Next. ಅಲ್ಲ ಪಾಸ್ ಓವರ್ ಇವ್ರು ತಗೊಳ್ಳಿ. ಇಲ್ದಾರೆ ಇವರು ಬಿಡಲ್ಲ ಈಗ. ಕೊಡಿ. 171 ಅಲೋಡ್ ಕಾಸ್ಟ್ ಬೆಳಗ್ಗೆ ಯಾರಿಗೆ ಹೇಳಿದೆ ನೋಡಿ ಮೇಡಮ್. ಸೀರಿಯಲ್ ನಂಬರ್ ಏನದು? ಫಸ್ಟ್ ಲಿಸ್ಟಾ? ಸರಿ. ಅದಕ್ಕೆ ಬೆಳಗ್ಗೆನೆ ತರಬೇಕು. ಬಸ್ ಮಿಸ್ ಆದ್ರೂ ಭಾರಿ ಕಷ್ಟ ಇಲ್ಲಿ. ಎಸ್. An offense?
My lords, cruelty in this matter, my lords.
Cruelty?
Yes, my lords.
I'm appearing.
Lords, both the parties are present. This is a family matter, my lords.
Cruelty ಅಂತ separate ಆಗಿ ಯಾವ್ದಿದೆ?
ಇಲ್ಲ, my lords. In section 85 of BNS.
Dowry harassment. Yes. Settle ಕೊಡಿ.
Both the parties are present.
Yes. Where have you settled?
In a MC petition, my lords.
ಕೊಡಿ ಅದು. Yes.
Joint, my lords, both the parties are petitioners here.
Petitioners, complainant ಯಾರು?
My lords, there is a
both of you filed the petition only for that purpose. All right. You are living together now?
Yes, no, my lords. They are taking divorce.
Fine. Yes. Right.
Yes, sir. Question.
Next. Both matters.
Much obliged.
Have day after 2-3 judgments I would like to say.
Right.
Because
Next
I don't
Tuesday.
like to- Please.
Wednesday. List on next Wednesday. End date is not ಹಾಕಿ.
I'll give those all judgments.
Same stage.
I'll give those judgments well in advance.
It's It's akin to filing a
I will
protest,
convince you, like,
recommendation to
this is
file
the
a protest
first-
petition.
First time in the history of this thing, because I did not find any government
That is
order
why we will lay down that law now.
where the government has intervened in investigation.
Government has done nothing. It has only, government has all the power to say, yalla B report hakiradella tappu, you redo. B report accept or close ಆಗ್ಬಿಟ್ಟಿದ್ರೆ, then government saying I can accept. It's not even closed.
I have judgments. Just
ಏನು ಒಂದ್ಸರಿ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ಬಿಟ್ರೆ ಆಗಲ್ಲ ಅಂತಲ್ಲ.
what is the procedure to be followed once a B report is filed?
Court will follow the procedure, sir. Government has not followed anything now.
I'll
Court ಮುಂದೆ protest petition ತರ ಹಾಕ್ತಾರೆ. Court is for the court to follow procedure.
maybe I may
Government
take
need not
about
follow
10
any procedure.
Even without that communication.
Exactly. Even without that recommendation, it is always open for him to file a protest
He
petition.
can melod very well, but now on
Just
the basis
because
of
he
the
has made a statement alli for
Now the
other
notice-
reasons,
notice
they make us.
issued to
Why
me-
did you make that statement?
notice issued to me based on the
All
government.
right. Why did you make that statement?
Get instruction, my lord, for that aspect, my lord.
Huh?
I have to get instruction for that aspect, my lord.
ಸುಮ್ನೆ ಹೋಗಿ ನಮ್ಗೇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅನ್ಬಿಟ್ಟು.
In two occasions, my lord, one is filed a B report also, my lord, we can file an application for investigation. And also, my
We'll
lord.
take it next Wednesday.
Please.
There is no judgment.
But I'll try to convince.
Yes.
I'll do my best. What can I do?
Of course, sir. Yes, you will. Yes. We'll return it in the same way. No worries.
I think I know.
I'll also do my best.
Please.
Yes.
Lord, petitioner is here, the bank manager.
Bank of?
It's an L&T Finance Limited, Lord.
Ah,
It's a
ಏನಾಯ್ತು?
financial institution. He's the manager. The respondent's mother is the applicant. And respondent's father and brother are the co-applicants.
108.
108 and 103 both have been invoked, my lord. 108, they say, 103 is as against the father, who is also
Get
committed
the
suicide.
investigation papers.
Please, ma'am.
The difficulty, my lord, is that.
Crime is too fresh, sir. 9th June.
Please, my lord. But they only availed the.
And it is
They availed loan only in the month of
Sir,
April 2026.
particularly in offensive abetment to suicide, without looking into the investigation paper. Charge sheet hakidre, I would have granted stay.
The complaint, my lord. There is nothing against as this particular accused. They have taken some financial loans from
No, no.
other parties.
No, no.
ನಮ್ಮಲ್ಲಿ ಬಂದಿರೋದು ಬರೀ
We
April
will not
ಮಾತ್ರ.
hold the hands of the investigation
Lord,
right away. Though you may be accused number 4. That's a different
The
thing.
reason is that the loan was only availed in the month of April 2026. There is no even default also. There is no, there cannot be
Get
any
the
such
investigation
allegation.
papers. Yes.
The difficulty,
Crime
my lord,
register 10 days ಆಗಿದೆ ಅಷ್ಟೇ.
The difficulty is that office open ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಿಲ್ಲ because of this thing.
ಆಫೀಸ್ ಯಾಕೆ ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
ಇನ್ನು ಆಗಿಲ್ಲ ಸರ್.
ಮತ್ತೆ ಎಲ್ಲಿದ್ದೀರಾ ಈಗ?
He's not in town. He's not in town.
Not in town.
Please.
ಪರವಾಗಿಲ್ಲ. ಹೆಂಗೂ you are not in town. ಪರವಾಗಿಲ್ಲ.
But the entire office has been shut down.
You are not in town ಅಲ್ಲ?
Other staff is also not coming because of this
Yes,
reason.
yes.
He's the branch manager.
Get the learned HCGP is directed to accept notice, secure the investigation papers and place it before the court. List the matter on 7th July, fresh matters. Seek bail, sir. You are accused number 4, bail ಸಿಗುತ್ತೆ ಮಾಡಿ. ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಯಾಕೆ? ಆಯ್ತಾಯ್ತು, ನಾಳೆಗೆ ಹಾಕಿ. ತಲೆನೋವು ಬೇಡ. ಆರ್ಡರ್ಸ್ ಕರೆದ್ಬಿಡಿ. ವಿಕೆಟಿಂಗ್ ಸ್ಟೇ.
For the petitioner, 498A and 323. State has filed an application seeking for vacating stay.
ಮೇಡಮ್,
Page-
ಇದೆಷ್ಟು ಕೊಡಿ ಡೇಟ್ಸ್? ಒಂದು ನಿಮಿಷ. It's 5:30 now.
Please.
Wait. We'll fix these vacating stays on a particular day. ಮೇಡಮ್, ಯಾವತ್ತು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 50 ಇರಲ್ಲ, ಅವತ್ತು ಹಾಕೋಣ ಅಂತ ಕೊಡಿ. ಸೊ ದೀಸ್ ಮ್ಯಾಟರ್ಸ್ ರೀಚ್. ಬೇಡ, ಕರೆಕ್ಟ್ ಅಲ್ಲ. 30th ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಇರುತ್ತೆ. ಫಸ್ಟ್ ವಾಟ್ಸ್ ದಿ ಲಿಸ್ಟ್ ಎಲ್ಲಿದೆ ಮೇಡಮ್? ಫಸ್ಟ್ ಇಲ್ಲ, ಫಸ್ಟ್ ಇಲ್ಲ, ಏನಿದೆ ಡೇಟ್ಸ್ ಇದೆಯಾ? ಪರವಾಗಿಲ್ಲ. ದೆನ್ serial number 23 to 30, all are vacating stay. They will all repeat on 1st of July in the same stage in the first list.
Interim order, my lord, in 26.
Interim orders wherever is there will continue. Don't have to mention.
Just one submission, my lords.
Then orders ಅಲ್ಲಿ admission weight is orders memo forward in terms of the memo withdrawn. Yes. 32 is again vacating stay. So on the same day, first July. Yes, 33 interim orders will continue, sir.
Office objections ಇದೆ. Copy serve ಆಗಿಲ್ಲ.
Copy serve ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ ಆಗಿದೆ.
The
Outsource ಮಾಡಿದ್ದಾರೆ.
council submits office objections have been ಯಾವ್ದ್ರಲ್ಲಿ ಇದು 32 ಅಲ್ಲಿ council submits office objections have been complied with office to verify. Yes. ಆಮೇಲೆ 33 in terms of memo withdrawn. Post immediately
regards to
after
petitioner
service.
number 1, my lord.
Who's R2?
My lord, R2 is the complainant, my lord.
1 minute, sir. The learned counsel
Please.
so and so undertakes to enter appearance for the second respondent complainant registry to print the name of so and so as appearing for the complainant. Interim order diya?
Interim order is this one.
Yes, list after 2 weeks. Yes, next.
My lord, may I make one submission, my lords?
No submission. 35 post immediately after service of
35,
notice upon.
35, I take notice for respondent number 2. This is a police constable goes to the police station with others and obstruct the police work.
Police versus police?
Everything is captured in the CCTV.
No problem.
May I
Yes,
request
the learned HCGP accepts notice for the second respondent complainant as well as it is the policeman. List the matter on Monday in the fresh matter, Tuesday in the fresh matters list. Yes. Next.
I appear for the petitioners, my lord. This
Council
regards to
submission,
the-
maintainability of the second petition. Why?
Yes, my lord. This is regarding Sushila Agarwal's judgment whereby the learned.
Oh, correct. Yes, you told me.
I will not take more than 2 minutes of your lordship, my lord.
Huh.
My lord, the learned magistrate has directed the accused to apply for regular bail once again after already having obtained anticipatory bail and placing on record the Honorable Supreme Court's judgment in Sushila Agarwal. The impugned order may be found at page number 16, my lord. And if the
Now, the earlier bails, he has cancelled the earlier bail?
no, my lord, the
File
earlier
kodi, madam,
petition
one
was
nimsh.
filed to quash the.
File kodi.
If I may, my lord.
Where is the order, madam?
Page number 16, my lord.
16?
Yes, my lord.
Accused number 1, so submission rejected direct. Anticipatory bail was granted?
Yes, my lord. You may find that at page number.
Page number?
58, my lord, for petitioner number 1 and petitioner number 2 to 3 at page number 67.
All the petitioners had been granted?
Yes, my lord.
The petitioners are before the court on a strange circumstance of gross illegality on the part of the concerned court, if not illiteracy. The petitioners all were granted anticipatory bail on registration of a crime in registration of a crime. The police conduct investigation and file a charge sheet. On filing of the charge sheet, the concerned court passes a strange order that the anticipatory bail would vanish once the charge sheet is filed and directs these petitioners to seek regular bail. The order of the concerned court flies foul of the Constitution bench judgment of the apex court, apart from what the apex court has held, directing apex court has held that the magistrates which cancel the bail on filing of the charge sheet should mend their ways. Likewise, the magistrate in the case at hand who has directed the regular bail to be taken on the filing of the charge sheet has also lost sight of the law. In that light, the order granting anticipatory bail would run notwithstanding the filing of the charge sheet even. Yes.
Thereby the order dated 8/6 may be set aside, my lord.
In the light of the said circumstance,
In the close.
disposed, yes. In the light of the aforesaid circumstance, the order dated 8/6/2026, which orders the petitioners to secure a regular bail on the score of filing of the charge sheet stands set aside. Consequently, the anticipatory bail granted, which date?
13/1/2026.
13/1/2026 stands restored and would continue throughout the trial.
To give the surety bond ಏನಾದ್ರು ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
ಅದಕ್ಕಲ್ಲ ರೆಗ್ಯುಲರ್ ಬೇಲ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ನೋಡಿ ಅಲ್ಲಿ.
ಎರಡು ಹೇಳಿದ್ದಾರೆ.
ಎರಡು ಎರಡಕ್ಕೂ ಆಗ್ತಾ ಇರಲಿಲ್ಲ. ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ cannot be cancelled like that.
Cannot be cancelled. It cannot be
Yes. So it's restored. All other conditions stipulated in the anticipatory bail may be are not disturbed. Yes. Disposed. Therefore, should observe for the so and so disposed. Yes. Next.
My lord, petitioner, this is a case of 307.
ಅದೇನೋ ಅರ್ಜೆಂಟ್ ಬೇಲ್ ಅಂದ್ರೆ ನಿಮ್ದೇನು
Date
ಪ್ರಾಬ್ಲಮ್?
may be fixed, my lord.
Yes. Office objections stand first time.
First time. Notice
ಆಗಿದೆಯಾ?
ಇಲ್ಲ. It has come, it has not reached, my lord.
ಸುಮ್ಮನೆ ಹೇಳ್ಬಾರ್ದು.
It has not reached.
ರೀಚ್ ಆಗಿಲ್ವಾ? At request list next week ಅಂದ್ರೆ ರೀಚ್ ಆಗಿದೆ. At request list in the fresh matters list ಎಲ್ಲ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ನಂದಲ್ಲ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಅರ್ಥ. ಆಮೇಲೆ at request list after 4 weeks ನೀವು ಪಕ್ಕದ ಕೋರ್ಟಲ್ಲಿ ಏನು ಮಾಡಿ ಇಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಮಾಡಿ.
Matter is not reached ಹಂಗಾಗಿ in the
ಎಲ್ಲ at
coordinate
request
bench only. ಯಾವುದು I have not sought for adjournment. Reach ಆಗಿದೆ ಕಾರಣ.
Anyway, list the matter in the fresh matters list on Tuesday.
Please.
Office objections overruled. Next.
Petitioner informant, your lordship.
Petitioner informant.
Yes, I'm not the accused, your lordship.
14%.
No, your lordship. I have filed petition seeking challenging the order whereby 311
Who is Ponnanna MB? You're an advocate.
We represent the informant in the prosecution case, your lordship.
ಸ್ವಲ್ಪ ಈ ಕಡೆ ಬನ್ನಿ ಮೇಡಮ್. ಸರಿ.
311 application of the prosecution was partly allowed. One of the witnesses who is the attending doctor of the deceased
We'll see,
herein.
it's come for steps.
Yes, your lordship, we have taken steps on 3rd March.
Learned counsel for the petitioner submits that steps have been taken, office to verify.
Your lordship,
What
there
could
is
you, what's the matter?
yes, indeed. Since there's only one witness is left
Wait,
out for
wait.
the prosecution.
.311 application,
Indeed. Offenses are 498 and 306, your lordship.
list on Monday in the fresh matters list. Yes. Tuesday, next.
Lordship, there is no interim order in
There is
the
no
matter.
interim order. Monday will close it. Yes.
Indeed. Much obliged.
39 all matters.
My lord,
40 ಯಾರು?
submitting 40 ಇಲ್ಲ sir.
40 ನಿಮ್ದಲ್ಲ 39 all the matters you
Filing the acknowledgement.
Your lordship may kindly have it after 11th, my lord.
list
No, my lord, on
list
Monday.
the matter.
Child,
List the
this is not on paid, my lord.
list the matter on Monday 29th. Yes.
29th, I mean, I have some inconvenience, my lord.
No problem,
After
madam.
11th, my lord.
No problem. Yes. ಅವ್ರು ರೀಚ್ ಆದಾಗ ಹೇಳಿ ಮೇಡಮ್. Yes, next.
So, I had filed this petition for, I filed the criminal miscellaneous case.
Go to the mic, madam.
I had filed the criminal miscellaneous case in 2018, sir. After that, it has been delayed completely, especially at the stage of petitioner's evidence and cross-examination.
What is the proceeding, madam?
Proceeding, I'm requesting for the orders of the trial court, which said that it has to move to the next stage of respondent's evidence, sir, as of 23rd March.
Who has drafted this? So much.
Yes. If I may request you to please go into the schedules.
You are seeking speedy disposal.
Yes, sir. So it was delayed for the
For
first
speedy, this much
Yes,
is
sir.
needed.
Not just that, sir.
Then
This is also, there have been 35 hearings from 2024.
don't worry, we will direct closure. Yes. The what
2024 in the-
what year is the proceeding?
2018 ಅಲ್ಲಿ ಶುರು ಆಗಿತ್ತು ಸರ್.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ. The petitioner appears in person, seeks the following. Your prayer runs into 7 pages. Sorry.
2024 ಇಂದ
Seeks plethora of, seeks a spade of prayers. Spade of prayers. The petitioner in person would, however, restrict the submission to a direction to the court for expeditious disposal of the proceeding, as the the petitioner submits that about 35 hearings have taken place and there is no progress in the case.
And the respondent never comes in to that case.
And the respondent does not appear before the court at all. Therefore, the complainant stands at the doors of this court. A perusal at the pleading or the order sheet appended to the petition would depict an appalling situation of the proceedings pending for the last 8 years without any progress. Therefore, if the respondent is not appearing before the court ought to have unleashed the coercive arm of law directing appearance of the complainant. While that is not done, but the adjournments are granted for its asking, is what the order sheet would depict. In that light, I deem it appropriate to infuse finality into the proceedings by directing the concerned court to conclude the proceedings within an outer limit of 4 months from the date of receipt of the copy of the order, if not earlier. It is needless to observe that the parties to the list, petitioner and the respondent to the case, would cooperate for closure of the proceedings. In the event they would not cooperate, the concerned court is at liberty to pass necessary orders in accordance with law. Ordered accordingly.
I have one more small submission, sir. The entire proceeding timelines have been used by the respondent for the increase of credit, and he has increased the loan limits of joint loan. The loan that had to get done by February 2025 has been increased to 2028 just for 1,34,000.
That's a matter you can argue there only, madam.
So if I can please be given some kind of a protection, that because I don't have RBI protection also.
While giving this direction, I cannot do that. One line barkoli. The concerned court shall answer all the contentions that are advanced by the complainant. It is needless to observe that the concerned court would answer all the contentions of the respondent, for the petitioner. Yes.
Thank you.
I appear for the respondents, your lordship.
ಇದು ಅವತ್ತೇ ಹಾಕೋಣ ಫಸ್ಟ್ ಅಲ್ಲ, ಫಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? But 2023 ಇದೊಂದಿನ ಹಾಕೋಣ ಇಲ್ಲ. 23 will start listing 23 matters. We'll for now take it after 2 weeks. List after 2 weeks, interim order.
Great.
Urgency idre heli. If there is something important event idre date kodu.
It's a case and counter case, my lords.
Interim order.
Interim order.
Same 2 weeks IVO.
Lord, in 43, I appear for the petitioner. The only reason I mentioned this matter, my lord, it's a pending matter. Departmental inquiry is initiated against me, my lord, and notice is issued.
Howda? Why?
498.
Why?
For in a 498 proceeding, they've initiated.
Adu departmental inquiry initiate madidara.
I'm covered by your lordship's order, my
yes.
lord, Brahma Kumari's case.
Brahma Kumarida. Why departmental inquiry for 498 case hakiddಕ್ಕೆ? Then this, yes. List the matter day after tomorrow in the fresh matters list.
Grateful.
Yes. Next. ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಬಂದಿರೋದಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ರಿಮಾಂಡ್ ಆಗಿರೋದು ಇದು ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ಪೋಸ್ಟ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಮೇಡಮ್. ಎಸ್
That's 45 minutes. This is the matter covered by.
ಅರ್ಬಟಿ ಅವರೇ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ?
ರೆಡಿ ಇದೆ my lordship.
ರೆಡಿ, ಯಾವಾಗ ಹಾಕ್ತೀರಾ? ಕವರ್ಡ್ ಅಂತ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ನೀವು ಹಾಕ್ತಾ ಹೋದ್ರೆ.
2 days my lordship.
ಎಸ್, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ in the fresh matters list. Yes.
That's interim order may be extended.
Interim order will continue, sir. Wherever interim orders are. Yes.
For the petitioner, that's PC Act matter.
Is the 46, 7 or 13?
13(1)(b) my lordship. 13(1)(b).
13(1)(b), 7th. Yes.
There's interim order.
Interim order will continue. Yes, next.
I'm appearing for petition,
Madam?
See for.
ಯಾವ್ದಕ್ಕೆ? Oh, he's no more ಅಲ್ಲ. ನೀವು ಹಾಕಿದ್ದೀರಾ ವಕಾಲತ್ತು?
No,
ಮತ್ತೆ?
I'm a proxy counsel myself. Uday Reddy is
advocate and
This
record.
Reddy or Uday Reddy is on record. Register to print the name of Uday Reddy as appearing for the petitioner
Date may
in
be
place
fixed,
of
my
G. This Reddy.
Date
Just
may be-
on 16th. Yes.
Achalo.
138 proceedings, my lord, we are the partner. As they are
Stay
also-
idea.
Stay less.
Yes. List
Party
on.
managing partner.
ಒಂದು ನಿಮಿಷ. List on 3rd July. Yes. 3rd ಅಲ್ಲ, sorry. 6th July. Yes. The fresh matters list. Next.
For R2, my lords.
Petitioners, my lord.
14 entry model ಇದೆಯಾ?
Yes, my lords.
2 weeks IO. Next. ಇದೇನು?
ಇಲ್ಲ my lords.
Same
Disproportionate.
objection ಹಾಕಿದ್ದೀರಾ?
2 days, my lord. Same.
ಅದು ಸೇಮ್ ಕವರ್ಡ್ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಅವತ್ತು ಸೇಮ್ ಹಾಕಿ ಮೇಡಮ್ 46 ಯಾವತ್ತು ಹಾಕ್ದೆ ಅವತ್ತೆ ಹಾಕಿ. 7th ಅಲ್ಲ ಮೇಡಮ್
45 and 50, my lord.
ಯಾವತ್ತು ಬೇರೆ ಹಾಕ್ದೆ
45 and 50.
45 ಅದು 45 and that yes covered. Next. Mediation.
The mediation has been failed. Sister has been given a complaint to escape from her liability. Actually, first I have
Stay
given a
ilva?
complaint. No, my lord.
Yes emergent note ನನ್ನ ಹತ್ರ ಬಂದಿತ್ತ ಮುಂಚೆ
Yes, my lord.
ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
No, my lord. Because the honorable court has told to do, it will be closed.
ಆಯ್ತು ಇನ್ನೊಂದಿನ ಕೇಳ.
No, actually, the petitioner number 2 and 3 are, 3 is bedridden and she is taking care.
No
Those
problem.
people are very much.
List one ನಿಮಿಷ. List the matter on 23rd July. Further proceedings where the petitioner shall remain stayed. Next. $52 2 weeks. 50 ಇದೊಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್ because party in person is there. List the matter on 16th. 8th July. Yes.
Entry model should be extended.
Date ಆಗ್ತದೆ ಸ್ವಾಮಿ.
Next.
Entry model should be extended.
Entry model ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್. Yes, next. 2 weeks IO.
55, my lord. This-
Entry model ಇದೆಯಾ?
ಇಲ್ಲ.
Monday fresh matters. Yes. Madam. Old matter. ನನ್ನ ಮುಂದೆ ಬಂದಿದ್ಯಾ? ಮತ್ತೆ ನಾನು ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ
Notice ಆಗಿತ್ತು.
ಹಂಗಾರ ನಾನೇ ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ. List the matter 26.
ಅಲ್ಲಿ
post parade.
charges ಗೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ. That's the reason.
ಆಯ್ತು list on 1st July. We'll see. Yes. 2 weeks IO. ಇದರಲ್ಲಿದೆ ಬಿಡಿ ಎಂಟ್ರಿ ಮಾಡಿ ಇದೆಲ್ಲ ಆಲ್ ದೀಸ್ 2 weeks IO. ಇದು 1 crore ಕೊಟ್ಟಿದ್ದ 1 crore ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದಲ್ಲ?
Yes, my lord, that.
Yes. ಇದು list the matter on 9th July. Yes. Two weeks. Entry ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Fresh ಒಂದೇ 6th fresh matters. Yes.
Moved for stay, my lord.
Fresh matter.
Fresh matter, I've taken notice, my lord.
Notice number. It will come.
My lord, date, my lord.
On the 2 weeks bit on date ಕೊಡಿ.
My lord, first week.
Admission, no? Yes.
Press report na impleading ಮಾಡಕ್ಕೆ I am filing up.
My lords, appearing for respondent number 2, 878 charge ಇದೆ. Before to that, I will file my statement of objection.
File ಮಾಡ್ಬಿಡಿ.
Entry ಮಾಡಿ.
2 weeks IO. Next. ವಿಧಾನ್ ಇವ್ರದ್ದು ಇನ್ನೊಂದು ಇದೆಯಾ? ಎಲ್ಲಿ ನೆನ್ನೆ ರಂಗನಾಥ್ ರೆಡ್ಡಿ ನೀವಿದ್ದೀರಾ ಇಲ್ಲಿ? ಹಾ.
Unlawful assembly.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? List on 6th in the fresh matters list. Yes. Next.
Trap matter. Trap PCR.
7A case, your lordship.
7A. Second.
Please, ma'am.
Next. Post immediately after service of notice upon the respondent.
ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ನೆನ್ನೆ.
ಮಾಡಿದ್ರೆ ನೋಡ್. Yes, next.
Lordship, I appear for respondent number 2. They are seeking quashing of FIR which was stayed, but the charge sheet is filed, my lord.
Charge sheet challenge ಮಾಡಿ.
Verify and
Your lordship.
Entry order ಇದೆಯಲ್ಲ 2 weeks IO.
Charge
But
sheet
before
was
the
filed.
before the interim order or after the interim order, when did you file the charge sheet?
Before the interim order, my lord.
Before the interim order, then challenge the charge sheet.
verify and
ಆಯ್ತು Monday fresh matters. Yes. CC number ತಗೊಳ್ಳಿ ಮೇಡಮ್. Yes. NDPS.
This application was to be considered.
Dictation.
Stay.
Stay idea.
It was supposed to be considered today.
When voluntary statement.
No
Yes.
qualitative, quantitative test not done.
In the mean, sorry, list on Tuesday, fresh matters. Next.
25th.
Tuesday, bada, 6th.
25th, that is for framing.
Don't worry, take time. 6th, fresh matters. Next.
411, my lord, solemnly on the ground, co-accused statement, my lords.
Offense,
411, my lord, 370.
411, stolen gold.
My lord, only on co-accused statement, my lord.
We'll see, corroboration is recorded. Recovery nimatra agidya?
No, my lord, the recovery, I am a branch manager, my lord.
Bank manager?
Bank manager, Muthoot Finance.
Manappuram.
It has been seized.
Manappuram.
35.
Manappuram bank idya?
But I am a manager of the NBFC, my lord. It has been recovered.
Both 67, 68, 6th. Next.
My lord, interim order may be granted.
No, yes.
My lord, there is no, my lord, sir, kindly see, my lord.
411 ilve illa. Yes, next.
My lord, the only issue is.
We'll see. 6th.
35, my lord,
6th in the fresh matters list. Next.
Monday, my lord.
Monday, 6th. Yes.
Appearing for the petitioner, my lord. The bail cancellation question. Bail cancellation.
You have applied for you have filed for cancellation of bail. Against cancellation of bail. Why?
My lord, the second respondent is filed a complaint with
Monday,
me.
fresh matters. Yes.
I have interim order.
Either idea.
Other matter, I am seeking quashment. It's a Mysore Nanjangud case.
Then list this on Thursday, madam. Yes. Bail
I
cancellation.
was not been able to in the
I think
station.
Thursday. Yes, next.
The petitioner, I had a file yesterday, I had to file a interim stay application.
Stay application.
Then senior,
I the list.
Fresh matters.
Monday, fresh matters. Next. 6th. Yes, yes.
72 minutes for the petitioner. There is stay, my lords.
2 weeks, I will. Next.
POCSO, Your Honor.
POCSO, yes.
Victim girl has filed the affidavit.
What affidavit?
With respect to that she's attained majority and she's willing to.
She's attained majority and she's willing to?
Marry the accused, and he is petitioner is in the judicial custody. On the last date of hearing, the court asked me to file the age proof.
What's the age?
Age now is her date of birth is 28/2. I filed her 10th standard certificate as well as TC.
ಏನಿದೆ ಅದರಲ್ಲಿ?
ಅದರಲ್ಲಿ 28/2
ಕನ್ನಡ ಬರುತ್ತಲ್ವಾ?
ಬರುತ್ತೆ.
ಮತ್ತೆ ಟ್ರಂಪ್ ತರ ಯಾಕೆ ಮಾತಾಡ್ತೀರಾ? ನೆನ್ನೆ ಹೇಳಿದ್ನಲ್ಲ.
28/2/2008 is the date of birth of the victim girl.
22/3?
28/2/2008.
ಎಷ್ಟಾಗುತ್ತೆ?
17 years, 2 months.
17 years, 2 months.
2008, sir. 28 February.
18 years, 2 months.
18 years, 4 months.
TC na ನೋಡ್ಬಿಡಿ ಅದು.
ಅಲ್ಲ ಕೊಟ್ಟಿದೆ. Copy is already served on them. It's filed before. No, later.
You've served the copy?
Serve the copy.
Very good.
Register ಮಾಡ್ಕೊಂಡು ಬರು.
Now get married.
He's in the judicial custody and they're ready
we'll grant an interim bail. Yes. The petitioner is the accused. Or sole accused?
Sole accused.
The petitioner is the sole accused who is now in judicial custody. He is facing charges for the offense punishable under the POCSO Act. The petitioner is now willing to get married to the victim. You are in love?
Yes, sir.
Whom he is said to have been in love. The learned counsel for the petitioner submits that the victim is now 18 years and 2 months and the petitioner's age?
23.
And the petitioner is 23 years. Therefore, both the two are of marriageable age in terms of law. The learned counsel has produced a certificate of the transfer certificate of the school.
10th marks card.
Or the 10th marks card, which depicts the age of the petitioner to be 18 years and 2 months today. 4 months today. Therefore, in the light of the said circumstance of the petitioner wanting to marry the victim, I deem it appropriate to grant the petitioner interim bail for the purpose of marriage for the purpose of getting married to the victim, the petitioner shall now be granted interim bail for 1 month. Marriage ashte. For a period of 1 month from to Magunu idya? Oh, adi yavaga 18 years agilla. It's all right. Yes. Anyway, get married. Then you have to get married. Yes. Will not permit you to escape. Is the then to get married to the victim. To get married to the victim who is already a mother of the child, whose biological father is the petitioner. In that light, the petitioner shall be released from prison, and after getting married, the certificate of marriage shall be placed before the court on the next date of hearing. The petitioner is granted interim bail for the purpose of marriage for a period of 4 weeks from the date of his release. The registry is directed to communicate this order to the prison authorities to enable the release of the petitioner for the purpose of marriage of the complainant. Marriage with the victim.
Okay.
Yes. List 4 weeks bit on date, 29th. Yes.
Okay, for the petitioner, my lord, custody matter, my lord.
Huh?
Custody matter, my lord. The last week.
Custody lidira. Why?
Cheating and forgery.
This is that husband and wife.
Husband and wife matrimonial case.
Oh, yes, sir.
Yes.
Why is he in custody, sir?
No, because he's not cooperated with investigation.
Did not cooperate with the wife. Huh?
Investigation.
Investigation.
And he's going and troubling wife.
Why, sir?
I'll undertake, my lord. He'll not trouble anymore. And I'll undertake, my lord.
That assaulted wife.
Already 498 days also pending, my lord. Other cases are pending. It's all divorce is also in the final stage, my lord. Already last week.
Should not go and trouble the wife.
Already last week in Aiders.
Huh?
1.5 months. He's already been in
1.5
custody from
months.
April 20th, my lord.
But why was he taken into prison? Not correct. Tomorrow I will regret. Yes. Agata madam. Second list. Third list.
Fresh list.
Yes.
Fresh list.
Fresh list. Sak madam. 6 ಗಂಟೆ ಆಯ್ತು. ಆಯ್ತು ಸರಿ. Weeks time. Okay. Yes.
2 weeks.
Enter ಮಾಡಿದ್ಯಾ? At the request of the counsel of the petition, please have 2 weeks. Next. Srinivas Reddy ಅವರ.
Petitioner by reinvestigation, my lord. We filed the
Reinvestigation. ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಚಾರ್ಜ್ ಶೀಟ್ ನನ್ನ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ, ಡಿಸೀಸ್ಡ್ ಮೇಲೆನೇ ಹಾಕಿದ್ದಾರೆ.
ಡಿಸೀಸ್ಡ್ ಮೇಲ? ನನ್ನ ಮೇಲೆ ಅಂದ್ರೆ ಡಿಸೀಸ್ ಇಸ್ ದಿ ಪೆಟಿಷನರ್.
ಅಲ್ಲ
ಮತ್ತೆ
mother of the deceased is the petitioner before this court, my lord.
ಪಾರ್ಟಿ ಮಾಡಿ ಕುಡಿದ್ಬಿಟ್ಟು ಗಾಡಿ ಓಡಿಸ್ಕೊಂಡು ಬಂದು ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿ
ಮೆಡಿಕಲ್
ಪಾರ್ಟಿ ಎಲ್ಲಿ ಮಾಡಿದ್ರಿ?
ಇಲ್ಲ ಪಾರ್ಟಿ ಇಲ್ಲ, ಎಂತದಿಲ್ಲ, ಓಡ್ ಸಾಯಿಸಿರೋದು.
ಓ ಆಯ್ತು.
8 ತಿಂಗಳಾದ್ಮೇಲೆ ಸ್ಟೇಟ್ಮೆಂಟ್, ಅಕ್ಯೂಸ್ಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡು.
ಈಗ ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
ರೀಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಬೇಕು.
ರೀಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಯಾಕೆ ಇವ್ರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ವಾ ಇನ್ನು? ಹಾಕಿದಾರೆ ಅಲ್ವಾ? ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಅದು ನಡೀತಾ ಇದೆ ಅಲ್ವಾ?
ಅಲ್ಲ, ಮೆಟೀರಿಯಲ್ ನಮ್ಮ ಮೇಲೆ ಇಲ್ಲ.
ಅಕ್ವಿಟ್ ಆಗ್ತಾರೆ ಬಿಡಿ.
ಪ್ರಾಪರ್ಲಿ
ಅಕ್ವಿಟ್ ಆಗ್ತೀರಾ?
ಅಬೇಟೆಡ್ ಚಾರ್ಜ್ ಶೀಟ್.
ಅಬೇಟೆಡ್ ಚಾರ್ಜ್. ಮತ್ತಿನ್ನೇನು ಬಂತು? ಎಸ್ ನೋಡೋಣ, ವಿಲ್ ಸಿ. ಎಲ್ಲಾದ್ರಲ್ಲೂ ರೀಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು 307 ಕೇಸ್ ರಿಜಿಸ್ಟರ್
ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್
8 ಮಂತ್ಸ್ ಆದ್ಮೇಲೆ ಸ್ಟೇಟ್ಮೆಂಟ್
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಆನ್ 23rd.
ತಮ್ಮದೇ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇದೆ.
ಅದೇ ರಿವರ್ಸ್ ಆಗಿ ಬಂದಿದೆ ಸರ್.
ಇಲ್ಲ, ಆಗಿಲ್ಲ ಒಂದಾಗಿದೆ,
ಒಂದಾಗಿದೆ ಸಾಕ್ತಾನೆ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇದು ನಾವು ಬಡವರು, ನಮ್ಮ ಮೇಲೆ ಈ ತರ.
ಅದಕ್ಕೆ ನಾನು ಜಡ್ಜ್ಮೆಂಟ್ ರಿವರ್ಸ್ ಆಗಬಾರ್ದು ಅಂತಿದ್ಯಾ? ಮತ್ತೆ
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪ್ರಾಪರ್ ಆಗಿ ಫೇರ್ ಆಗಿ ಆಗ್ಲಿ ಅಂತ ಅಷ್ಟೇ. ದಟ್ ಈಸ್ ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್.
ಆಯ್ತು. 23rd will consider it. Yes.
Press list.
Fresh list.
For petitioner members, lien on bank account.
Huh?
Lien on bank account members, there is an interim order.
2 weeks to do the needful. Yes, next. Yes, Vinod Prasad.
This is first wife's petition.
First wife petition na?
Houdu.
Next wife?
Alla, second wife files petition before domestic violence court, seeks 40,000. Husband's entire salary is 40,000. What these three should do, if entire salary goes to her, I want to come on record to say these things. Court says you are not necessary party. I can't have any other,
List this matter in the fresh matters list on Tuesday. Who are you?
Humble request for the date on medical emergency.
Medical emergency?
Petition of 2023, my lord.
What? Advocate ilva nimge?
Advocate 3 ಸತಿ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ my lord. ಫಾದರ್ ಗೆ ಟ್ರಿಪಲ್ ವೆಸಲ್ ಬೈಪಾಸ್ ಸರ್ಜರಿ ಆಗಿದೆ.
ಏನ್ ಕೇಳಿ?
ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಗೆ ಡೇಟ್ ರಿಕ್ವೆಸ್ಟ್. I am requesting for the date.
ಏನಿಲ್ಲ ಇದು ಆರ್ಡರ್ ಎಡ್ಜನ್ ಅಂತ ಆಗಿದೆ my lord.
ಯಾವ್ದು
Big roof ಅಲ್ಲಿ.
ಮೇಡಮ್ ಯಾವ್ದು ನೋಡಿ ಅದು ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹಾಕಿ. ಯಾವ ವರ್ಷದ?
2023 my lord.
ಅದನ್ನ ಬುಧವಾರ ಹಾಕಿ ಮೇಡಮ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್. ಕಂಟೆಂಪ್ಟಾ? ಮೊನ್ನೆ ಯಾವ್ದೋ ಒಂದು ಬರ್ದಿದ್ದೀನಿ, ಟರ್ಮು ಆಗೋಯ್ತು. ರಿವರ್ಸ್ ನೋಟಿಸ್ಗ ಆಯ್ತು, ಈ ವಾರದಲ್ಲಿ ಮಾಡಿ. ಈ ವಾರ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರೋಬೇಕು. ಮುಗಿತಲ್ಲ ಮೇಡಮ್ ಎಲ್ಲ?
Serial number 79 in call out. Preliminary interim is considered. Didn't be called out, my lord. I was here present throughout. For relaxation of video conferencing, interim is there, my lord.
Anyway, there is a respondent ಯಾರೋ ತಗೊಂಡಿದ್ದಾರೆ.